All right, welcome everyone, both in person here at Cato and online, to our 24th annual Constitution Day conference here at the Cato Institute. Every year on Constitution Day, we celebrate the Constitution by releasing a new edition of the Cato Supreme Court Review, the first and fastest volume of legal scholarship on the Supreme Court's just completed term. And for the second year in a row, we've also released our illustrated Supreme Court Review, whose editor-in-chief is James Craven. My name is Tommy Berry, and I'm editor-in-chief of the Cato Supreme Court Review and director of the Robert A. Levy Center for Constitutional Studies here at Cato. As always, at our Constitution Day conference, we'll have 3 panels looking back to the big cases from the past term, 1 panel looking ahead to the big cases and potential big cases of the upcoming term, and a keynote address, which this year will be delivered by Stephen Richer, Senior Fellow in American Democracy at the Harvard Kennedy School. For those of you following online, you can join the conversation on social media by asking questions or leaving comments using the hashtag CatoSCOTUS. Here at Cato's Center for Constitutional Studies, we freely confess our biases. We view the Constitution from a Madisonian perspective as a document that protects individual rights against government overreach and that strictly separates the powers of the government so that they check and restrain one another. We also reject the tired dichotomy of judicial restraint versus judicial activism. We simply urge judges to engage with and follow the law, and the law includes, most importantly, the Constitution. If that means invalidating a statute or a regulation, it's the judiciary's duty to do so, without putting a deferential thumb on the scale in favor of the elected branches. But at the same time, judges should not be outcome-oriented. Some decisions may lead to a bad policy outcome, but that's not an argument that the decision was legally wrong. Indeed, we think any rigorous legal philosophy must sometimes lead to policy outcomes that a judge doesn't prefer, or else it's not really a legal philosophy at all. But we don't want the Cato Supreme Court Review to just be an echo chamber. Not every author you'll hear from today would necessarily self-describe as an originalist. Certainly not all would self-describe as a libertarian, and that's as it should be. If we wanted the review to just say exactly what we at Cato believe, we could just reprint the amicus briefs and the op-eds that we've written throughout the year. But that's not what it's about. Instead, we invite a stellar lineup of authors and give them the freedom and trust to write what they want on this year's biggest cases. And as usual, they did not disappoint. And most of the panelists you'll see today will be authors of the articles you can read in the Cato Supreme Court Review. Now, both this edition of the Cato Supreme Court Review that you hold in your hands and this conference took an enormous amount of work from many, many people. I want to first and foremost thank all of our authors, most of whom had literally just 1 month start to finish to write a law review article, which is basically unheard of. Thank you also to my colleagues here at Cato, Clark Neely, Walter Olson, Brent Skorup, Dan Greenberg, Matthew Cavadon, and Mike Fox, who all provided great help in editing the review and in picking up the slack for me on my other work while I was buried in edits in the entire month of August. Thank you to our Cato legal associates, Christine Marsden, Harrison Prestwich, Samuel Rutzik, Caitlin Kennard, Alexander Zenos, and Vikram Valame for their work in editing and site checking. Very important to get the facts right and the blue booking on point. Thank you to Cato interns, Caleb Krebs, Karen Gupta, Quentin Crawford, and Ben Woods for research assistance that really streamlined the site checking process. And a huge thanks, as always, to Laura Bondank-Harmon, our permanent legal associate who juggled 1,000 moving parts to keep the entire process on track. We also relied on wonderful editing from the many copy editing professionals at Pubs Pros, and the physical books that you hold in your hands, believe it or not, were all typeset and printed within just the last week by the amazing printing professionals at R.R. Donnelly. Thank you to Eleanor O'Connor in Cato's publishing department, Brandy Dunn in our marketing department, and May McLeod who put together the cover. This conference also came together through the tireless efforts of many Cato staff: Ryan Moore, Kiana Graham, Moy St. Ong, David Tassi, Jonathan Fields, Darren Walker, Elcid de Monteverde, Roshni Asher, John Myers, Linda Osu, Cecil Sherman, Savannah Beatley, Sam McKenney, Jose Medina, and several folks who went out and passed around constitutions yesterday at various metro stops to help spread the word about Constitution Day. Alex Frank, Kim Coleman, Ari Rao, Emily Salomon, some of the legal associates I already mentioned, and Kevin McKenney helped organize that as well. So what can be said just briefly to set up about the term we're going to be discussing, this past term at the Supreme Court? Obviously, it was hard to follow the term prior to that in terms of both blockbusters and wins for liberty. The term prior to this last one obviously had the Loper-Bright decision, overturning 40 years of Chevron deference, putting administrative law cases back on an equal footing for the first time in 40 years. It had the Jarkissi case, which found a Seventh Amendment right when the SEC tries to bring enforcement challenges against you. We had the net choice cases that found a First Amendment right to social media companies to decide what they allow on their websites and what they don't. Those were huge blockbuster cases and big wins for liberty, and it would have been hard for the following term, the sequel, to measure up. And if anything, I think if you had to give a title to the sequel to that term, it would have to be The Government Strikes Back, because if anything, we had several decisions that were disappointing from the perspective of those who sue the government for a living, or those who think that the courts are all too often too deferential to the government. Many of these cases you'll hear about in the upcoming panels. We had several wins for the federal government or state governments defending laws, probably the most high profile being the TikTok case, where 9-0 the Supreme Court deferred to the government's claims of a national security interest in shutting down TikTok. That was apparently so urgent that they needed to decide it within a week, but not urgent enough that it can still be delayed for going on 9 or 10 months now and indefinitely in the future. We similarly had some administrative challenges and constitutional challenges that were unsuccessful. Cases like FCC versus Consumers Research, where the non-delegation doctrine continued its 90-year losing streak at the Supreme Court, of the Supreme Court declining to invalidate a federal statute on the grounds that it gave too much policy-making power to the executive branch. We had a loss and an appointments clause challenge, somewhat surprising given that the Arthrex case just 3 terms ago was a win in an appointments clause challenge. Several of the justices who ruled against the government 3 years ago ruled for the government this time, holding that there was no problem with a policy-making board of making important decisions about coverage under the Affordable Care Act, despite not having been appointed by the president or confirmed by the Senate. But it wasn't all bad news from the point of view of those who sue the government. We had several mostly procedural but still important cases where challengers won, at least at a preliminary posture. Cases about standing, for example. When can courts use common sense to hold that someone has been injured? Cases about criminal justice. What factors should courts look at when someone brings a claim of police brutality and that type of thing? What factors should courts look at when considering whether the Federal Tort Claims Act provides immunity to a particular challenge? You'll hear much more about those cases coming up, including our first panel right after this on administrative law. But before we dive into it, a few logistical notes. Lunch will be served in the conference rooms that are 1 level up at noon, directly after this upcoming panel. If you just follow the person in front of you, you're unlikely to get lost. There are single stall restrooms here on this floor, but there are larger bathrooms, both 1 level up and 1 level down. So I recommend you try those first, especially if there's a traffic jam here on this floor. As you get tasty snacks and drinks throughout the day, please be aware food and drink are not allowed here in the auditorium. It was recently renovated. We want to keep it looking nice for at least a couple more years. And because we live stream our panels on a 2-minute delay, be aware that every panel will actually start 2 minutes early. So the first panel will be starting at 10:43, not 10:45. I'll now invite up our first panelist of the day to discuss the administrative law cases of the term, moderated by our own Brent Scorup. Brent?
All right, thank you, Tommy, and I want to thank everyone for giving up part of your day to join us today and celebrate the Constitution, a little more about the Constitution and the Supreme Court. And I want a special thanks to our panelists who each contributed very thoughtful scholarship on constitutional law issues on very tight deadlines, as Tommy mentioned. So this panel is about administrative law. And if you're an administrative lawyer, or if you care about the regulatory state, or the rights of people when they're before a regulatory agency, it's been a very exciting 5 years or so. And this term was no different. We have 3 great experts to talk about some of the administrative law cases and issues, and I'll introduce each, and then each panelist will discuss their article and the Supreme Court's decision. First, we have Larissa Whittingham. She's at the Retail Litigation Center and Hush Blackwell LLP. She has a BS in criminology from Missouri State University and a JD from Boston College Law School. Damien Schiff is a senior attorney at the Pacific Legal Foundation. He has an undergraduate degree from Georgetown, a JD from the University of San Diego, where he graduated magna cum laude, and he clerked for Judge Victor Wolski of the U.S. Court of Federal Claims. Eli Nachmani is an associate at Covington and Burling. He has a BS in sports management from NYU and a JD, magna cum laude, from Harvard Law School. He clerked for Judge Stephen J. Menashe on the U.S. Court of Appeals for the Second Circuit and also taught sports management at NYU. But we're glad to have each of them here, and I'll turn it over to Larissa for the first case, FCC versus Consumers Research.
Yes, hello. It's so good to see everyone today. A big thank you to Tommy and Brent and everyone at the Cato Institute for putting this great event together. It's great to be here on Constitution Day, and I'm especially excited to kick off today talking about FCC versus Consumers Research because it is really discussing a core separation of powers principle that dates back as earlier than 1690, John Locke's Second Treatise of Government, and then was developed in American constitutional jurisprudence back in 1825. So in 1825, Chief Justice Marshall, in a case called Wayman v. Southard, blessed the principle that the legislative branch cannot give away powers that are strictly and exclusively legislative. And so Chief Justice Marshall blessed the non-delegation principle, but also said Congress can give instruction, guidance, give leeway to another body, typically the executive branch, but could be the judicial branch or another body, give leeway to fill up the details was the term he used, and this term that has showed up over and over again in cases before the Supreme Court, recognizing that in any given statute, Congress may not be able to envision all the administrative details of how the law is implemented, so some policy-making judgments can be made. So over and over in Supreme Court history, it has taken up cases considering the non-delegation principle. And over, it has affirmed the non-delegation doctrine is alive and well. It's not a textual principle. As some scholars have said, you won't see a non-delegation clause in the Constitution, but it arises from the separation of powers. And it's never wavered, and the Supreme Court, in a majority opinion or in any meaningful and influential concurrence or dissent, has never said either that it's completely unjusticiable, and said they have blessed the doctrine, but then gone on to uphold whatever statutory provision has been challenged. So in all but 2 cases in the court's history, it has upheld the challenge provision. The 2 that it struck down happened in the same year, 1935. And since then, the court has used what's called the intelligible principle standard to determine, okay, what things fall on the permissible versus impermissible side of the delegation. That comes from a 1935 case, J.W. Hampton, in which the court said that as long as Congress lays down an intelligible principle by which the recipient of the grant, the delegation, can determine what it's supposed to do to accomplish Congress's purpose, then it is constitutionally acceptable. So throughout the years, there's been a call from academics, from practitioners, and from judges and some justices to reinvigorate the non-delegation doctrine, to say, okay, we have said this over and over again, that this is a core constitutional principle, but are we really living out our beliefs here? And we need something stricter than the intelligible principle test that is passed over and over. So in 2019, there was a decision called Gundy versus United States that, again, upheld a statute despite a non-delegation challenge. But in that case, Justice Gorsuch authored a very influential and pointed dissent saying we need to reconsider the intelligible principle standard and show that we have meat to the bones of the non-delegation doctrine. So Justice Gorsuch was joined by Chief Justice Roberts and by Justice Thomas. In that same case, Justice Alito joined the rest of the court, but wrote separately in a concurrence that he would be willing to reconsider the intelligible principle test in a future case. So when the Fifth Circuit used the non-delegation doctrine to invalidate a statute last year and the Supreme Court took up the case, there was a lot of buzz. Is this the time that we're going to get a more meaningful non-delegation doctrine? And this case seemed especially well suited because it involves what we could all agree is a core congressional power: revenue raising, taxation. So we'll get to what happened with the court, but first let me describe what happened in the Fifth Circuit. So Consumers Research, a nonprofit, along with a few other petitioners, brought a two-pronged challenge to the funding mechanism for universal services. We could talk a long time about what universal services is, but to just give a broad overview, this is a guarantee that the FCC is supposed to ensure that rural schools, rural hospitals, and rural and low-income residents have access to essential telecommunications services. So things like home phones to reach 911, and there's, as you would expect, a lot of money going into ensuring that these populations have equal access. So Congress gave the FCC the ability to raise revenue to meet the universal services guarantee. And in that, they did not provide any actual rate, like a taxation rate or number or caps to the amount of money that the FCC could raise. Instead, it said, go FCC, go forth, raise as much money as you need to provide universal services. So the first challenge before the Fifth Circuit was, did Congress delegate to the FCC the core and exclusive power, legislative power of taxation and revenue raising in a way that violated the Constitution? The second part of the challenge had to do with how the FCC has determined how much to raise. And to clarify, the amount of money it's raising is coming from telecommunications carriers, but those carriers can pass the cost on to consumers. So for any of you that still have a home phone, you can look at your home phone bill and you might see a universal services line item where you are paying what the carriers had paid to ensure that this was met. So the FCC established an organization called Universal Services Administrative Company, USAC, that was heavily involved in determining what a quarterly calculation from each of these service providers was. So they looked at the projected expenses of universal services, they looked at the revenues of the contributing carriers, they developed a formula to determine quarter by quarter how much was being paid. So the second argument, that even if the first delegation, Congress to the FCC, was appropriate, then Congress to this private organization who was run, the directors were from telecommunications services providers and beneficiaries such as representatives of rural libraries, was that an unconstitutional private delegation? So a three-judge panel in the Fifth Circuit said, no, this is okay, applied the intelligible principle test, no problem. The en banc Fifth Circuit, so the full court, took up the question again and decided differently. They analyzed each of these two arguments, said these are both problematic, we have concerns, but we were not going to rule dispositively on either of these questions. Instead, they said the combination of these two things, the delegation to the FCC and then FCC's delegation to this private entity, was a constitutional violation based on the non-delegation doctrine as was articulated back in 1825 in Wayman v. Southard. So it gets to the Supreme Court. They accept cert. It's a lot of speculation. Is this going to be a time where we have a hardier doctrine? The very last day of last year's term, we get the decision, 6-3, and it's upholding the statute. So unexpectedly, Chief Justice Roberts left Justice Gorsuch out in the dissent land, even though he had joined him in 2019. And we had Justice Kavanaugh, who many had watched on this issue, also joining the opinion of the court, authored by Justice Kagan. And so there's two big takeaways I want to highlight and I discussed at length in the paper. And one is that the separation between the majority of the court in FCC versus Consumers Research and the dissent written by Justice Kavanaugh and joined by Justices Alito and Thomas really hangs a lot in statutory interpretation. They agree on more things than you would expect. They all echo the non-delegation theme that we've seen over and over, but instead they use statutory interpretation principles to distinguish different scopes of power that Congress granted to the FCC. And so Tommy mentioned Loper-Bright from last term. Everyone loved Loper-Bright in this opinion. So Justice Kagan quoted Loper-Bright to say, we can and should read the statute ourselves to recognize limits on the scope of authority. In Justice Gorsuch's view in the dissent, he said, well, we have a core taxing power, what could be more strictly and exclusively legislative, and if there's not any monetary, any quantitative limit, then that's delegation. Whereas the court said, even if there's not a quantitative limitation, what we have as we interpret ourselves because of Loper-Bright, the text of the statute, is a qualitative limitation. So the language in the statute said that the FCC can raise enough money to provide sufficient funds for universal services. And sufficient has a floor and a ceiling, Justice Kagan said for the court. And she said that if it was really true that the FCC could raise as much money as they wanted, then that would be constitutionally problematic. That phrase has already been cited less than 3 weeks ago by the Federal Circuit in a concurrence on one of the tariff challenges, where they said, here we have no qualitative or quantitative cap. So the full court, as an opinion written by Justice Kagan, said that would be constitutionally problematic. So we have some hope of the non-delegation doctrine still being used because of the various statutory interpretation ways. And then just quickly, the second point is that we see a different description of what's actually happening on either side of a permissible or non-permissible delegation. Justice Kavanaugh, in his concurrence, echoes Justice Scalia back from a 1986 dissent in a case called Mistretta, where he says there's really no permissible delegations. If the legislative branch is actually giving away any of its power, that's always a problem. But what's really happening in most of these cases is a reliance on the inherent power of a different branch. So of the executive branch, when you're dealing with executive agencies, or the judicial branch in a few cases, it's instructions and guidance on how to exercise their own power. Naturally, that means he is not a fan of what's called the private non-delegation doctrine, right? The question of can authority be given to a private entity because there's no inherent constitutional powers. Whereas Justice Jackson, in a very short concurrence, looked at it very differently and said, no, actually, a delegation to a private entity is probably no different than to any government agency, to an executive branch or the judicial branch. In a future case, we should take it up, which in that case, the court said, really, FCC had maintained its ability to control what the rate was, so there was no private delegation. So I'm sure we'll get into more of the details further on the panel, but I'll pass on to my fellow panelists.
Thank you for that. And just a brief note, we will have time for audience Q&A at the end after I've asked a few questions. So you can start formulating those in your mind, and for those online, you can enter questions on the registration webpage. There's a dialogue box, and those will pop up for me if for any watching online who have questions. Damien, I'll turn to you.
Thank you, Brent, and I join Larissa in thanking Tommy and Cato for the opportunity to present this morning on, for myself, something of a sleeper case for those who are not interested in environmental law, but I think one that nevertheless will have significance not just in environmental law, but outside of environmental law and administrative law generally. And it's called Seven County Infrastructure Coalition versus Eagle County, which I think is undoubtedly the most significant decision ever issued by the U.S. Supreme Court in interpreting the National Environmental Policy Act, and probably one of the most significant environmental law decisions ever. Now, NEPA was signed into law by President Nixon on January 1st, 1970, and it inaugurated a decade of pretty significant federal lawmaking in the environment, statutes such as the Clean Air Act, the Clean Water Act, and the Endangered Species Act. Yet NEPA is unique among all these laws in that it only imposes procedural obligations on federal agencies. So specifically, NEPA requires an agency to produce an environmental impact statement, which is supposed to explain the anticipated effects of any proposed major federal action that an agency will undertake, and at the same time to investigate sort of a reasonable array of alternatives to that proposed action. Now, despite this procedural limitation, NEPA, frankly, from the get-go, was used aggressively, principally by environmental groups, to stop significant federal infrastructure projects. And unfortunately, many of the lower courts for nearly half a century sort of played willing accomplice to this effort. The prime example of such is the D.C. Circuit's very first, or nearly very first, NEPA decision called Calvert Cliffs versus Atomic Energy Commission, which concerned an environmental challenge to the Commission's first NEPA regulations. In what really became a canonical opinion written by the liberal lion Judge Skelly Wright, the D.C. Circuit ruled in the environmentalists' favor and initiated a multi-decade phenomena of NIMBY-NEPA litigation. The court explained through Judge Skelly Wright that through NEPA, quote, the commitment of the government to control at long last the destructive engine of material progress had been taken. And he concluded with a peroration that it was, quote, the court's duty to see that important legislative purposes heralded in the halls of Congress are not lost or misdirected in the vast hallways of the federal bureaucracy. It's interesting, actually, Justice Scalia, when he was a law professor, published a law review article where he kind of made fun of that language, where he said, I actually think it's a good idea when things get lost in the hallways of the federal bureaucracy, to slow things down. But anyway, so as the lower courts began to bless this aggressive NEPA litigation, especially in the D.C. Circuit and the Ninth Circuits, the trouble became that virtually any NEPA error in these documents could lead to, and did lead to, a vacatur of the project's approval, which in turn meant that these agencies had to go all the way back to step zero after spending many years, a lot of resources, including help from the private parties who were supporting the projects, go all the way to step zero. And oftentimes that meant the end of the project, effectively, because there was no longer any desire or money to go forward with it. And ironically, this judicial activism, not engagement, Tani, but judicial activism was enabled, again, ironically, precisely because NEPA was understood to be a procedural statute. Now, typically, courts are very reluctant to second-guess an agency's substantive decision-making. But when it comes to procedures, they feel like, sure, we can enforce procedures. We're not making a judgment call. And so since NEPA ostensibly was pure procedure, lower courts really didn't feel any problem with being very aggressive in making sure that it was followed at the consequence even of projects being permanently stopped. So the seven-county case concerned a proposal to the Surface Transportation Board to build an 88-mile length of railroad track in the Uinta Basin, which is a remote area in northeastern Utah that has a significant petroleum potential. Now, after years of review, a 3,600-page environmental impact statement, the board finally granted approval. But this was challenged by Colorado County and a coalition of environmental groups. And not surprisingly, the D.C. Circuit ruled in favor of the challengers and overturned the project approval, the rationale being that the Surface Transportation Board had failed to analyze the effects of the upstream and downstream consequences of the 88-mile length of track. So the board looked at what the track would do, but the board didn't analyze what would happen with all of the petroleum or oil refining that would be incentivized downstream by the creation of this railroad track that would connect the Uinta Basin to the National Railroad Network. So in the Supreme Court, the dispute was on causation. The question is, to what extent can an agency ignore but for causes and effects of its action if they're distant in time and effect? And in the majority opinion issued by Justice Kavanaugh, the court definitively answered yes, an agency can ignore certain such effects. But what's interesting is how the court begins its analysis. It says quite firmly that, quote, a course correction is needed for instructing how the lower courts are to go forward in adjudicating NEPA cases. And interestingly, that course correction begins with, quote, deference. Now, that might seem kind of strange, as you've already heard a few times this morning, that deference, we think that's gone with Loper-Bright, but Loper-Bright just dealt with deference to legal interpretation, not factual determinations. In particular, the sort of technical or scientific determinations that are frequent in NEPA documents. Justice Kavanaugh said lower courts should be really deferring to those things, not second-guessing the agency. Secondly, Justice Kavanaugh said that the focus of the review is always on the rationality of the agency decision itself, not on whether every jot and tittle of the EIS has been properly formatted. Just because the EIS, the Environmental Impact Statement, is wrong doesn't mean that the project should be vacated. And that's a significant change. Third, the court said that, yeah, you don't need to analyze effects that are distant in time and place. So, for example, for the Uinta Basin, you build the railroad, maybe someday down the road that will have more refining going on in the Gulf states, that will lead to greenhouse gases. You don't need to analyze that. It's too far afield. And the same thing goes with respect to regulatory authority. The Surface Transportation Board can only say yay or nay to railroads. It has no authority to regulate any sort of mineral development, any sort of refining. So that was another reason the court gave as to why a more limited analysis was appropriate. So yeah, I think Seven County certainly promises to be a watershed decision for NEPA practice, but let me say very briefly in closing why I think it has more significance than just simply for NEPA litigators. For one, I think that it really shows how, as sort of a legal historical matter, NEPA has been effectively subsumed into the, quote, hard look review of State Farm. Now, State Farm is a famous 1983 decision from the Supreme Court concerning motor vehicle safety standards, but it's regularly cited throughout ad law as articulating the canonical definition of what it means when an agency acts arbitrarily and capriciously. And part of what that standard says is whether the agency has relied on factors that Congress didn't intend to consider, or whether it's failed to consider an important aspect of the problem or failed to explain itself rationally. That's basically a NEPA document, what the court is saying there. And I think, ironically enough, that 1970s era of aggressive NEPA litigation actually led to the Supreme Court more generally allowing judges to be more engaged in administrative law cases through this State Farm understanding of arbitrary and capriciousness. Secondly, I think relatedly, NEPA has colored administrative law green. I think it would be unthinkable to imagine a court saying today that a, quote, important aspect of the problem before an agency doesn't include the environment, unless the statute says, no, definitely don't take into account the environment. I think that's kind of the green common law of administrative law. Thirdly, I think the court shows itself very sympathetic to the, quote unquote, abundance agenda. Throughout Justice Kavanaugh's majority opinion, he says, look, one reason why this is crazy, what's going on in the lower courts, is it's thwarting the economy. People are losing jobs. Projects are not going forward. We should be able to build more. Now, he has legal analysis too, but I mean, the fact that he includes that as well, I think, shows that the court, in other cases too, may be open to that sort of economic critique of some of these crazy agency interpretations. And finally, I'll just conclude with this, that environmentalists do not have a friend on the current court. Even the liberal, so-called liberal justices on the court agreed, although they concurred separately, they agreed that the D.C. Circuit got it wrong. They agreed that lower courts had not been appropriately deferring to agency decision-making under NEPA. And so I think it just goes to show that really not since Justice Douglas in the 50s, 60s, and 70s has there been a, quote, environmentalist justice, and I think that's really showing itself in the court's decision-making, especially in the 7-county case.
Terrific, thank you. And finally, Ellie.
Excellent. Thank you so much. And Tommy and Cato Institute, thank you so much not only for hosting this event today, but also for inviting me to contribute an essay to the review. Anything that I say here is in my personal capacity, not as a lawyer of the firm. And I also want to take a brief moment sort of at the outset to acknowledge this is my first time speaking on an issue of law or policy or structure of our government since the assassination of Charlie Kirk. And so I just feel, especially on Constitution Day today, very fortunate to live in a country where we have that freedom of speech to be able to speak and disagree on these sorts of issues. It's extraordinarily important. So Diamond Alternative Energy LLC against EPA. It's an environmental law case. It's an administrative law case. Most importantly for the Supreme Court, it is an Article 3 standing case. And the case boils down to California's attempt to impose heavy-handed regulations on fuel economy standards for automobile manufacturers. This has been an issue going on for well over about 20 years now. The way that the fuel economy standard regulation works is that the EPA, through the Clean Air Act, has a preemptive effect over states generally on fuel economy regulation. However, the Clean Air Act recognized that prior to its enactment, California had its own sort of nascent attempts at regulating fuel economy standards, and so the Clean Air Act allows the EPA to grant a waiver under certain circumscribed circumstances to California to impose its own fuel economy standards. You might imagine that California sometimes wants to go a little bit further than the federal government does, and so California has applied for this sort of waiver, which the EPA has either granted or declined to grant, depending really on the political affiliation of the presidential administration in power. I mean, it's quite literally the George W. Bush administration declined to issue this waiver. The Obama administration issued the waiver. Trump 1 rescinds the waiver. And then the Biden administration reinstates the waiver. It's that reinstatement of the waiver as to fuel economy standards for certain model years ending around now that was at issue in this case. So the litigants in this case, you would imagine, would be the automobile manufacturers, right? Of course, the regulation of the fuel economy standards operates on the automobile manufacturers, telling them you must manufacture the cars in this particular kind of way to consume less fuel. You might be surprised, however, to learn that the litigants here, the plaintiffs who challenged this EPA waiver of the California regulations, were not the automobile manufacturers, the directly regulated parties, but rather they were both states and, as important here, fuel producers. So fuel producers' theory of this case is, well, as the fuel economy standards operate on the automobile manufacturers, it will have the consequence of making them create cars or manufacture cars that consume less of our fuel. And so even $1 less, and this is classic Article 3 standing doctrine, even $1 less of fuel that will be consumed is an injury. And so that's our theory. We're the fuel producers. We want to be able to come into court and say we're aggrieved by this agency action within the meaning of Article 3 of the Constitution. Federal court can hear the case. And despite the fact that we're not directly regulated, it will have this downstream impact on us. The DC Circuit disagrees. In fact, the DC Circuit says you have not demonstrated that if you win on your challenge, and the challenge was we want the EPA's waiver to be vacated by the court, we'll get back to that, we want the EPA's waiver to be vacated by the court, the DC Circuit was not convinced, based on the evidence that the fuel producers had adduced, that vacating the waiver would actually impact the manufacturing of the fleet of cars in such a way as to create maybe even $1 more of demand for fuel by the cars that the automobile manufacturers produce. The fuel producers take this up to the Supreme Court, and in a 7-2 opinion by Justice Kavanaugh, joined importantly by Justice Kagan, the Supreme Court reverses and determines that, in fact, the fuel producers had satisfied the elements of Article 3 standing, including this redressability inquiry. Justice Kavanaugh applies what he describes as common sense economic principles, perhaps the most important of which is, if the government is imposing some sort of regulation, we might assume that that regulation is going to have at least its intended effect or some sort of effect that's adjacent to that intended effect that will get us the at least $1 that gets you in the door for Article 3 standing purposes. Okay, so that's Diamond Alternative Energy v. EPA. It's actually a relatively straightforward Article 3 standing case. In a way, the court says some things that will make it perhaps easier to sue the government in the future, at least from an Article 3 standing perspective. Again, perhaps the most pertinent of which is if the government is imposing a regulation, we'll assume that the regulation has some sort of meaning and is going to do something. If the government then, the Supreme Court says this, continues to defend that regulation in court, the court can say, well, the fact that they're defending the regulation in court is perhaps evidence of that regulation having some impact. So fine, so that's Diamond Alternative Energy. Lurking beneath the surface of this case is something that I think the Supreme Court is trying to signal to us, or at the absolute least Justice Kavanaugh is trying to signal to us, about an ongoing debate in administrative law that is of the utmost importance. That is the meaning of Section 706 of the Administrative Procedure Act. Section 706 of the Administrative Procedure Act is the heartland of regulatory litigation. It provides that a reviewing court shall hold unlawful and set aside a regulation or an agency action that is determined to be unlawful for one of a variety of reasons. Among others, it could be arbitrary and capricious. It could be one or another reason that the agency action is unlawful. There's a debate on the court right now as to what the phrase set aside means. If you take the view of folks like Justice Gorsuch, joined by Justice Thomas and Justice Barrett in a separate opinion that he wrote in a case called United States against Texas, set aside merely means that when a party comes into court and a regulation is at issue or an agency action is at issue, the court in that individual proceeding is to set aside the regulation when making a determination as to what that party's rights are or how a litigation should come out. Justice Kavanaugh, by contrast, and he lays out this view in concurrence in a case called Corner Post, Justice Kavanaugh says, no, what set aside means is that you vacate the rule, i.e. you wipe the regulation off the books. We don't talk about statutes like this. Some do, but we don't talk about statutes like this. We don't say that you erase a statute from the law books. Rather, you say You hold a statute unconstitutional, or you declare the statute has no constitutional validity in a particular case. But Justice Kavanaugh says, as to regulations, as to agency actions, set aside means vacate and you wipe it off the books. Consider the implications. And I like that we can do this at Cato. We can consider the implications, because the meaning of that statutory text, there are serious scholars on both sides of the debate. Mila Sahoni brings some evidence to bear for Justice Kavanaugh's position on vacator. John Harrison brings some evidence to bear that actually it just means, as to individual cases, don't regard the regulation. But there's a practical consequence here, and I think it shines through in Diamond Alternative Energy v. EPA. If set aside under Section 706 of the APA actually means what Justice Gorsuch says it means, what John Harrison says it means, this idea that it merely in individual cases requires the setting aside of the regulation, and so it has no legal effect in particular, we might call them enforcement actions, Diamond Alternative Energy cannot go forward. Because here it's not the automobile manufacturers who are suing. It's not that the automobile manufacturers are waiting for an impending enforcement action from the state of California and saying, well, hold on, let me get into court as quickly as I can to ensure that the regulation, as applied to me, has no legal effect. Rather, it is fuel producers who say that enforcement action or the threat of that enforcement action is going to have a downstream consequence on my bottom line, on my ability to sell fuel, on my market for fuel. But if it means set aside, then the fuel producers can't get any practical relief. And so my essay is titled Vacater as Complete Relief. Because as to the fuel producers in this case, and as to a host of unregulated third-party plaintiffs, who the APA has long, it seems, granted a right to sue when aggrieved by agency action, the whole idea that their injury is redressable depends on the possibility that the agency action can be vacated and not to have effect on third parties who will never be in a sort of enforcement posture. And so I flag this issue because I think it's coming back to the Supreme Court. I think the court will resolve it at some point. It's adjacent to this issue of nationwide injunctions, but it's quite important. And so I think the focus on remedies lurks underneath the surface of Diamond Alternative Energy v. EPA, but at least from a practical consequence perspective, may have no impact on what the statute means, but at least from a practical consequences perspective, if in fact Section 706 means set aside as to individual parties, lawsuits like the fuel producers lawsuit don't make sense.
Thank you very much, Ellie. And now we'll turn to questions. So again, you can start formulating questions in your own mind, and we'll pass around mics in a few minutes. But first, I have a few questions for the panel. Well, Ellie, I'll go to you first. So a few weeks ago in Trump v. Casa, the Supreme Court said district courts can no longer issue universal national injunctions. Could you talk about any tension with this issue of set aside or vacater when it comes to administrative law? Because that case is pretty plain that district courts cannot issue these nationwide injunctions, and it's got to apply to the parties directly before them.
Yeah, so formally, no tension. The Supreme Court, in fact, in a footnote, expressly reserves this question whether set aside under the Administrative Procedure Act, this is in Trump v. Casa, expressly reserves the question whether set aside under the Administrative Procedure Act is amenable to the Justice Kavanaugh position or amenable to the Justice Gorsuch position. What the Supreme Court does in Trump v. Casa is it interprets the scope of a federal court's remedial mandate not to allow relief to extend beyond the plaintiff in a given case. You can't issue relief as to everybody in the country, everybody in the world, unless you have the plaintiffs before you that would allow you to issue that sort of relief, because the relief must be tailored to the plaintiff before you. You can imagine a case in which vacater, or what some might call a universal injunction as against the enforcement of a particular regulation, is complete relief for the party that's before the court. And so the fuel producers are perhaps the best example of this, that they need that vacatur to have complete relief as to them. And the Supreme Court in Trump v. Casa recognizes that in a case in which, and at issue there was the birthright citizenship executive order, but in a case in which the only way in which to provide the plaintiff before the court with complete relief is to enjoin the defendant party, in that case the government, in this case the government, from not doing a particular thing. Okay, they're not enforcing the birthright citizenship executive order. Here, well, actually what the court would do is invalidate the waiver and thus not allow California's regulations to come into effect because they would be automatically preempted in the absence of that waiver. But if that's the only way in which to provide complete relief, my understanding, my read of Trump v. Casa, which to be sure was in a preliminary emergency posture, and so the court is doing likelihood of success in the merits and balancing other factors, but I think lower courts would be well advised to follow the legal ruling there just as a matter of practice. But the universal injunctions limitation in Trump v. Casa, I don't take to be inconsistent with the idea that APA Section 706, at the absolute least, authorizes vacatur of agency action.
Thank you. Damien, you hinted that the justices seem to be kind of hidden abundance advocates. They care very much, it seems, about economic growth and large infrastructure projects. Could you talk about the implications of that view and how that might play out in other cases outside the environmental context?
Yeah, I think, and my colleague Charles Yates and I talk about this a little bit in our paper. I mean, you could argue that maybe the court is developing a sort of a new statutory canon of construction, kind of like an avoidance canon, where the court, when presented with statutory language that could go one way or the other, in fact, Justice Kavanaugh says this expressly in his majority opinion in Seven County. He says, courts should strive to interpret the statutes that affect, quote, the American economy in a way that promotes clarity and consistency and predictability. So that is kind of a piece with what the court has done, for example, in the cases that are called the major questions doctrine cases, where the court is particularly sensitive when agencies embark upon rulemaking that promise to have significant social or economic effects. I think this is kind of a piece with that. And I think actually there's even a little bit of crossover with the Diamond Energy case that Ellie was just talking about, where Ellie mentioned what drives the standing analysis is Justice Kavanaugh's common sense appreciation of economics. And he also says there that it's kind of ridiculous for California to try and deprive the regulated industries from trying to sue to relieve themselves of these burdens. So I think there is, both inside and outside environmental law, a signal that the court is going to be particularly sensitive in statutory interpretation cases when it has room to interpret, so as not to unduly burden economic activity, which I think is a very good thing.
And Larissa, when it comes to non-delegation, which as you noted has been essentially dormant for decades, but how did the justices break down in their concurrences and in other opinions? Can you categorize how they view non-delegation doctrine and the chance of a revival?
Absolutely. So we did get a lot of hints about different perspectives on non-delegation through the 4 different opinions in FCC versus Consumers Research. So the majority of the court was, pretty staid in terms of, okay, this is the same old principle. We use intelligible principle tests to find out whether or not the delegation is permissible, and it seemed pretty normal. Like Gundy, we read, like many other cases throughout the years. But then you have some marked difference when you look at the concurrence by Justice Kavanaugh and the concurrence by Justice Jackson. So both a part of the majority of the court aligning in this case, but seeing very quickly that in future cases they might go polar opposites. So I alluded to this in my opening remarks, but Justice Kavanaugh really views most of the challenge delegations as just instructions to another branch. Whereas Justice Jackson, in a very short concurrence, flagged that that is not at all how she looks at it. So she signaled that there should not be anything special about a private non-delegation doctrine, right? That any assignment of responsibilities or duties by Congress to a private entity should be looked at the same lens, presumably the intelligible principle standard. And that runs completely at odds with Justice Gorsuch's philosophy that there needs to be some inherent constitutional powers of the recipient of a delegation. Also, in Justice Kavanaugh's concurrence, he marks the difference in applying the intelligible principle standard to an independent agency. He says, well, the FCC does not have statutory for-cause protections, so it, in his view, is not an independent agency, so we don't have to address that issue now, but in a future case, we should consider where there may be a different standard beyond the intelligible principle test for independent agencies. He also flags foreign policy and national security in a statement respecting denial of cert in a different case. He had flagged, do we need some kind of different non-delegation major questions doctrine for foreign policy or national security. He states it a little differently in his concurrence, but still kind of raises the red flag of my analysis might be different in a future case, as does Justice Gorsuch. I mentioned that everyone seemed to love Loper-Bright. In this case, Justice Kagan cited it in the opinion for the court. Justice Kavanaugh cited it when he was talking about the policy results of non-delegation doctrine in our history, right? He seemed to acknowledge, hey, yes, the intelligible principle test has resulted in upholding a statute over and over again, but we have other opportunities to save the detrimental policy consequences. And there he cited Loper-Bright. Courts should be applying their statutory interpretation muscles to do exactly what the court did in FCC versus Consumer Resources, which is narrow the scope of authority granted. Justice Gorsuch in his dissent accuses the majority of rewriting the statute to achieve this. And whether you agree with his characterization or not, it's an important principle because whether they rewrote it, or just in good faith applied statutory interpretation, they did limit the scope of power and said, no, this characterization that the petitioners are framing and that Justice Gorsuch advocates that the FCC could raise as much money as it wants, this is not the case. And then Justice Kavanaugh also talks about the major questions doctrine, another canon of statutory interpretation, to say, well, we need to apply that muscle as opposed to non-delegation. Justice Gorsuch pretty rightly calls him out on that and said, well, that only works if you've got Congress that wants to hold on to its power. But if you have a Congress that wants to clearly and unequivocally delegate power to another branch, to the executive, major questions doctrine isn't going to save us. That's why we have non-delegation, essentially. And if there's any power that is strictly and exclusively legislative, which are the words of Wayman v. Southard, then isn't it the taxing power? One thing that I think was very relevant in the minds of the justices, going to Ellie's point on downstream consequences, is what would it mean if we agreed with the petitioners and agreed with Justice Gorsuch that every revenue-raising statute has to have a quantitative threshold? So the government did a very effective thing in one of their brief, which is they listed 9 different statutes and agencies that would come into question because it gives revenue-raising authority to the executive branch without a quantitative limitation. So I think a great example of this is FDIC insurance, right? So the government requires banks to pay into it, the banks get a benefit, and there's a question that was talked about a lot at oral argument, and that was discussed in both the majority opinion and Justice Gorsuch's dissent of, well, would that be a tax or a fee? If it's a tax, then in the petitioner's view, under non-delegation, FDIC is out, right? We got to rewrite the statute, the funding mechanism for the insurance. Whereas in Justice Gorsuch's view, well, that's really a fee, and the fees don't have the same constitutional constraints. So, you look at Chief Justice Roberts, who was in a different position in FCC versus Consumers Research than in Gundy, the last significant non-delegation doctrine. He didn't write separately, but I think one of the main reasons is the downstream consequences. He didn't want all of these 9 statutes that the government lists to immediately come back up to the court. And by joining the statutory interpretation framework of the majority, even though Justice Gorsuch calls it inauthentic, by joining that, he can avoid the result of all these cases, but still leave in play an ability in a future case to distinguish just as a matter of statutory interpretation another case. So I think it gives us some clues as to what they're looking at and then how it might play out in future cases.
All right, thank you. And Larissa, I'll go to you again. Yeah, I should say Cato filed in this case, and I have a special interest in this topic. But as I noted at the beginning, this court seems to enjoy, administrative law cases. There was hope, as you noted, with Gundy, that the justices or a majority had an interest in bringing some teeth to the intelligible principle doctrine. Yet, in this case, which in a lot of ways seemed like a very good case to do that, there just wasn't a majority for that. In this case, where you have taxing power, you also have this bizarre system where the FCC is essentially subdelegated all practical operational authority to a private corporation, and yet they still couldn't bring themselves, or a majority couldn't bring themselves to strike it down. So do you see, is there an appetite this term for the court to do non-delegation again?
No, I do not think there's an appetite. I think that this is, they don't use the term constitutional avoidance in any of the opinions, but I think that's really a big part of it, is they want to be able to retain the ability of the court to speak to this, and to reiterate over and over again, yes, it's a core principle that Congress cannot delegate purely and exclusively legislative powers, but they don't want to actually put the money where their mouth is to do it. And so, I think you're right that this was a prime case, and if they were willing to do it, this would have been the case. There's the downstream consequences that I think gave pause, but they really don't want to put their neck out there, and I think they're afraid of what would happen if they did. You mentioned the purely giving away authority to USAC. This is the administrative company who was involved in determining what the actual contribution rate was every quarter. If you read the Fifth Circuit en banc opinion and you read Justice Kagan for the court, her majority opinion at the Supreme Court, you are dealing with two very different factual descriptions. And in the opinion of the court by Justice Kagan, it's, they're doing math, they're adding up numbers, but then the FCC can come in at any time. And this audience may be interested in her citation of an amicus brief. She says, hey, we have this amicus brief from former FCC officials that said, really there's some behind the scenes back and forth before anything's published, so there's probably more going on. On the other side, both the petitioners and the en banc Fifth Circuit says that's absolutely not what's going on here. The FCC is rubber stamping, they put in the motions for USAC to give them 2 weeks to consider, but that's never happened. They've never asked for more information. They've never changed the contribution amount. And so I think to the extent we see non-delegation really engaged with, it's going to be in the private non-delegation doctrine. I should flag, we will see the court take up potentially the issue of non-delegation in the tariff case, which they'll talk about later. I suspect they'll try to avoid actually applying it in the same way they did here, which is by using statutory interpretation principles. So it will get to the court, but I think there's a hesitance on relying on it or revitalizing it.
Damien, you noted the court in Seven County emphasized that courts should be deferential to agencies when they're making these environmental assessments. Can you talk about any tensions, if any, with Loper-Bright, where the court said, we don't defer to agencies any longer when it comes to statutory interpretation?
Yeah, I would certainly say that there's a tension in the sense that judges can be competent to assess whether an agency has followed the basic standards of rationality in either interpreting statutes or in assessing evidence. But formally, I guess there's not a conflict in the sense that Chief Justice Roberts' opinion in Loper-Bright specifically exempts from the court's holding those decisions that are based upon fact-finding, especially fact-finding that involves some measure of expert, technical, or scientific expertise. And in fact, actually, in that part of the opinion, the Chief Justice footnotes as examples several environmental statutes, whether it's EPA under the Clean Air Act or the Clean Water Act. And actually, in fact, Justice Kagan, in her dissent in that case, in noting that, well, the majority doesn't go as far as it could, cites an Endangered Species Act provision as an example, again, as to where agencies will still receive deference from a reviewing court. So in that sense, there's no formal tension, but I think there's definitely an ideological tension because what you will see, and in fact, we at PLF have already seen this in litigation since Loper Bright with the Department of Justice, both under the Biden administration as well as under the Trump administration, reformulating their arguments. What they used to say, well, this is a question of statutory interpretation, you know. Does the Endangered Species Act protect this type of subspecies or population? And therefore, you should refer to us under Chevron. Lo and behold, now they're saying this is a difficult question of scientific and technical expertise as to whether this population qualifies as a subspecies, and we should be deferred to because it's a factual determination. So it remains to be seen the extent to which this becomes a big end run around Loper Bright, but it's definitely a cause of concern. Now, if anywhere where it's appropriate, I think perhaps it would be under NEPA. But there is, of course, the concern that it won't be limited to that. And as I say, the federal government as litigator is already endeavoring to use this creatively in the lower courts.
Thank you. And a final question for me, for Ellie, and then we'll turn it over for audience questions. And you can raise your hand, and I believe a mic will find you. Let's see, where's my question for Ellie? So can you talk about the history of third-party plaintiffs bringing APA suits? Is there a litigation history over this? And to what extent does the APA contemplate that third parties who are not the object of a regulation can bring lawsuits under the APA?
Yeah, there's been some scholarly battle over this history. And the reason why the history is relevant is this idea of, okay, well, what exactly is the remedy, right? So there are examples. There's a Seventh Circuit case from, I think, 1941 involving, I want to say it's corn syrup manufacturers, and the idea is there's some regulation as to what can be described as, I'm going to get the facts wrong, but it's something as to what you can describe as sweet milk by the Secretary of Agriculture. And if you can't have corn syrup as one of those inputs for your sweet milk, then the corn syrup manufacturers say, hey, look, if we can't sell to the sweet milk producers, we're going to lose some demand. So there is some history of this. Of course, 1941 pre-APA, so maybe not exactly an APA litigation. What I would say is the more important sort of landmark shift occurs in this case, Abbott Laboratories, where the Supreme Court essentially blesses this idea of pre-enforcement review for agency actions. And of course, there's some dispute over that, whether Abbott Labs is exactly the touchstone. But I think that comes back to the broader dispute here is, you can envision a world in which it makes sense for set aside only to mean the regulation has no effect as to the party in interest in an enforcement action if the only time that this sort of thing would come up is in an enforcement action. And so the government, they come, they enforce, and on the other side, somebody says, hold on, you set aside this regulation as to me, it's unlawful for one or another reason. And the court says, okay, well, that's right, that's the meaning of set aside, and so the regulation does not apply as to you. Everybody goes home happy except the government, which we like. However, if it's the case that you can sue to get the agency action invalidated, wiped off the books, that not only impacts the first order consequences of regulation, but also impacts the second and third order consequences of regulation. Justice Kavanaugh has some fascinating examples. You could tell he was thinking about baseball when he wrote the opinion. There's one example in there of the government bans aluminum bats in Little League. It's not just sort of the little leaguers or the parents or the league itself that's regulated. It's the producers of the aluminum bats. It's what he calls the objects of regulation. And so, Justice Gorsuch and John Harrison, they have some pretty good evidence around the time of the APA's enactment, where we might say this was a sort of back burner remedy. Although Justice Kavanaugh, citing Mila Sohoni, then has examples dating back to the early 1910s of the vacatur of rules, or Mila Sahoni would like nationwide injunctions too, fine. But in this sort of historical debate, I think it's also important to think about, okay, the APA is a statute that has been applied over time. That meaning we might say has liquidated. I'm not taking a position on the liquidation question, but there might be an argument that this sort of lawsuit has been understood, at least by the DC Circuit, for a long time to authorize vacatur. But it's a fascinating back and forth. There's good history on both sides, but really I think this comes down to this pre-enforcement challenges question, because if I can get a challenge of the agency action before there's an extant enforcement proceeding, then vacatur comes into play and can be really interesting from a remedial perspective.
Okay, great. And forgive me, I have another question for Ellie before we turn to the audience that came to me. So in the decision, the majority said, I think they say common sense like a dozen times. The common sense, predictable effects on a third party generally will provide standing to sue. Justice Jackson, her dissent, makes the point, and I'm somewhat sympathetic to, common sense is often in the eye of the beholder, and she points to the court's decision in the previous term in Murphy v. Missouri, where the court denied standing to social media users who pointed out government agencies and the White House were putting pressure on social media companies to pull down COVID speech and the like. But the court didn't grant standing in that case. So that, to some people, including myself, it seems common sense that when the White House tells a social media company to remove speech, that would have a predictable effect. So are you worried about this courts developing this common sense framework for standing purposes?
I don't think so. I mean, let me say this, sort of first principles. Murphy and Diamond Alternative Energy were both decided by the Supreme Court, and thus they are formally consistent. Are they actually consistent? Okay. What I think we're seeing is, and Richard Ray has a good paper on this, is there's sort of a retrenchment in standing doctrine where the conservatives have become, or you might call them conservative coded justices, have become more interested in recognizing Article III standing in certain cases. It's not every case, right? You have not only Murphy, but also there's the Alliance for Hippocratic Medicine case. Josh Blackman has a post on the Volokh conspiracy that comes out like right after Diamond Alternative Energy, where he even sort of distinguishes and says, well, there's a difference between what you might call socially conservative, ideologically coded litigation and business litigation, which we might put this one more into the category of. And I don't know that Professor Blackman takes the position that the Supreme Court is more sympathetic to business interests, and like that's a more precise way of putting it, but I think his post at least lays out some cases in a way that would suggest that might be his position. But no, I think when applying common sense economic inferences, there may be a bit of a common law process over time where the Supreme Court explains what its common sense is and how lower courts should think about that. But the principle to be derived here, I think, is that when there actually is an underlying regulatory framework, like a regulatory framework is in place and can be enforced, when the government actually goes ahead and defends the enforcement of that regulatory framework or the upholding of that regulatory framework, we can assume that the regulatory framework will have some sort of impact, either on the directly regulated parties or what Justice Kavanaugh calls, as I described earlier, the objects of regulation. That can be the directly enforced parties, or it can be parties for which there's a predictable downstream consequence, like here, the fuel producers. As to Murthy, I think what the Supreme Court is doing here is it's developing over time the principles of standing. And as to whether they're exactly consistent, I think I would begin by, well, what exactly was the regulatory framework at issue? What was the regulatory framework stated by the government to do? And then did the government come into court and say, here's an existing regulatory framework that we're enforcing, but actually it's not doing the thing that we're saying it's doing or the thing that we're hoping it's doing. That might be a little distinct from what was going on in the social media cases.
Thank you. Well, now turn it over to audience. Does someone have a mic or? Yes, sir. I saw your hand first. Yeah, back there. Thank you. And please state your name and affiliation. And
J.P. Hogan, been writing about politics for decades. You bring me back to the years 2006 to 2008 with the, because somehow we went from $1 gas to $4 gas. I knew the Democrats wanted the $4 gas to force behavior change, and they wanted that as the climate change policy since the early 90s. So when you have this overreaching, the housing and banking collapse sort of got triggered by the $4 gas, which was the climate change agenda, but they were using it's all Bush's fault. There's a lot to unpack there, whereas it seems collusion, it seemed like it needed foreign collusion to affect elections, and yet it was done in the name of climate. If you want to discuss how a lot of those points seem to be a lot of areas of law that I think, still have to unpack and face, as far as whether it was foreign collusion, whether it was they had the right to force behavior change, because that banking housing collapse, the Democrats wouldn't do stimulus checks because they wanted to force a behavior change to get people off the gas cars. So there's a lot of dynamic in there that I think needs placement in where we're seeing the laws forward for environment, for delegation, overreach.
okay, thank you, Damien. I think that's for you. Do you have a comment?
Well, I would just, what started off all of the greenhouse gas regulation at the federal level was the Supreme Court's decision in Massachusetts v. EPA in 2005 or 2006, where the court 5-4 ruled that the states had standing to sue because they sort of stood to lose coastline or had other impacts from the consequences of greenhouse gas emissions. And even though you couldn't say that EPA's regulation could effectively stop greenhouse gas effects, nevertheless, it would be a sort of one step in the process of regulating. And the court said that was enough, at least on behalf of states. And in light of what Ellie was just talking about with respect to Diamond Energy, I wonder whether the court today would be as generous to the efforts of states to, as you're suggesting, forcing behavior through these petitions for rulemaking to the EPA. I suspect that that's probably one thing that might change. And also, too, this idea of deference to agency decision-making. If you'll recall in the Mass v. EPA case, EPA had said, this is a tough policy decision. We're not really quite prepared to issue a determination as to whether it's appropriate for the Clean Air Act that was enacted before global warming became an issue to be used as the vehicle for the federal government to respond to climate change. I think if that case were before Justice Kavanaugh today under, say, the Eagle County or 7-county framework, they probably would have said, yeah, we should defer to that and not second-guess the sort of political judgment that goes into that determination. So I think, yeah, definitely things have changed. Now, whether that particular case will be overturned, as some of you may know, the Trump administration is currently trying to undo by regulation the endangerment findings that gave rise to EPA's regulation of greenhouse gases. So that, I'm sure, will be litigated and perhaps will get to the Supreme Court over the next couple of years.
I'll go to a question from online. I'll go to Larissa first, but I think this is for the panel. Each of these cases involves statutory interpretation, and the court seems to envision an ideal Congress that carefully and competently drafts various statutes with intent. Is there a mismatch between the court's mental model of Congress and the real-world Congress that has the real-world problems of drafting and consensus?
Yes, there is definitely a mismatch. And this reminds me of a footnote I didn't bring up earlier in the opinion of the court in FCC versus Consumers Research, and most of us know the good stuff's always in the footnotes. And in this case, the court divided up the sections of the statute dealing with universal services funding. And even though the parties had never briefed it this way, the Fifth Circuit didn't break it down this way, but the court said, we're only looking at the overarching Section A statute for universal services. There's a separate one for advanced, and I think it's specialized, I don't have the correct word, but there's two other provisions that they specifically said in the footnote, hey, we are not making a ruling on the constitutionality or any non-delegation issues. as to those provisions. The fact that they spelled that out is super noteworthy, which Justice Gorsuch calls out very blatantly in his dissent, saying, hey, even this court can't give rise to these particular provisions because there's no saving grace there. And it goes right to the statutory interpretation, right? Is presumably the reason it was pulled out is that the court couldn't find a qualitative limitation for those provisions. It found one in the first one, but not these two others. So those will likely come back up to the court. That's currently being litigated, these two other provisions, with Justice Gorsuch encouraged for further litigation in the dissent. And so we might have a different outcome. And the more we have those kind of outcomes, the more Congress is going to have to decide, do we want to fulfill our expectation and constitutional obligations and write clear and precise statutes, or do we risk them going back up, and whether it's statutory interpretation or non-delegation or fill in your canon of interpretation or constitutional principle, have to go back to the drawing board.
I'd like to disagree, if I could. I think the court's mental model of Congress is exactly what it should be. It takes Congress seriously, it takes Congress literally, and even to the extent that there is ambiguity in the drafting, it understands that ambiguity against backdrop constitutional and statutory interpretation principles, where maybe there are the development of new canons of interpretation or the recognition of old canons of interpretation. But I think what's quite important, and what may be lost in light of some of the criticism that Congress has gotten, especially in the context of the non-delegation doctrine of ceding power to the executive branch, is that Congress should be understood to be doing this with intentionality. I think Congress is not drafting the statutes in such a way, as the questioner might describe, imprecisely or not fully understanding what it's doing. I think Congress knows exactly what it's doing. And to the extent that there is a constitutional principle to which Congress must be held, whether it's non-delegation or something else, or a statutory interpretation rule against which we will read a statute to cure the delegation problem. This is Cass Sunstein's idea from 30 years ago in his non-delegation canons article. I think that that's the judiciary doing exactly what it's supposed to be doing, and it's consistent with what I describe as an august history of a relationship between Congress and the Supreme Court in particular. Some debate about whether Congress has this relationship with the lower courts, but the Congress and the Supreme Court, at least in particular, as to the Supreme Court interpreting a statute, and if the Supreme Court either gets it wrong or interprets the statute in such a way that Congress did not want the statute to mean, Congress can amend the statute.
All right, thank you. Yes, sir. I saw your hand.
Hi, John Vecchione of NCLA. Thank you for saying that, Brent, about Murphy, because I thought the same darn thing. The government should be held to what it intends to do, but that's where we were. My question's for Ellie and the APA vacatur. It strikes me that none of the class actions that have been recognized in the lower courts after Casa v. Trump have been challenged in the Supreme Court. There's no emergencies to go up because those nationwide vacators, nationwide injunctions are still in place. They went back down. They said, here's a class action. Injunction put back in, and the administration hasn't brought those back up. And my question is it, if the class action can get you nationwide relief, does that make the court more or less likely to look at the APA with the jaundiced eye on this?
I think it has no impact. I take those cases almost to be an entirely different, at least in terms of legal significance, universes. So in one series of cases, you have what became Trump v. Casa, which is a case about the birthright citizenship executive order, but was up at the Supreme Court in an emergency posture on the particular issue as to the appropriate scope of the remedy. And what the court does, in what I thought was an excellent opinion by Justice Barrett, is the court analyzes, okay, at equity, what would have been the scope of the remedy? And the court determines that the nationwide remedy would not have been understood as an appropriate remedy when a court was doing equity. Under, we might call it the Judiciary Act of 1789. That is, of course, not the only statute where a federal court might derive an equitable power from, although maybe all of it goes back to the judicial power of the United States as vested in Article 3 of the Constitution. But I take all of that to be proceeding along a track of, okay, number one, what are the equitable limitations? And then number two, how do we interpret what the federal rules of civil procedure have done with the class action, grafting on top of the old school equitable limitations on the judicial power, and in particular, the scope of available remedies. I'll flag a good paper, I think is still forthcoming, by a recent law school graduate, Elias Niebert, on this question of, okay, if we have the appropriate class, can what might look like nationwide relief be granted in that case? And there are some other problems there with putative classes or certified classes and the like. That debate proceeds. It carries on apace in the lower courts, as you rightly note, because there are, of course, the birthright citizenship challenges and many other kinds of challenges. I will note that I think the Trump administration, through its Office of the Solicitor General, has been quite strategic about the cases that it brings up to the Supreme Court, which I think can account for the administration's impressive win record at the Supreme Court, is the job that the SG's office has been doing in framing up these cases. I take the question whether the statutory term set aside under the APA means, can we grant complete relief to parties who might not traditionally have that cause of action that John Harrison at least seems to understand? Or is it that we're supposed to grant the relief of wiping an agency action off the book? I take it to be in a separate universe legally. Whether they converge practically, whether one or two or enough justices to constitute a swing in a majority ruling, believe that the atmospheric effects of some of the court's holdings, or you might at least call them in the emergency posture, ruminations on the law of equity, impact what the meaning of the statute is? I don't think so, but I totally understand, like, there is an atmospheric backdrop here as to the scope of remedy in cases in which the executive branch of the federal government is on the other side in one form or another.
Okay, we have time for one or two more questions. If you have a question, please be brief. Yes, sir.
Fred Bonig from the Daily Ripple. If the FDA decided that there would be no more vaccines for children, mandatory vaccines for children, would Big Pharma have a case the same as the gas company? I mean, because they're going to lose money if they're not going to have mandatory vaccines, right?
Truthfully, I haven't studied it. I don't know exactly what the relevant cause of action would be or how that would work. What you'd need, of course, an administrative record to take a look at. There are a variety of questions as to the underlying statutory authority, the arbitrary and capricious standard, but without having studied the particulars of that case, I think I'd be doing a disservice to the legal question to try to analyze it.
Brent, could I add just one thing on the question of vacator that sort of prescinds from this issue of what does set aside mean? It shows you how oftentimes the deck is stacked against property owners in the lower courts, that in the D.C. Circuit and in the Ninth Circuit, even if you win under the APA, if it's an environmental case, oftentimes the court won't set it aside at all. I mean, we're not even talking about universal vacator. They won't even set it aside as to the challenging property owner under the fiction that, well, in equity, we can keep this illegal rule in place because on remand, maybe the agency will be able to fix it, and we wouldn't want any snail darter or fairy shrimp to be destroyed in the interim. And it really is pernicious, and it just goes to show you that remedies, if you don't have a good remedy, then you really don't have a good right. So I think to the extent that the court does address this question of vacator, it would be great also if they were to address at least consistency in those who challenge under the APA.
Thank you. And I think we have time for one more question from our audience here. Okay, I will take up a question then. Let's see. I guess what administrative law cases or issues do you think are primed that the Supreme Court wants to take up or should take up in earnest. And it will be quick. We have about 90 seconds.
So we'll talk about it more later today. I think I mentioned the tariff case, which non-delegation is one of those arguments along with others. So we'll be watching closely. And some of the language that Justice Kagan used in the Consumer's Research opinion, it may be very relevant depending on how they interpret the language of the statute.
I would say the question of administrative adjudication, Tommy mentioned the Jarkissi case from a couple of terms ago, the extent to which that case can apply beyond just the facts of an SEC adjudication, whether other administrative penalty proceedings might be at risk because you're not afforded an Article III tribunal. I think that would be an important follow-up case for the court to take.
And maybe shifting gears a little bit from what we've been talking about in terms of review of agency action, I think that the court is primed to take a merits case on the question of how far the independence of independent agencies goes and what the remit of the president's power is to remove the heads of so-called independent agencies with whom he has a policy disagreement, what the limitations of for cause are in certain statutes. And so I think we'll hear a lot more from the Supreme Court in the coming terms about what exactly the executive power allows in terms of presidential removal of purportedly independent officers.
All right, terrific. Well, I want to thank the panelists, and please join me in thanking them.
Good afternoon, welcome back. We're going to have a panel about a topic that can't fail to warm your heart on our first rainy fall day. One of the most important and satisfying topics that you can discuss, suing the government. I'm Clark Neely, I'm Senior Vice President for Legal Studies at the Cato Institute. To my right is Brent Skorup, who's a legal fellow with the Center for Constitutional Studies, a graduate of Wheaton College and George Mason Law School. To Brent's right is Patrick Giacomo, a senior attorney at the Institute for Justice and co-leader of IJ's project on accountability and immunity. How's that going? And then,
it's an honest living.
well, we'll find out. And then to Patrick's right is my colleague, Matthew Cavadon, who is our new director of our project on criminal justice. We're going to be discussing at least 3 cases, perhaps more. Why don't we start in reverse order? So Matt will talk to us about Barnes v. Felix, which is a traffic stop case involving a rather unusual legal doctrine that the Fifth Circuit used to have. And then Patrick will talk to us about Martin versus United States, which was a botched FBI raid. And then Brent will talk to us about Trump v. Casa, which involved, well, it started off with an executive order on birthright citizenship, but it morphed into a case about universal injunctions. So a lot on our plate, and perhaps some other cases will come up as well. As always, we look forward to your questions at the end, so please be thinking of some good questions, and we'll turn to those after we've had some back and forth here. Matt, you want to kick us off?
Thank you all very much for coming back after lunch. Hope that you enjoyed it very much, and thanks for paying your dues by sitting through my part of the talk. But I wish I had riveting facts like alternative fuel producers suing state bureaucrats over federal exemption waivers, but all that I've got is a traffic stop. I want to take you back to 2016 on the Sam Houston Expressway outside of, indeed, Houston, Texas, where Constable Roberto Felix pulled over a car. He had information that the car had unpaid toll fees for the Sam Houston Expressway. And indeed, as a constable, enforcing toll collection was an important part of Constable Felix's duties, not just because it's part of upholding law and order in society, but also because the constable's office receives a fair cut of the funds that are collected through toll enforcement. The particular driver that he pulled over was a man named Ashton Barnes. Ashton quickly explained that the car, in fact, wasn't his. It was a rental car. And he wasn't even the one renting it. It was his girlfriend's. Nevertheless, Constable Felix stopped him, requested identification, and began to question him about the possible smell of marijuana. At some point during their exchange, the car went out of neutral, back into drive, presumably because Mr. Barnes indeed put it back in drive, and began to pull toward the road. I say presumably because we actually don't have body cam footage from Constable Felix. This is all from his dash camera back a good ways from the car. In any event, the car started to head back toward traffic. Constable Felix responded by jumping up on the door's runner, the front door's runner, drawing his firearm and saying, "Stop, stop," and within 2 seconds, firing repeatedly blindly into the car, killing Ashton on sight. Ashton's family brought a civil rights lawsuit arguing that Constable Felix had violated Ashton's right to be free of excessive force in the course of a government seizure. A lot of these lawsuits depend on granular factual analysis of what led up to an officer's use of deadly force, what was the context, what was the rationale. But when Ashton's survivor's case went to court, the court said, I actually only care about one thing. Was Constable Felix in danger at the time he pulled the trigger? And because he was standing on the runner of a moving car, the answer was yes. The court said, I really don't like that I have this many blinders on, but the Fifth Circuit Court of Appeals has directed me to consider only the moment of the threat. Based on that, the case is over. There's no relief for the family. There's, in fact, no further inquiry, nothing here for a jury to do. The family appealed to the Fifth Circuit, and a panel of the Fifth Circuit wrote and said, Yeah, indeed, them's the brakes. That's what our test is excessive force is measured only in light of the moment of threat and nothing else. In addition to the trial judge saying, I don't like these blinders on, the Fifth Circuit's author, Judge Higginbotham, said in a lengthy concurrence, I don't like that this is what our precedent tells us to do. In fact, it seems like when we're looking at the reasonableness of force, we should look at the totality of the circumstances. We should let courts explore the full picture and not just limit ourselves to a few seconds that are the crucial decision moment, but look at the entire encounter. His concurrence helped persuade, I'm sure, the Supreme Court to grant review in the case. The Supreme Court, in a unanimous decision by Justice Kagan, reversed the decision below and said, when we're talking about the Fourth Amendment, we're talking about reasonableness. When we're talking about reasonableness, you can't have chronological blinders, as Justice Kagan called them, on the court's inquiry. You got to look at the whole picture. What that means is you got to consider, what are the reasons for the stop? What is the potential danger to the public? What other options does the officer have? How split-second was the officer's decision? All of those things are relevant for a court's consideration. The court did not say that Constable Felix violated Ashton's rights. It simply said that the case needs to go back for a fuller, more robust inquiry. On the one hand, the majority's decision was pretty narrow. All that it did was get rid of this fairly artificial test that the Fifth Circuit had put in place, saying only look at the specific moment of danger. In that way, the case actually lines up with Seven County Infrastructure Coalition v. Eagle County that you all heard about this morning. The Supreme Court just not having much of an appetite for lower courts coming up with extra requirements beyond those that are put in by the Constitution or statutes. Skepticism of judicial rulemaking. On the other hand, hopefully, the court also signaled that some of these very fact-bound issues should be sorted out not by smart people in robes, but by juries. That indeed there's a role for the public in assessing what is reasonable and holding government accountable. To look at some of the bigger issues contextually that came into play here, there was a concurrence. Justice Kavanaugh, joined by 3 other justices, so that's 4 out of the 9, almost a majority, wrote a lengthy concurrence talking about how just because we're opening the door to relief here, don't go too far. Police officers do really dangerous work. A lot of things are split-second decisions. In fact, that's especially true in the context of traffic stops. The court's opinion came out just weeks after somebody in New Orleans plowed a car into a crowd. Justice Kavanaugh said, you never know if somebody you're pulling over might be that person. He also pointed out that the Oklahoma City bomber, Timothy McVeigh, was picked up after a traffic stop. He mentioned hijackings, child abductions, all of these things, basically to say the courts shouldn't put too tight of a leash on police, especially in traffic stops. You never know if John Wayne Gacy or Jack the Ripper might be driving the car. So on the one hand, you do have a bit more room to sue the government. On the other hand, you have this very strong reaction against there being too much skepticism of that. Now, is that borne out by the facts? Well, police training manuals often do talk about traffic stops as exceptionally dangerous. The most thorough academic study of them, though, found that only 1 in about 5,000 even involves an unarmed assault or any kind of aggression toward the officer, and that deaths are vanishingly rare in the context of traffic stops. There's the potential for danger, to be sure. You have an officer who's approaching a car where they might not have full lines of sight. But nevertheless, I think that, and my essay in this year's review argues, this is a bit of a knee-jerk reaction here, because there's also the potential for police abuse in these situations. Yes, drivers can be dangerous to officers, but also officers might kill somebody over unpaid toll fees on somebody else's rental car. As with a lot of issues in the Fourth Amendment context, there needs to just be careful balancing. I think it's a bit much to say that we owe extreme deference in the context of traffic stops in particular, especially because a number of jurisdictions are thinking carefully about alternatives to policing in the traffic context. We're starting to see some of those duties in certain cities handed over to civil enforcement, or just pick up somebody's license plate on a camera and send them the ticket in the mail later on, rather than doing a stop where you're putting an officer and civilians potentially in harm's way, more so than you would be otherwise. So we'll see what happens with the case on remand. Another big legal issue that's lurking here that came up in the briefing a fair amount is, what do we do if an officer contributes to or creates the danger that they then use as a justification for using force? The court punted on this, explicitly reserved it, and said we are not making any decisions about whether that's automatically a factor in favor of accountability or whether that's a non-factor and we only look objectively at the circumstances. But it is a live question. It is a question that comes up often in cases that Cato has worked on recently. We filed amicus briefs in a couple of cases over the past few years where, say, officers didn't verify an address before going out and kicking in a door. What happens if an officer creates danger to some extent by not doing their homework and confirming things like whether or not the house out front has a wheelchair ramp, an attached garage, the right street numbers? These are the kinds of things that sometimes go through the cracks. And I think we're about to hear a little bit more about raids gone wrong. But especially in a country where people often exercise their Second Amendment rights, and if you're not expecting police officers to show up and somebody bangs through the door in the middle of the night, if you're a gun-toting, rights-bearing American, well, who's created the danger there that ensues? The Breonna Taylor case featured some of that in Louisville a couple of years ago, right? You had an unannounced raid on an apartment. The people inside had no idea that it was police who were showing up at their door. Breonna's boyfriend retrieved a gun, opened fire. Officers killed her as a result. Does the role of officers in not verifying their information and taking those steps ahead of time, does it factor in, and if so, how? There was a lot of question as to whether Barnes was going to be the case that explored those issues in detail. The court took an easier way out and went with a more minimal solution on this. I'm guessing reflecting divides among the court's members on this, and indeed the concurrence explicitly said that we don't think this is a valid consideration. So we'll see where this heads in the future, but I think that I have hopefully prepared things nicely for the Martin case, and there you have it.
Thanks, Pat. As some of you know, I have a radical idea for answering some of these questions, which is to leave it to a jury. But, that's me. I'm crazy. I'm an originalist, unlike some people I could name, on this issue. So, Patrick, I think some people who are unschooled in the ways of the modern judiciary might think if you're sitting at home minding your own business with your family and an FBI SWAT team comes barging into your house, weapons drawn, perhaps with a couple of flashbang grenades, maybe prones out a couple of your kids, holds everybody at gunpoint, terrifies everybody. Turns out they had the wrong address and no real good excuse because they threw away the GPS device that supposedly sent them to the wrong house. You might naively think that you would have some remedy, but that would be premature, wouldn't it?
I think it lacks a certain nuance when the question is whether you can hold the government or its agents accountable. And one of the things that you often run into in litigating issues that amount to immunity and accountability work is the concept that you have to be really smart to believe some things that are so dumb. And I think Clark's introduction here kind of gives you a good flavor for that, because most people across the levels of judicial or legal engagement will hear a story about the police, whether they're FBI police or local police, raiding the wrong house and think, well, of course, there's going to be something you can do about that. You're an innocent person who is doing nothing wrong. There was nothing you did to invite this problem. It's not the difficult decision we just talked about where you played some role, you drove the car presumably. This was just the police screwing something up. But as it turns out, First of all, this is a much more common problem than I think most people realize. Frankly, even though I had been working in this space for a decade at the time, I had no idea how prevalent the wrong house raids are across the United States. And over the course of about 6 months, without any intention of doing so, the Institute for Justice managed to collect 3 different cases that were all being litigated on different legal issues. And we realized, wow, this is a big problem. One of those cases was called Jimerson versus Lewis, and it's what was referred to earlier with the wheelchair ramp. We filed cert in that case the same day that we filed cert in Martin, and I should also say my bias here is the fact that I represented the Martin family in Martin versus United States and argued the case before the Supreme Court. In Lewis, the issue was qualified immunity, and we're not going to get into all that, but it's a whole can of worms that many of you are probably at least somewhat familiar with, and that was the reason why the family in Texas, in Jimerson, was told they couldn't sue the officers who broke into their house without checking the address. Justices Sotomayor and Jackson actually voted to grant, but the rest of the court didn't come along. We didn't get to the 4-vote threshold. At the same time, we filed cert in the case of Martin versus United States. And this was another wrong house raid case that took place in Atlanta, where an FBI SWAT team, as opposed to a local SWAT team, kicked in the door of a suburban home without bothering to check the address. We're not talking about other difficult inquiries that need to be made. They had a warrant for one address. They went to a different address. They showed up. No one thought to look at the numbers on the mailbox, for instance, or notice several other conspicuous features. And instead, the tactical team rushed in and threw flashbang grenades and pointed guns at everybody, including a 7-year-old. And then they realized, oops, we're at the wrong house. Immediately, they left and went to the correct house and did the raid again down the street as the people who had just been traumatized, the Martin family, could sit on their porch and listen to this. Then the officers came back and basically said, hey, sorry about that. Here's a card you can call to get this taken care of. I've also seen this happen repeatedly where the card is handed out, and when you call it, it turns out that you cannot get it taken care of. This was one such case. So the Martin family, Trina, Toy, and then 7-year-old, now 14-year-old Gabe, brought a lawsuit against the federal government under several theories. The one we're going to talk about today is one under the Federal Tort Claims Act, because despite how difficult it is to sue government officials writ large, thanks to things like qualified immunity, when it comes to suing federal officials in particular, it's almost, if not actually, impossible in many instances. So you had the implied cause of action under Bivens for constitutional claims that the Supreme Court recently gutted in a decision called Egbert versus Boulay. And that leaves you with at least one small avenue, which is the Federal Tort Claims Act, a statute that Congress passed in the 1940s to essentially put the federal government in the same position as any other employer when it comes to vicarious liability. And the way the statute works is it says you can sue us, the United States, for the harms committed by our employees as if we were a private person acting under the local law. So here we're talking about Georgia tort law. Torts, for those who aren't familiar, are basically the lawyer word for harms. And these are things that you'd think of like assault, battery, false imprisonment, these sorts of things. So that sounds great, and it is great, except for the fact that the FTCA is littered with exceptions and loopholes and requirements that are very difficult to satisfy. And so as it turns out, despite the fact that 80 years ago, Congress wanted to provide an ability for people to get a remedy, over that same period of time, the Department of Justice has done as much as it can and has been successful in many ways at turning the FTCA into Swiss cheese. And so we're going to talk about a little bit of how that comes up in the Martin case and what the Supreme Court does about it. So the Martins sue the United States saying you committed assault, battery, false imprisonment, and false arrest when you blasted into my house in the middle of the night and yanked me off of the floor and handcuffed me and pointed a gun at me and my kid. And you don't need to do too much explaining to understand why that would be a problem and why, if private people had done this to someone, there would not be a big question about whether you could sue over it. Nevertheless, the government pulled out its bag of tricks and it said, well, you have these different clusters of claims. You have the ones that are negligence claims, meaning whoopsie, and you have the intentional claims, meaning I put my hands on you. I knew I was putting my hands on you. This is intentional. And for the whoopsie claims, the government says, there's this thing in the Federal Tort Claims Act, and by the way, no one's been able to figure it out in 80 years. It's called the discretionary function exception. And it says that if you're conducting what is called a discretionary function, a term of art that's not defined, then we are not allowed to be sued as the federal government. We retain sovereign immunity. Here, there's discretion involved in deciding how to rate a house, and so we get this protection. That's not what the exception means, but the lower courts agreed with this. However, in the district court, they said, but for the intentional tort claims, those get to move forward because there's another exception in the FTCA called the intentional tort exception that says you can't sue for intentional torts, but it has a proviso that says, provided you can if the people you're suing are federal officers. And the reason that proviso exists is because in the 1970s, in the early years of the drug war, Congress amended the FTCA after a series of raids and said, we want you to be able to sue cops if they break into your house and beat you up. Nevertheless, after the district court said that, the 11th Circuit applied what it has called a supremacy clause bar to kill intentional tort claims as well. And so in the 11th Circuit, the rule was the intentional tort claims, they could move past this discretionary function exception because of the law enforcement proviso, but then they'd be eaten up because the 11th Circuit said, well, since these guys are federal officers, and even though it's the Federal Tort Claims Act, it's relying on state law. And that would somehow violate the idea of supremacy, even though Congress is the one who's passed the statute. It doesn't make any sense. And you might be thinking I'm giving it an uncharitable definition. The government itself didn't actually defend this rule. In the Supreme Court, they had to appoint an amicus. So it really was a completely kooky rule. But the end of the day was the case went to the 11th Circuit. They basically affirmed on both points. The discretionary function exception eats all the whoopsie claims, and the supremacy clause bars all the intentional claims. Sorry, innocent family who had your door smashed in and you were terrified and traumatized. There's just nothing we can do. You know, lamentations. Here's an unpublished decision that we don't go into much great detail about. So we took the case, and as I said, we filed cert on the same day as Jimerson. Jimerson got denied, but Martin got granted. And the questions that the Supreme Court took up are very important, even though what we're talking about is somewhat esoteric, and that was whether this law enforcement proviso essentially overrides all the other exceptions in the FTCA such that you can just sue federal law enforcement agents if they violate your tort rights, regardless of what the FTCA says elsewhere, and whether the supremacy clause has anything to say about it. So as I said, the federal government defended only this issue about the law enforcement proviso. The Supreme Court had to appoint an amicus who argued about the supremacy clause bar. And we argued that the law enforcement proviso should override the discretionary function exception, but they don't even come into contact. These are dealing with separate things. What the discretionary function exception is supposed to be about is protecting administrative decisions. So for instance, there's a case from the 1940s where you'd say, hey, we were doing this big policy after World War II of figuring out how to get a bunch of fertilizer to Europe as part of the Marshall Plan. And as a result of that, there was an enormous explosion in Texas that killed hundreds of people. There's a Wikipedia page about it. And they said, well, you can't sue about that under the FTCA because you're essentially suing for the policy making, which was, arguably quite bad. But you can sue for incidents of negligence. So like if you can't sue the Secretary of War for deciding let's put the ship there and fill it with fertilizer, but you could sue like the guy who throws a cigarette into the hold and causes the explosion. Over the years, the discretionary function exception instead morphed into basically any time someone has any discretion at all, a court's going to be willing to apply it and get rid of the claims, which of course has led to a situation where much of the FTCA's exceptions have swallowed the rule of the FTCA, which is to waive immunity and accept liability, because the goal is to put innocent victims back into the place they would have been but for harms created by the government. And so what the Supreme Court ultimately did here, in addition to being quite incredulous about the Solicitor General's arguments about how, for instance, FBI agents have the discretion to raid a house without checking the address, and that although it is the policy of the United States to do those sorts of things, if an FBI agent doesn't do that, there's nothing that can be done about it. Or, for instance, like Clark said earlier, if an FBI agent claims that his GPS, his personal GPS, led him to the wrong address, but is then unable to produce it because he threw it away despite his knowledge of an impending lawsuit, there's no problem with that either. There are a number of other factors that should have alerted officers that they were at the wrong place. Things that we would expect, by the way, a Domino's delivery driver to look at and discern before they put a pizza at the front door. So when the question is whether you rush in there with assault rifles and stun grenades, I think that it's reasonable to expect a little bit more from people that are sworn to uphold the Constitution. Ultimately, the Supreme Court did two things in this case, and they both seem kind of technical, but they're actually a very big deal, especially now in the current state of play when it comes to suing federal officers. One is they said, no, the 11th Circuit was wrong that the law enforcement proviso wins out across the board. That doesn't mean that you can't bring a bunch of claims. It just means that they have to be subjected to the other exceptions, and if you can get over those hurdles, you can proceed. So that's something that actually is somewhat beneficial to the government. The 11th Circuit was the only one that had this rule. There was another rule that was kind of like it. But it sent this issue back down for further consideration, which I'm going to get into. The other one was the Supremacy Clause bar, which they agreed with everybody else except the poor amicus who had to argue the case because he was doing his duty for the court, is completely nuts. To say that the Supremacy Clause bars Congress from passing a federal law to hold accountable, itself, essentially, the United States, just made no sense. This is a unanimous opinion by Justice Gorsuch, who gets into all this stuff about in Ray Nagel and how you couldn't, criminally charge security for a Supreme Court justice back in the 1800s. It's an interesting little story, but it's not a difficult issue to apply to a case involving a wrong house raid. But a lot of the good done in this case comes in the final section of the opinion where the court says, look, Patrick and the rest of the folks at the Institute for Justice are telling us we should go further and explain why there should be an avenue here and why these exceptions shouldn't apply, but we don't want to do that yet because the 11th Circuit hasn't. This is, of course, not uncommon when it comes to the Supreme Court. But what the Supreme Court then did was articulate all of the arguments that we had laid out and said, well, these make some sense. There are some more circuit splits. You really have the Supreme Court remanding a case saying there are more circuit splits on these issues, but we're going to leave it to the 11th Circuit to address this stuff in the first instance before we take a look. So we'll see what happens with the remand, but the Supreme Court is obviously at this point dog-eared some additional issues for the FTCA for a potential future return in the Martin case, depending on how it shakes out. The other thing we have is Justice Sotomayor, joined by Justice Jackson, concurring and saying, yeah, of course, all that stuff's true, but being much more forceful and saying the discretionary function exception doesn't cover this sort of behavior. We've explained in other cases that, for instance, driving is something that, of course, everyone has a lot of discretion. They're deciding how fast to go, how slow to go, when to turn, use your turn signal, all these things. That's not covered by it. So what's the difference between deciding to drive to a house and then deciding to raid the wrong house, and how is one covered and one isn't? It doesn't make a lot of sense to me, says Justice Sotomayor. So we are now in a place where the door is at least cracked open for a new avenue into federal accountability to be reopened, because since Bivens did exist for much of the last 50 years, the FTCA has kind of been an issue, a place where a lot of things have just gone fallow. It was not viewed as the main civil rights avenue because of all its exceptions, because it's talking about torts, because you have to find a tort that sort of maps onto your constitutional violations. Now I think with the demise of Bivens, especially because the court's justification for that is we need Congress to provide a cause of action, and of course the FTCA does just that. The Supreme Court now and the lower courts hopefully will be reinvigorated to take a closer look at the Federal Tort Claims Act and make sure that it actually does provide the remedy that Congress intended, or at least some remedy at all. And that's the goal and the hope that what we can accomplish in this case going forward, and if not this case, others that are pending.
Thanks, Patrick. So, Brent, as a former litigator, I have experience with the ability of a court to issue an injunction that either requires a party to take some action or forbids a party from taking some action. And generally speaking, once the court has jurisdiction over a party, court gets to tell that party what it can and can't do. You think about Starbucks, for example, has got a shop on pretty much every urban street corner. And the idea that Starbucks could have some illegal hiring policy go into court and be like, you can only tell the store at the corner of F and Massachusetts Ave to stop doing it, right? That's not a thing. Starbucks is the party in court. But we may see a theme developing here on this panel, because when it comes to the federal government, this idea that once having acquired jurisdiction over a particular party, you can tell that party what to do and what not to do, doesn't necessarily apply to the federal government across the board. Fair? Or at least in the light of the Trump v. Casa case.
Yeah, that's right. in Trump v. Casa, I'm sure many are familiar with the underlying issue. I mean, there's no escaping the birthright citizenship issue. Although when it reached the Supreme Court, it was squarely about the power of district courts to issue universal injunctions in this.
Let's back up and make sure not everybody in the audience might know how the case was initiated. How did it start?
Certainly. If you do know this case, you know about the birthright citizenship issue. So on day one of the Trump administration, he issued an executive order purporting to reinterpret the 14th Amendment's citizenship clause, which provides all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And that was passed that was added, amended to the Constitution, an amendment to the Constitution in 1868, shortly after the Civil War. It was Congress responding to the Dred Scott decision a decade earlier, which involved a slave who believed he was free when he got to a free state in Illinois, tried to assert his rights, and the Supreme Court said that he could not, he was not a citizen, that anyone, any black person who descended from slaves is not a citizen, whether they're free or enslaved. And so this was Congress responding to that squarely, saying, if you're born in the United States and subject to the jurisdiction thereof, you are a citizen. And certainly after the Civil War, this was a major issue as many are freed black people were freed. Now, the core legal dispute is about what does this phrase "subject to the jurisdiction thereof" mean? That conditions the clause that you're subject. If you're born in the U.S., you're a citizen. And this was viewed as settled by there were some cases in the 1890s involving typically Chinese families who subjects of the Emperor of China, but who had children in the U.S. They were resident aliens in the U.S. And the Supreme Court held in Wong Kim Ark and some other cases that children born to resident aliens, even if their parents are subject to a foreign power, those children are subject to the jurisdiction of the U.S. They are citizens if they're resident aliens. And that's been how everyone has assumed the 14th Amendment is interpreted. I should say in Wong Kim Ark, there were some narrow exceptions that the court laid out, and this is relevant, but they're all extremely narrow. Children of foreign diplomats, children who are born aboard of foreign flag ships in U.S. waters, children of who are born to an occupying army. I mean, there's not many pregnant women in occupying armies. I don't think it's ever been an issue. And then also Native American, unassimilated Native American tribes who live in tribal lands, but that's no longer an issue either. All that say, I mean, children of diplomats has really been the only small category of children born in the U.S. who are not deemed to have birthright citizenship for decades, and that's been the practice of the executive branch for decades. As I would say in the last 15 years or so, there's been a small group of scholars and activists who want to revisit what subject to jurisdiction means and expand upon it. And the Trump administration has taken that as an invitation to broaden the categories of people born to aliens to include, under the executive order, a child would not be a citizen at birth if they're born to a mother who is in the U.S. temporarily, perhaps on a student visa or tourist visa or something, or if their mother is in the U.S. illegally. And that's a pretty huge expansion of these classic categories that everyone has recognized. So that's the background. As you can imagine, many parties immediately sued at the issuance of this executive order, including some pregnant women who might be here temporarily or illegally, who feared quite rightly for the citizenship of their future child. You also had states sue, alleging harms dealing with some administrative harms about determining citizenship, and also they receive federal payments for welfare benefits and distributing them to women and infants. So several groups sued. Critically, in the District of Maryland, the district court judge issued what was called a national injunction or universal injunction. Just a little bit about this because it was relevant in the decision. These national injunctions, universal injunctions, were there's some legal dispute about when they originated. The majority, and I'll get to the decision in a moment. I'll go into the decision and discuss the history. So the government brought this to the Supreme Court on emergency posture against this national injunction. So they kind of left the citizenship issues aside. They want to focus. They picked this case to offer the issue of universal injunctions. I should add that the waning days of the Biden administration also tried to raise this issue of universal injunctions. It's been a thorn in the side of many presidents that district court judges, there are almost 700 of them out there who are issuing national or universal injunctions. So the Trump administration brought this to the Supreme Court in emergency posture in March. The Supreme Court quickly agreed to hear it and issued a decision a few weeks ago about the authority of district court judges to issue these national injunctions. And the core legal issue, the federal government offered two reasons to deny district courts this authority. One is in Article 3, judicial power, saying they don't have judicial power to issue these, which the court didn't take up the invitation to approach that. But the core issue was, does the Judiciary Act of 1789 authorize district court judges to issue universal injunctions? So the Judiciary Act of 1789 gives federal courts jurisdiction over all suits in equity. And this is still the foundational law for the jurisdiction of courts. And so the question is, in equity, can a court issue universal injunction? And it's been the position of the Supreme Court since Grupo Mexicano, a case in 1999, that when determining what sorts of relief a court can offer at equity, the court will look at what remedies were available to the Court of High Chancery in England at the time of the founding and at the time of the 1789 Judiciary Act. And so, the decision, all the justices seem to agree on this originalist framing. What remedies could courts issue in 1789? Where they disagreed was on whether there was an analogy to the relief available in 1789. So in a 6-3 decision with 6 conservatives siding with the Trump administration and 3 progressives in dissent, they did a historical analysis about types of injunctions available in 1789 and said, and here's where we go to the history. So what's largely agreed is that universal injunctions did not arise and probably did not have occasion to arise until the 20th century. The majority says 1963 was the first issuance of a national injunction. Some scholars believe 1912, but I think everyone agrees it was not a feature until the 20th century, although there were some earlier possible analogies. And so for the majority, that's the end of the story. These were not available in the 18th century or 19th century, these universal injunctions. Therefore, that's the end of the story. The dissent thought there was a close analogy, so-called bills of peace. And this is where much of the argument and oral argument was about whether bills of peace, which are a traditional way of bringing an equity suit, where you could bind a few parties together. But for the majority, they said there's too many differences with it. The bill of peace eventually evolved into a class action lawsuit that we know today. And for the majority, that was enough that distinguished it from these universal injunctions. The dissent also makes some compelling policy arguments about if, and what they said was here, with a patently unconstitutional action by the government, that has exceptional harms, district court judges should be able to provide a national injunction against that. The majority said, well, on policy grounds, these go both ways, and it's just hard to make that the rule, because and this was the position of the Biden and Trump administration, that as they see it, the problem with universal injunctions is that the president, the government has to win at every district court wherever this is brought, and if even one gets through, they are enjoined nationally. And then issues of percolation, the idea that you want to have several district courts approaching this issue, along with some other issues. The majority said the public policy considerations go in both directions, and ultimately they were not compelled by that.
It seems extraordinary to me that there wouldn't be some carve-out or some limit. If ICE had a policy, for example, of any time it hears somebody speaking a foreign language in public, that's grounds to initiate a removal. The idea that literally everybody who speaks a foreign language in public would have to litigate that on their own behalf, or come up with a class action of everybody who sometimes speaks a foreign language in public. It seems unserious to me for the court to take the position that that there's no policy so palpably unconstitutional and outlandish that the federal judiciary would lack the ability to say you just can't do that.
Yeah, and this formed the thrust of Justice Jackson's dissent, that what. And I believe it was Kagan who brought this up in an oral argument, or maybe Sotomayor. Suppose another administration reinterprets the Second Amendment and starts seizing guns en masse from many Americans. The practical reality of this case is that gun owners like the pregnant woman here would have to join a class action. In both cases, you might have some reservations about adding your name to as a party in these things, and so it does raise some difficult sensitivities. Justice Kavanaugh, in his concurrence, seemed to want to comfort the American people on this. Said, well, we have the functional equivalent of a universal injunction, which is emergency application of the Supreme Court to kind of peek at the merits and stay whatever the government is doing. I'm not sure every justice would welcome that invitation, but that was Kavanaugh's view to, I think, calm the nerves.
Just want to make sure we have plenty of time for audience questions, but Patrick and Matt, I guess I'll ask each of you to just comment really quickly on one point of my choosing, because I'm a moderator. Patrick, if I recall correctly, the 11th Circuit was unanimous in shooting down your claims in Martin, right?
Yes.
And yet the Supreme Court was unanimous in saying that the 11th Circuit was wrong. And what's always fascinated me, and I've counted this before, is the number of times that you will get a unanimous circuit court saying whatever the government's doing is fine, and then on that rare occasion when somebody manages to get it to the Supreme Court, you'll have all 9 justices saying, no, it's not fine whatsoever. What it makes me wonder is, so for those who don't know, the Supreme Court only takes about 50 or 60 cases per year, but you've got more than 10,000 appeals going on. How often do federal courts of appeals unanimously uphold something illegal that the government's doing that wouldn't even get a single vote of support in the Supreme Court? That is a question that haunts me.
Yeah, I don't think there's any way to avoid it, and I think the fact that the Supreme Court uses discretionary review instead of having to look at every single case just creates this situation. But I think the Martin case is actually a great example of how egregious this can be, because not only was the 3-judge panel in the 11th Circuit unanimous in saying something that the Supreme Court said was wrong for 2 different reasons, but it didn't even bother publishing the case. And so for those of you who aren't kind of in the know, when a circuit court decides to issue a decision, if it's important, it will make it a published case. So they're all published, actually. This is a historic holdover. But the point is, unpublished cases are not even precedential, and they're kind of meant to be like, this is so easy, nobody really cares about this. So This case got thrown into the waste paper basket. And that was actually a concern for us as we were thinking about cert, was like, is the court going to be concerned that this is not a good vehicle because the case isn't even precedential? And so for the court to take it anyway and then to unanimously reverse it really underscores, how often this sort of thing might be happening, but for, the work going on across the country to try.
Yeah. Matt, I'm going to ask you to pardon me in advance for asking a technical legal question, but what accounts for such a preposterous and kooky rule as the moment of the threat doctrine in the Fifth Circuit? I just can't get my head around it. It's such a stupid rule.
Even though it is a preposterous rule, I think what it is reflecting is policy concerns of the sort that we see in the concurrence at the Supreme Court.
Well, fair enough. I mean, the judiciary is the policy-making branch, right? Oh, no, wait. There's another one. There's another one that makes policy. My mistake.
It's been a while since I was in high school civics, Clark. I'm not sure what you might be referring to there. Must be the administrative branch, right? The fourth branch of government.
That's what it is.
I mean, a lot of the concerns here are that in the Fourth Amendment context, the court shows a lot of deference to law enforcement. Enforcing the law is a dangerous job a fair amount of the time. Not at the point where you're deciding whether or not to check addresses, but by the time that you've stopped a car on the side of the roads or something, it can be a very dangerous circumstance. Nevertheless, the danger doesn't just run in one direction. And to say that we need all of these layers of insulation so that officers never get questioned, so that they have all of these different shields that they can raise in the unlikely event of a lawsuit. And by the way, let me back it up a little bit here. I said, this case can still go forward, by which I mean now the court on remand can decide whether or not there was a clearly established right to be free of whatever force Constable Felix used. Qualified immunity is still in play. Even in the event that Mr. Barnes' survivors make it past that, they then still have to convince the judge that there's a material issue of fact as to whether or not Constable Felix was reasonable. Only at that point can they go before a jury and ask a jury to decide, in fact, whether or not this was reasonable. All that the Supreme Court did in Barnes v. Felix was remove the outer fence before the moat filled with crocodiles, before the wall with the archers that dooms most excessive force cases. So
you mentioned qualified immunity, which is another example of judicial policymaking because it doesn't have the slightest support in text or history, correct?
That's right.
I feel like I'm detecting a theme.
The theme is that one of the background rules of civil rights jurisprudence is it's really hard to sue the government, and the courts are going to make it as hard as possible. And if that includes erecting artificial barriers to doing that, they'll do that. If it means setting up procedural hurdles that other kinds of litigants don't have to face when they sue private companies, they'll do that. If it means that if Congress opens the door and says, go ahead and sue, the courts will go, well, hold on a second, hold on, we're not ready to entertain all of these. Here's all these boxes you have to check first. Well, so where did this legally kooky, made up out of thin air rule come from? I mean, exactly the kind of atmosphere that creates these kinds of rules over and over and over again.
I feel like when it comes to all these doctrines that the courts make up out of thin air to protect government officials, some of these judges really miss their calling. They should really run for office if they want to be in the policymaking business.
Well, a fair number of them didn't miss their calling. Before they were judges, they were government lawyers, as you detailed in a study a couple of years ago. Something like, 2/3 or more of the federal judiciary used to be prosecutors.
Yeah, so about half of the federal judiciary were courtroom advocates for government, either as prosecutors or some other role, right?
So they didn't miss their calling. A fair number of them, perhaps, are still working out that calling, just doing it in robes now, so.
Well, but yeah, one more thing that highlights in terms of the heads I win, tails you lose analysis is in a lot of these immunity side cases, the courts will say, oh, well, we need these because we don't want this flood of litigation and all these lawsuits, right? And so the concern for the court is we can't open the floodgates. But then you look at CASA, and you have the Supreme Court saying, well, the solution here is you just bring 117 million lawsuits. Yeah. Like that we can't have a universal injunction. Just every one of the 32 million people will bring a lawsuit and it'll get decided, and that's how we'll decide.
Now, I'm still getting a distinct flavor of heads the government wins, tails the plaintiff loses.
Exactly.
Now, I don't mean to inject any cynicism after lunch here. one might wonder whether or not by
That ship
axing,
has sailed, Matt.
by taking down that fence alone, whether the court in fact has just made it that much easier to defend the moat and the wall and every other barrier by saying, oh yeah, we really do care. We're going to make the playing field fair. We'll nix the moment of threat doctrine. Yeah. Well, what does that mean for everything else? In the context of everything else, I mean, it is a win. I don't mean to downplay it. But, I mean, the Barnes's lawsuit still has a very slim chance of even getting to a jury, much less resulting in recovery.
Well, on that happy note, we'd love to get your questions. Maybe something will have a happier question. Sir, in the back, if you would, we should have a microphone for you. State your name and affiliation if you care to, and please do make in the form of a question. We got about 10 minutes left, so the shorter the question, we'll try to complement that with a brief answer as well.
J.P. Hogan, been writing about politics. I've been puzzling on birthright citizenship, especially because if in the Constitution there should be no right to crime, do you have to say legally born, or would that be redundant? Because a grammar in a Constitution would be there's no right to crime, no right to benefit from crime, bringing Robert's reuse, if there's a new benefit, it resets statutes of limitation. If giving someone citizenship based on a legal entry, it seems you don't have to say legally born.
Thank you.
Yeah, if I understand.
Make it quick, Brendan, short.
Yeah. I guess I'll say, even at the time of the 14th Amendment, it was a small class of people, but there were people who were not in the U.S. lawfully. Like convicts were not allowed to immigrate. Paupers were not allowed to immigrate. Some black slaves were brought illegally. So it wasn't totally foreign in the 19th century that some people might be illegal or not in the country permissibly.
Next question. Yes, sir. Third row.
Hi, my name is Andy Hawks. I'm a retired attorney. My question relates to Trump v. Casa. In striking down universal injunctions, did the court also prohibit a district court from prohibiting the government from doing whatever the injunction said throughout the district, or is it just to the party? In other words, similarly, if an injunction is upheld by the Fifth Circuit, is that now the rule in the entire Fifth Circuit for other cases similarly situated?
Yeah, the focus of the decision was that the parties are bound. This was a critical point. The parties themselves are bound, so even if, and I believe this has happened, even if the injunction is sustained against Trump administration against the named parties in the Casa case, even if they move to another district, the president and his delegates would still be bound by that.
But even if it's in the same district, a party has to sue again.
Yep, yeah, because they were non-parties to the original suit.
It's only if the defendant is the federal government,
Well,
right?
and I should say, and the Supreme Court pressed Solicitor General Sauer on this, that would you, if a district court ruled against you, would you follow that as precedent in the district? And he didn't give quite satisfactory answer to that. He said generally, and there is a long-standing practice of the DOJ. They just in some cases they will if they want to relitigate a case, they will try to relitigate again within the circuit or with, I don't know if within the district, but within the circuit. So that seemed to upset all the justices somewhat to not get a square answer, but that has been a DOJ position for a long time.
I think they got the answer. I think we all know that the government will just continue doing it.
Yeah. So it just occurred to me, there are some states, including my home state of Texas, that has multiple federal judicial districts. And I guess, if you have a state agency that has a blatantly unconstitutional policy, like if I don't know if the Texas Rangers had a policy of shooting Native Americans on site, which they used to, does everybody who doesn't want to get shot have to go and litigate that?
Well, I mean, then you've got the whole issue of the lions standing problem.
Yeah, that's
so,
right.
Well, we didn't know this particular Indian doesn't know he's going to get shot.
Yeah.
That's where we are with how ridiculous the parsing of all these things is.
But even if you could get past that, I guess my question is, after Trump v. Casa, is it the case that that doctrine applies equally to, let's say, a bad state agency, that you can't enjoin the entire Texas Department of Public Safety? Do we know? Do we have to speculate?
Yeah, I don't think we know. The court, pushed this back down to the courts. I mean, the big issue, and I think how a lot of this will be resolved, is that states, as litigants, pose a particular problem, or probably can get something resembling universal relief, just the nature of states as parties and the fact that people move interstate. So, functionally, it probably resembles a universal injunction, but no, there's many unanswered questions about how this will play out.
Yeah, I would say so. Anybody else in the audience have a question? Also, if you're joining us online, you can submit your questions through Facebook, YouTube, Twitter, hashtag Constitution Day, so feel free to do that. So Matt, when you say that the Barnes family has a long road to go, is there anything else besides qualified immunity that stands in the way? What else is there sort of manning the barricades against a successful lawsuit in that case?
I mean, there's also just the issues of you still have to convince a judge that a reasonable jury could determine that Constable Felix acted in an unreasonable manner in a split-second or relatively split-second decision like is at issue in Barnes v. Felix. That's going to be a tough call. Qualified immunity, to drill down a little bit more for folks who may not be as familiar with it, is the doctrine that a government official can be held liable only for violating a clearly established right. So a court could actually resolve the entire case by just saying that you didn't have a clearly established right not to be shot under these circumstances. Because no federal appellate court in the specific area had reached that decision before. And the Supreme Court has actually said that no court has to get to whether or not there was a rights violation if the right wasn't clearly established. So the court could simply say, we're not going to decide whether or not there was a rights violation, i.e. we're not going to clarify for the future whether or not there's any kind of right at issue here. We're simply going to say, well, as of the day it happened, it wasn't clearly established, and that's good enough. Or maybe it was clearly established in the 10th Circuit up in Oklahoma, but the 5th Circuit hadn't actually issued an opinion.
I've got a vivid illustration of how bad this is, and I know Patrick knows the story as well, but back when IJ and Cato were really pressing hard on qualified immunity and we thought there was some chance the Supreme Court might take it up, one of the cases, so they had a raft of about a dozen cases that were all pending before the Supreme Court, and they had rescheduled some of them, so they were kind of seemed to be synchronizing them. But just to take one case, there are so many we could talk about. This case involved a police pursuit where an officer tackled a guy in the front yard of a family's property in Georgia while the kids were playing out in the front yard. And so the officer had everybody lay down. And then the family dog came out from underneath the house. And of course, the officer did what any reasonable person would do, which is to draw his sidearm and start blasting away at the dog. Not being a very competent officer, thank goodness he missed. Dog retreats under the house, comes back a few minutes later. The cop starts blasting away. And the dog's not like growling or barking or attacking or anything. The cop's just blasting away at him. This time, he hits a 10-year-old boy who's lying on the ground a couple yards away from him. And you would think there would be no universe in which there could be any dispute about whether it's clearly established that you shouldn't be blasting away at a non-threatening family dog in a yard full of proned out 10-year-olds. But the 11th Circuit, in its infinite wisdom, said, well, when we look at our cases, we don't see any case with these identical facts, and so this officer would not have been on notice not to do that, so he gets qualified immunity. And we could sit here literally all day just telling these cases back and forth. And again, hopefully this isn't belaboring the point, but qualified immunity was not reflected anywhere in any law that was enacted by any Democratic body. It is a pure judicial invention by an act of judicial policymaking where the Supreme Court just said, well, it seems like police need a little more protection than Congress has chosen to give them. And it's not just that. Maybe since we're on the subject of immunity and non-accountability, there's an even more appalling non-accountability doctrine that maybe one of you guys would like to talk about, which is, so qualified immunity is what it sounds like, it's qualified, but there's another form for prosecutors, because qualified immunity is not sufficiently protective of rights-violating prosecutors. You know what they get? They get absolute immunity. So if a prosecutor has a beef with you, maybe you beat their softball team or something like that, or they don't want you, taking a particular person out on a date, they frame you for a crime they know you didn't commit, they suborn perjury to get the conviction, and you're in prison for 10 years, and they admit to all of it. Yep, I did all of it out of pure malice. I fraudulently made up all that evidence, and they admit to it. You still can't sue that prosecutor. Why? Not because Congress said you couldn't, but because the Supreme Court says you can't. Isolated example or part of a theme?
It's part of a theme. We have a case right now we're challenging prosecutorial immunity where a prosecutor in Texas spent 20 years working as a prosecutor by day and moonlighting in his own cases as a law clerk by night. And so he would write a motion, and then in the evening he would
write a motion as a prosecutor.
Yes.
I'd like to get this done for me.
Correct. And then at night he would write the order for the judge granting his own motion. And this guy sent hundreds of people to prison in Texas, including at least one to death row. And so we've been litigating for the last few years to challenge prosecutorial immunity in this case, which is called Wilson versus Midland, Texas. Ralph Petty is the name of this fine gentleman who was eventually disbarred after he retired. And we haven't even gotten to the prosecutorial immunity because, wouldn't you know it, there's all sorts of other doctrines that crop up first. And so in this case, we're dealing with something called Heck versus Humphrey, the Heck bar. But I do want to come back to one point on this reasonableness thing, which is what Matt and Clark have said is qualified immunity, at least in one of its many faces, is supposed to protect the ability for government officials to do their job without worrying. We don't want them to hesitate, right? So this includes police, and this often gets extended to say, like, it's a dark and stormy night. There's a shiny object. Maybe it's a gun. We don't want the policeman to think, I shouldn't pull my gun because I don't know. But the problem is we're double counting, or in the moment of threat case, we're triple counting, because that's based on the concept that police need breathing room. Qualified immunity considers the possibility that police need breathing room. And the Fourth Amendment itself considers the fact that police need breathing room. And so what that means is in a case like Jimerson, the wrong house raid case we talked about earlier, there, all that was appealed to the Fifth Circuit was the clearly established part. The district court held it was unconstitutional to raid the wrong house, and the officer just said, well, it wasn't clearly established. So it goes to the Fifth Circuit. And they point out, this guy didn't even challenge that he violated the Fourth Amendment, and yet they gave him qualified immunity anyway, which means, functionally, what the court is saying is, when you raided the wrong house, you were reasonably unreasonable. It makes no sense.
And let me, as long as our civil litigator here is going to talk about criminal issues, I'm going to talk a little bit about a civil elements of this, which is qualified immunity. Courts pretend like it's always about middle of the dark and stormy night and some shiny object. Qualified immunity extends to pretty much any government actor doing anything government-y. So we filed a brief last year. University of Rhode Island Department of Social Work canned a graduate student for being too conservative over the course of like a semester's worth of meetings. They said that his views were not a good fit for the social work profession and that they weren't going to give credit for a number of his things. I apologize if it wasn't URI. I think it was. It was a public college in Rhode Island, and I believe it was URI. This is not the middle of a dark and stormy night, somebody making a snap-second decision. This is committees upon committees of bureaucrats within an educational institution deliberately deciding that they didn't like somebody's speech, and so they were going to can him from a graduate program.
Well, I have another
qualified immunity.
Yeah, and I have another more timely example, which is, as many of you are familiar with, last year the Supreme Court decided a case called Vullo, where they said, hey, the Vullo versus NRA, where they said the person in charge of doing insurance stuff in New York is not allowed to jawbone the NRA's insurance companies into dropping them as a client. And the Supreme Court was pretty uniformly like, yeah, that's terrible. We shouldn't do that anymore. Case sent back down to the Second Circuit, which just recently then, of course, granted qualified immunity to this bureaucrat in New York, because the bureaucrat, it wasn't clearly established that you couldn't do something so outlandish as literally to go from office to office to office and say, hey, we did an audit on you and we found that you didn't file this paperwork correctly. And the thing is, we're going to have to prosecute you unless you turn away from the NRA and stop offering them products. And so we'll see if the Supreme Court's interested now in kind of reaping what it's sown with all of this sort of thing. This seems like a pretty good place to do it. But the point is, that's obviously not a situation where you'd be like, well, we don't want people hesitating. No, I think we do want people hesitating, especially when what they're doing is engaging in like a years-long strategic campaign to go after an enemy of theirs.
And let's not forget, the Supreme Court only just held a year or two ago that if your rights violation is so crazy that there's no clearly established law, because nobody has ever thought to violate somebody's rights in this way before. The Supreme Court has now said, if you can prove that you're in fact the only person ever prosecuted in this way, you can sue. But that's like a 2-year-old precedent. Yeah.
Yeah, you know, I mean, I hate to beat a dead horse, but it seems to me that this is a question a jury ought to answer, right? I like the idea of government officials thinking to themselves, before I do this kind of awful thing, let me envision myself trying to explain to a jury why it is that I made this decision. That seems pretty healthy to me.
Well, this takes us back to where we started, which was that you have to be really smart to believe something so dumb.
Right.
Because the courts have said, hey, we've created qualified immunity, and by the way, the question of qualified immunity is one of law, so it's not for the stupid jury to have to weigh in on. They don't get a chance to do it.
Dance like nobody's watching, write emails like they'll someday be read aloud in a deposition.
A little piece of personal advice, don't ever find you somebody who looks at you the way courts look at juries these days. That's not a good person to have in your life. All right, is there anybody else? I thought I saw a hand up there before. I see like almost a gesture. Okay, that's close enough.
Hi, my name is Mary Budars. I'm just a private citizen. I'm just wondering what the birthright status, what's going on with that? Is there, I mean, one guy said it's no good and that's it.
Well, it's of no effect, particularly right now, I think, right? It's nobody's been denied citizenship on the basis of the executive order.
Right. The injunctions, I believe, are all essentially in place. And I think functionally that will happen. As I mentioned, 22 states, typically Democratic-led states, joined the litigation. And so, assuming that they can get relief, if half of states require relief, I think it will look a lot like a national injunction when they're granted relief.
Anybody else? Yep. Hey.
Yeah, hi, Paul Kamenar. And I think I talked to you, Clark, about this case. I'm working on an excessive force case here in the D.C. representing a January 6th protester who tried to pull a guy down from the window who was trying to break in. And she said, no, we don't do this kind of stuff. And then she was pushed into the West End tunnel where there was 50 officers and basically a phalanx of officers. She was savagely beaten with a metal baton over her head 35 times, bloodied, punched in the face 5 times by the lieutenant in charge. And we did a 1983 case. They filed, as expected, a motion to dismiss on qualified immunity, even though we have,
in the form of a question.
Yes. My question is, their defense is, well, I said, well, your own police report standard said you can't use that kind of excessive force. So they're saying, well, that doesn't count. You have to look at a case that says we can't do this. And even though the police form says you can't do that, that's not relevant. So what is the issue of the police own department's guidelines saying that this is excessive force, and yet they can get away with it?
So we've made these arguments, and I think they're good arguments on first principles, but most courts have rejected them. And most famously, there was a case in the 10th Circuit called Frazier versus Evans, where police were beating someone badly and another person videoed them. They saw they were being videoed. They went over and forced the person to give them the video.
Well, Patrick, they were trying to beat the drugs out of his mouth.
Yeah, I mean, I'm not trying.
Let's be fair to the police here. Right?
I'm not speaking to the merits of the underlying issue. And they had all been trained, in fact, recently by their police department. This violates the First Amendment. And I'm not going to say it verbatim, but I'm not being hyperbolic when the 10th Circuit's decision says whether or not you actually know something, whether you've been trained on it, is irrelevant. We look only to the available appellate decisions in your circuit or the Supreme Court. And by the way, a number of judges, including at least one on the Supreme Court who's been sneakily inserting it into decisions, have indicated that they might be opening this consideration to only looking at U.S. Supreme Court cases. So even a circuit court decision won't be enough if that's true. Now, hopefully that's not where things go. There have been like 7 cases where the court has kind of said, assuming that circuit decisions are sufficient, this wasn't clearly established. Now, this is crazy for a bunch of reasons. One of them is that in Harlow versus Fitzgerald, the case that gave us qualified immunity, the court's footnote saying what might influence what's clearly established included like district court decisions. And then in a case that's related to this obviousness exception called Hope versus Peltzer, the Supreme Court itself relied on the fact that DOJ and Alabama prison regulations had told prison guards, you can't, stake a prisoner outside in the heat and feed water to a dog in front of him. You didn't need to be told that, as it turned out. But the point is, like every one of these cases, as you've observed, is another opportunity for the court to say, as it has in one of my cases, well, that case said you couldn't put someone in a chokehold, but they were sitting in a chair, and your client was laying on the ground. And so you have to have these machinations every time. And if you win, the government gets an immediate appeal in the case, and so it makes the cases take longer. It's really, the title of our paper is Through the Federal Accountability Looking Glass, but with all of these immunities, we're through the looking glass. Like, there's no sense that can be made of this. There's no common sense. There's no reasonableness. We're just in a purely technical, made-up world.
Now, Patrick.
Hold on, Matt. I have to add one wrinkle to this Frazier case before we get too far. So this is the case in the 10th Circuit in Colorado. You can't generally sue a police department unless you can show that they have a policy or practice of doing the thing that happened, and failure to train can be as well. And so what happened in that case is when the police basically bullied this guy for recording them in public and sued both the department and the police, the officers asserted qualified immunity because they said there's no case on point saying not to do this. Yes, we were trained not to do it. Then they sued the department. The department said, well, you can't sue us because we have a policy of training officers not to do the thing. And so the judge granted both of them, said to the department, yep, you had the right kind of training, so you're out of the case. And then to the officers, you received the training, but that's irrelevant because we don't have a case on point, so you're out of the case. And nobody was held liable in that case, right?
Right. And
even though it was a blatant constitutional violation.
And like Clark said, we're at the point of this being like a parlor game where we could just sit around and throw back and forth insane examples of actual cases in the real world where things as kooky as this happen every single day.
So I don't sometimes use the term Article 3 co-counsel. I assume you know which branch is Article 3. So I used to get a lot of crap from certain people saying Article 3 co-counsel. Well, I defy you, in light of the discussion we've had today, to tell me that the term Article 3 co-counsel is totally unfair in every case. I think not. Sorry, Matt, go ahead.
No, I was going to say I just want to remind both of you gentlemen that we need to look at the real world. And if the whole point of qualified immunity is to make sure officers are on fair notice, well, look, people sleep through trainings all the time, but I don't know if you've ever met an officer who doesn't spend his nights reading federal appellate decisions on Westlaw, right?
No, it's actually, there's empirical evidence that police are not trained on the most recent court decision. So it's a fiction upon a fiction, and it had a really vivid illustration. You may remember one of you may remember the name of the case, but there was a Third Circuit case a few years ago where the Third Circuit had to ask the question, how long does a case have to have been out in public? How long after we publish it can we attribute this fictional knowledge to relevant government officials so that we know they're not going to read it, but what's the amount of time before we can pretend as if they would have had time to read it? And I can't remember what that was. I think it was a few days was enough.
I don't remember that case, but that's an argument the government made in our Castle Hills retaliation case.
Right.
They said, well, the case that clearly established this only came out like 30 days before we retaliated against your client. So that's not enough for us to have notice.
30 days is not enough time to not read a case. I can tell you that much.
Yeah.
All right, we've got time for one or two more. Yes, hey, Andrew.
Thank you, Andrew Feldstein, private citizen. I just want to make sure I understand the way this on notice rule works. Does that mean that if a court has never decided that whatever the action is doesn't give you qualified immunity, that action will always get qualified immunity? Because
Almost.
well, how can a new action, a new bad action?
That's a good question.
There is a narrow exception. It comes from the Hope v. Pelzer case that was mentioned earlier. If something is so much you're literally tying a human being to a post without water for 10 hours in the Alabama sun in summertime, if it is so stunningly uber-duber bad that the court can't stomach ruling in favor of the government, then the court has a narrow exception for that.
The way that the more functionally it works is as a matter of just grace from the court. They can take your case and say, look, it's not clearly established that when you savagely beat Patrick in front of the audience at the Cato Institute that it violated his rights.
Oh, you gave away the surprise.
I know, sorry. Hold on, everyone, in the next break. But in this case, we're going to announce that it is unconstitutional. And then going forward, it will be. And so the courts can just decide that in their own discretion, and some of them do, which kudos to them, but as you've observed, a lot of them do not, and then the cycle just continues, and the snake eats its own tail.
And we'll conclude by I'll just give you the last time the Supreme Court handed down a so bad that we don't need a case on point. A man was confined in prison in a cell that was covered on every surface with human excrement. The drain was backed up, so it was about 6 inches deep in human excrement, and he was fed his meals in there with no furniture, and it was also cold. And the Supreme Court said, yeah, we don't need a case on point. You want to know what the epilogue is? In the Fifth Circuit unanimously said, yes, qualified immunity, because we don't have a case on point where you can't hold somebody in what amounts to a cold open sewer for 6 days. So sorry. That's how bad things have gotten. Thank you all very much. Really appreciate your questions. And we'll take a 15-minute break before the next session.
All right, well, we're going to jump right into our next panel. So you all had the exciting topics like NEPA review and administrative law and standing. Now, unfortunately, you have to sit through the it's totally boring topics like religious liberty, porn on the internet, the cases no one really paid attention to this term. So this is our Bill of Rights panel, though I realized after we named it that technically one of the cases here is the Equal Protection Clause, which is in the 14th Amendment, which most people perhaps wouldn't include in the Bill of Rights. So we'll just say it's our rights panel speaking broadly, constitutional rights. So we're thrilled to have three great panelists who wrote three great articles in the Cato Supreme Court review this term on the cases. First up, joining us remotely is Vera Eidelman. She's a senior staff attorney with the American Civil Liberties Union's Free Speech, Privacy, and Technology Project. Her practice focuses on protecting free speech and privacy rights in the digital age, including the rights of protesters and young people, online speech, and genetic privacy. Previously, Eidelman was a William J. Brennan Fellow at the ACLU, and she holds degrees from Stanford University and Yale Law School. Before joining the ACLU, she clerked for Judge Beth Labson Freeman of the U.S. District Court for the Northern District of California. Next to my right is Cynthia Crawford, who's a senior policy counsel at the Americans for Prosperity Foundation, where she focuses on regulatory issues, freedom of expression, and educational freedom. She previously worked as a senior litigation counsel with the Cause of Action Institute, focused on defending clients against government overreach, emphasizing constitutionally protected individual rights. She holds a BA in Applied Mathematics from the University of California, Berkeley, a JD and an MA in American Government from Georgetown University, and an MBA from Cornell University's Johnson School of Management. And to my far right, Ezra Young, a nationally recognized scholar and attorney based in New York. He maintains a boutique private practice and previously served as a visiting assistant professor at Cornell Law School, where he taught courses on constitutional law, critical race theory, and transgender people, and the law. Young previously served as legal director of the African American Policy Forum, research director of the Columbia Center for Intersectionality and Social Policy Studies, and director of impact litigation at the Transgender Legal Defense and Education Fund. Young holds a BA in philosophy from Cornell University and a JD from Columbia Law School, where he completed a postdoctoral studies in trans rights and critical theory under Kimberly Crenshaw. So up first, we're going to go to Vera remotely to talk about the case Free Speech Coalition versus Paxton. Take it away, Vera.
Thank you so much, Tommy, and thank you all for letting me join you remotely.
Sorry, can we get our volume higher? Try again, Vera.
It wouldn't be 2025 without some technical difficulties. Good?
Sound good.
Okay.
Sound good.
Perfect. Thank you, Tommy, for the introductions. I'm excited to hear everyone's reflections on the cases today, and thank you all for letting me join remotely. So Free Speech Coalition versus Paxton is the case that I want to just quickly summarize for you all today. My goal is to just tell you what the case was about and what it held, and then I imagine that might spark questions, and we'll talk about pieces of it. I should also note that I was one of the attorneys on the case once it got to the Supreme Court, though not at the lower levels. And of course, I am only reflecting my own views, not the ACLU's and not those of my clients. So Free Speech Coalition versus Paxton, the law that was challenged in that case was a Texas law that required age verification for access to any website where 1/3 or more of the content was quote unquote harmful to minors, regardless of what was on the other 2/3 of the website. Harmful to minors under the Texas statute was defined as essentially obscenity as seen through the eyes of a minor. And I think very useful background for this is that that is a category of speech that exists in Supreme Court doctrine. It's a category that in a case called Ginsburg, the Supreme Court held the government has more authority to regulate with respect to kids than with adults. Essentially, adults have the right to look at content that is harmful to minors or obscene through the eyes of a minor, fully protected in the way that any other speech is for adults, but minors do not. And the test is essentially ratcheting down the obscenity standard for Miller to the perspective of a minor. And that fact, the fact that there is this difference between the First Amendment rights of a minor and an adult in this one context, only in this one context, is central to the court's opinion in the case, and I think to the very limited reach of what this case should mean for any other regulations of speech. So the case presented to the Supreme Court two questions. The first question was, what level of scrutiny applies when adults' right to access speech is restricted, is burdened on the basis of the content of speech that's fully protected as to them, but not protected as to minors. We argued that it has to be strict scrutiny because it's a content-based law just like any other law, and you could imagine the justification that it's bad for kids expanding much more broadly than just this one context. And we also argued that it's basically required that that be the test given a long line of Supreme Court precedent, including two prior ACLU cases, Reno versus Ashcroft, Reno versus ACLU and Ashcroft versus ACLU. Reno versus Ashcroft would be a fascinating case. And in both of those cases, the Supreme Court had looked at regulations of indecent sexually explicit speech online that included affirmative age verification as a defense to liability and held that those statutes were subject to strict scrutiny. So we basically said, this is the same case, same standard applies, and nothing about technology has changed the ultimate result, which in the prior two cases was that the laws were unconstitutional. Meanwhile, Texas argued that rational basis is all that should apply here, precisely because of the prior Supreme Court case Ginsburg that I had mentioned, which says that when the government is restricting access for minors to harmful to minors content, rational basis scrutiny is what governs. That question is incredibly important, as I'm sure you all know, because the level of scrutiny that applies often determines whether or not a law survives. If it's strict scrutiny, it's the most stringent possible test. It's very hard to survive. If it's rational basis, almost certainly the government will end up winning. And the Supreme Court ended up taking a middle road, basically holding, I think in a surprise to all of us, or at least I can speak to myself for me, that the law was in fact a regulation of unprotected speech with merely an incidental effect on protected speech, essentially applying a test from a case called O'Brien. And in order to get there, the court says, actually, no one has the right to access harmful to minor speech without first verifying their age. And the logic there is, if there's a difference between the rights based on age, the government has to have the authority to identify what age someone is. And so it basically bakes into the category of unprotected speech and out of the First Amendment protected right the exact burden that we were challenging, the requirement that people verify their ages. And just to step back for a second, why do we actually think that's a burden? Age verification typically requires identifying yourself, whether through government identification, through education, mortgage, banking, financial records, potentially biometrics. So there are a lot of ways in which it either gates people out of accessing speech because you don't actually make it through, the technology is inaccurate, you don't have the documents you need, or it chills people who would want to access, in this case, adult content, but are worried about there being a record of their particular interests, of the particular sites they frequent, etc. But notwithstanding all of that, the court basically says that burden is just not protected by, freedom from that burden is not protected by the First Amendment, precisely because rights in this context differ by age. And so it holds that intermediate scrutiny applies, and it holds that the particular age verification requirements in the Texas law satisfy intermediate scrutiny because verifying one's age advances the government's interest in knowing one's age to determine whether or not they have the right to access the underlying content at the end of the day. The one other thing I'll say is everything about the decision hinges on that point, that kids have different First Amendment rights in this specific context than adults do. And so it really ought not extend beyond this one context. That doesn't make the opinion good, in my opinion. I think it just continues the uniquely negative and burdensome way in which we approach sexual content in our legal system. But it does mean that this shouldn't extend to, for example, laws that are being challenged right now that require age verification for social media, parental consent for social media, et cetera. I think, Tommy, I will stop there, but if you want me to cover anything else, let me know.
No, that's great. Setting the table for the discussion to come. Cindy, take it away.
Okay, I'm Cindy Crawford, Americans for Prosperity Foundation. We filed an amicus brief in support of the petitioners in Mahmoud v. Taylor and have no relationship to any of the parties. So just by way of a little bit of background in this case, this is the Montgomery County School Board case in which they introduced a variety of literature into the curriculum of pre-K through 12th grade school levels that related to LGBTQ characters. The case itself relates more to the younger grades. So the claim was brought as a free exercise case, relying primarily on Yoder and Barnett. So the Yoder case was both free exercise and a hybrid parental rights case. And just to refresh your memory a little bit, this is the case from 1970 in which the Amish parents wanted to opt out their children from school after 8th grade because that was the tipping point at which it became preferable to them to have their kids at home learning their religious practices, their way of life, and so forth, and having them in public school became a burden on their free exercise. So also a little bit by way of background, before this case came along, and still today, Montgomery County, along with the vast majority of other school systems and states across the country, allows opt-outs for teaching of human sexuality, either in an opt-out or an opt-in sort of situation. So there's parental either approval or ability to disapprove having their kids involved in those types of instructional materials, as well as a variety of other situations in which typically parents have to give permission to school to do certain things with their children, like take them off campus, provide medication to them, and so forth. So it's not necessarily an unusual thing. There's a backdrop against which parental involvement in what happens with their children in school exists before this case came along. So Montgomery County, the school board introduced these books. The idea was to be inclusive, to introduce characters to the children, to maybe broaden their horizons and so forth. But when the books were introduced, clearly the school board knew that there was a potential for conflict, because originally they said that there would be an opportunity for parents to opt out. What happened was so many parents opted out that it actually became difficult for the school to administer the opt-out program because there were so many kids being taken in and out of class. And so that's where the conflict came. The school board then said, well, we can't administer this anymore. It's too difficult, so we're going to eliminate the opt-out. In response to that, over 1,100 parents signed a petition asking for the opt-out to be put back. So that's what led to the lawsuit. Also, by way of background, and the parties noted this and the court noted this, Montgomery County is one of the most racially and religiously diverse counties and school districts in the country. And so the petitioners in this case actually came from a variety of religious backgrounds, but they had similar concerns with wanting to withdraw their children from the instructional materials. So the legal background to this comes out of a couple of different sets of cases. So there's a body of case law from the 1920s that were brought under the 5th and 14th Amendments, which probably will sound familiar to you. We've got Meyer v. Nebraska, Farrington v. Tokushige, and Pierce v. Society of Sisters. All of those related to the ability of parents and teachers to control the curriculum that was taught to certain children in view of state efforts to either prohibit or require certain types of instruction. And then there's the big gap until we get to the 1970 Yoder decision. What's interesting about the Yoder decision is that it's been unclear for a while exactly how strong and how broad that decision was. Because on the one hand, it's been relied on as sort of a general right of parents to control the education of their children. And on the other hand, there's been very, very narrow interpretations of it in which people have argued that, well, it really only applies to the Amish because they have a very well-described and contained lifestyle, which is somewhat different from making minor adjustments to what a child is being taught in public school. So the Yoder decision was based on a combination of free exercise and parental rights. And then that leaves also the question of, is it really necessary for deciding these questions by invoking two rights? And here in the Mahmoud opinion, the court actually relied on that hybrid rights theory quite a bit. And so it's critical to this decision, but it kind of leaves open the question of, do you really need two rights to get this kind of outcome? The holding had two elements. So the first element was the sort of hybrid religion parental rights element. And then the second one, which piggybacks on a series of recent cases, the court also held that government cannot condition the benefit of free public education on parents' acceptance of instruction that violates their free exercise. So where does this leave us? First, there's one very clear element to this, which to me I hadn't really thought of before, and so it was a little bit surprising, but apparently there's a Yoder exception to Smith. Now this kind of makes sense if you think about it from the perspective that Yoder was decided before Smith, right? And Smith did not overrule Yoder, therefore Yoder should still exist and be powerful on its own. But most of the discussion about Yoder turns on the hybrid rights theory. And so the question is also, do you really need to have the hybrid rights to get that exception to Smith? So that leads me to wonder, going forward, if you need hybrid rights, does one of the hybrid rights have to be free exercise? Or could some other right fill that spot? So for example, you can imagine if the facts in this case were reversed, right? Say the books that were introduced into the curriculum, if they took a different perspective and they were actually hostile to the LGBTQ characters in the books, presumably there would be at least some set of people who objected on that grounds and wanted to opt out their children. They may not have a free exercise claim per se, but they would have a concern that would be at least a right of conscience. And maybe that type of concern could be brought under, for example, a free speech concern. And there's certainly a bit of literature out there discussing the extent to which free speech is relevant from the parents' perspective for their children that are in public school. And so I think that would be a very interesting place to go next with this. And with that.
That's great. All right, thank you, Cindy. Ezra.
Sure. I'm here to talk about Scrimity v. United States. This is an equal protection challenge. Many of you probably know it as the trans minor health ban. Over the last 5 years or so, 26 states have enacted pretty close to the same set of model legislation, essentially criminalizing and also banning trans minors, their parents, and their doctors and providers from accessing care that the Supreme Court sometimes calls gender affirming. That's a really dumb label, so I'm not going to use that. I just call it trans healthcare. The reason why I call it trans healthcare is this is healthcare that literally every single person in this room might at some point in their life need. The only thing that marks it different legally is if you're trans, the government puts a trans label in front of healthcare, and suddenly, apparently under Scrimity, you have less rights to access it. If you do not like big government, if you do not think members of Congress who are not the best we have ever sent to Congress should be the ones vetoing what medical decisions you make for yourself or your child, this is a case you should be up in arms about. Okay? So it was an equal protection challenge. The court initially presented the question as one of, are these trans healthcare bans, specifically of minors, but they could be of adults too, do they violate equal protection? The court didn't say, but it was highly implicated that maybe these would be some sort of sex classification. I argue in my piece that appears in the Cato Law Review, these are most certainly a sex classification. When you use a law to define sex and then put those labels onto people and then treat them differently because of those labels, that seems to be a sex classification. Unfortunately, the court did something really, really bizarre. And I'll say this much, I own my own law firm, it's named after me. I've written about Scrimity both before and after it was decided. I did not litigate Scrimity, but I did give advice to the ACLU that if they would have followed, they would not have lost. So, and I will die on that hill. But here's the problem with what the court did. And I mean no offense to you. I mean offense to the people who know I mean offense to. So this is the problem that the court did. And it's something that I think builds a little bit off of your case in a way that we should understand sort of the differences between what we're doing to rear children and what like full adults participating in our republic should know about. And you know, as a former professor and just person, we should all read more books, and we should not get our news from TikTok. Really read history books, among other things, okay? Trans people are not new to the United States. In part, we have the 14th Amendment, you know, that contains the Equal Protection Clause, because a black trans woman named Frances Thompson testified in front of Congress in 1866 about being gang raped by a mob led by the Attorney General of Tennessee, irony, and there was nothing that could be done because there was no federal power to go after the mob that defiled her and 4 other black women, but she was the only trans one. 1866, our predecessors knew what trans people were. They weren't idiots, as we are not idiots. Everyone was fine with the 14th Amendment protecting Frances Thompson. That was the person that they thought they were protecting. They knew what was going on. They thought it was abhorrent that lawmakers, especially the Attorney General of a state, would lead a racist mob. They didn't just rape these 5 black women, they also burned down all of the black churches in the black neighborhood of Memphis, because of course segregated. They destroyed most of the schools, and they destroyed the vast majority of the homes. So this is a very early pushback against the attempt of black people post-slavery to make lives for themselves, right? Fast forward 150 years or so, and we have this very bizarre debate going on in our courts, one that we've never seen before, where we're trying to sort of figure out what equal protection promises people. And I named my piece Scrimity's Mistake because this is a mistake we've seen in equal protection jurisprudence ever since ratification. There's some reason that too many Americans want to write in exceptions to equal protection that literally do not exist. There are no exceptions to equal protection if you read the clause. That's not a mistake. If you like reading books like I do, or audiobooks, because this one's long, Akhil Amar's Born Equal just came out. It's really, really good. If you're a huge history nerd and love going into footnotes, I suggest you read it among others. There's lots of legislative history around the Equal Protection Clause. It was not supposed to accept anyone. That was the whole point. It was supposed to shore this up forever and ever. But what did our US Supreme Court do in all of its brilliance to create more problems than needed? Over the decades and centuries at this point, the court has decided that it's not going to met out equal protection equally. Instead, bizarrely enough in the context of equal protection, it is going to create a hierarchy of groups and persons, some of whom deserve more equality than others, like some horrible joke via Animal Farm, but this is the reality of our equal protection jurisprudence. So fast forward to 2024, when this case is argued in December, many of the justices are scratching their heads and saying things that you might have heard your local politicians say. Well, if trans people are going to have this right, shouldn't they have to get a constitutional amendment? Shouldn't there have to be a special law that establishes you're not allowed to treat trans people differently than the rest of everyone else, right? That's diametrically opposed to what equal protection is supposed to do. And unfortunately, the court went down that rabbit hole. In a very weird majority opinion authored by Chief Justice Roberts, he held that the Tennessee law, known as SB 1, is okay constitutional because it meets rational basis review. And by the way, for anyone who cares about getting rid of the scourge of sex discrimination, he concluded it is not sex discrimination. Instead, and this is even better yet, for some reason, it's disability discrimination. It's okay to discriminate on the basis of disability because Clearborn, right? If we go through the logic, and that's what my piece does in the review, go through the logic of why Tennessee says that they needed this law, it's all bogus. they cite supposed victims of, I think they call it gender medicine, who were not victims of gender medicine. They were victims of, among other things, a circumcision gone wrong and a bunch of idiot doctors convincing a kid's parents that they should do a surprise sex change on the kid as an infant. Guess what? That kid's name is David Reimer. That same thing can happen today under SB 1 in Tennessee. Why? Because while screwing over trans people, it also screws over intersex kids. Their doctors and their parents can make whatever decisions they want, no matter how permanent they want, without any input from the kid, and there's no liability. It carved out an exception to a law that Tennessee used to have that protected everyone, that prohibited genital mutilation on minors. That was a good law. SB 1 undoes that. Right? And for what reason does SB 1 do this? Well, unfortunately, if you fast forward to Justice Barrett's concurrence, apparently, and this should, again, leave you gobsmacked if you care about the Bill of Rights and the 14th Amendment, this is okay until trans people as a community can show decades upon decades upon decades of de jure discrimination. So the Supreme Court is telling us, one, it's okay to continue to mutilate equal protection. Two, maybe someday in the future we might fix it so long as this isolated minority group endures decade upon decade upon decade of de jure discrimination. But before that happens, we're just going to treat this as rational basis. We're not even going to sort of, pull back the curtain to see if any of the rationales that Tennessee provided to support this law even make sense. Where is this going to go from here? I think, sort of much like my co-presenters, scurmity is a bad result. It's a bad result for trans people. It's a bad result for minors and parents who want to make important medical decisions on their own with the guidance of doctors and even with respect to their faith. But this is yet another case where the court sort of just invites more questions. And the questions that it's inviting are horrific, especially for these turbulent times, right? How bad does the discrimination have to get before equal protection protects someone, right? If in the case of trans people, because there is no long history of de jure discrimination, that was a question Justice Barrett asked at oral argument, there just isn't one because we didn't used to treat trans people like this. This is brand new. If we have a society that invents new kinds of bias, even if it's horrifically virulent and violent, as we've seen in some examples, that's not going to be enough to merit heightened review under equal protection. Again, that's something that should be horrifying. Just because I'll add this back, because there's a lot of pushback and misinformation, I have a lot of footnotes, more footnotes than others, as Tommy pointed out in my piece, because a lot of people just don't know about trans people. They definitely don't know about gender dysphoria. Why? Because we are rare, exceedingly rare. But there is a long history of our medical care. The treatments that trans kids in Tennessee used to get, they're more than 150 years old. They are more well established by medical science than the vast majority of other interventions that you could have medically. One of the only things that's older is cataract surgery, because apparently the ancients used to do that, which is horrifying, but I'm glad that they were able to do that. But that's how ancient these medical interventions are. They get updated with time as, anesthesia, that was a boon for everyone. Isolating hormones outside the body, exogenous hormones. We weren't able to do that until the 1920s or 1930s. You don't want to know how we gave people hormones before then. It was horrifying and bad. But this is old medicine. Going back to what should concern most of us, because most of you aren't trans, most of your kids aren't trans. It's probably for the better right now because it's not a good time in the US to be trans. Be concerned of how the court is trying to continue to defile equal protection in a bizarre way. Remember, we all did that huge Civil War thing, and there was lots of blood and lots of death and lots of horror. The 14th Amendment and the rest of the Reconstruction Amendments were supposed to bring us together so we never had to go through that again. Instead, the court repeatedly over time, and I talk about this in another forthcoming article also about scurmity in the Journal of Health Law and Policy over at SLU. That one's like 4 times as long as this one, bless them. This is a continual sort of receding away from the promise and the guarantee of what equal protection is. And the court is so unaware of our history, they didn't even think about Francis Thompson. Francis Thompson was gang raped by a marauding white supremacist mob led by the Attorney General of Tennessee. How many people who push back against police violence today have lost a federal case trying to prove that being raped by a police officer violates someone's constitutional rights? A lot of people have. when we forget our history, we forget the brave souls who stepped up and contributed to what made our nation great and how we came back from some of the worst horrors imaginable, we really do an injustice to our predecessors who, again, were not idiots. They were pretty smart and they knew what they were doing when they tried to fix things. And it also bodes, poorly going forward. Though you might not be targeted by scrimity today, it could easily be used against you tomorrow. And even though you might not realize you're part of a minority group today, that doesn't much matter. It was very different being trans even 20 years ago. It's far more fraught today, so keep that in mind.
All right, thanks so much. I want to remind the online audience, as we prepare to get to the questions from the audience later on, you can submit questions under the comments if you're watching on Facebook or YouTube, or you can comment on X using the hashtag CatoSCOTUS, CatoSCOTUS. I want to start by asking the panelists, do you have any questions or reactions to anything a co-panelist said?
I actually have a question for Vera, if I may.
Yes.
So Vera identified a limited scope to the holding, limited to sexual material. And I was actually wondering what effect, if any, you think there might be relative to the medium of delivery. If you think there's any place that this decision could go. We're talking about the technology that's used to deliver particular material to minors.
Meaning, do I see a distinction? Do I think this is limited to the internet versus in-person distribution of materials?
Yeah, because what I'm thinking about from the perspective of the dichotomy between adults and children, right? And so some forms of media, it would be a clear infringement of an adult's right to receive information if there were certain regulations that were put between them and information that they wanted to gather through, pick a delivery mechanism, right? But if the delivery mechanism has either demonstrated or inferred potential for injuring children, how would this decision map onto attempts to potentially require an age, proof of age before accessing a particular type of media?
That's interesting, and I think that to me, I don't think that it would or should, and I do think this is an argument that the government is going to be making in the social media, parental consent, and age verification contexts, but I don't think it quite lands because the First Amendment doesn't actually distinguish by medium whether a minor or an adult has a right to access that particular medium. And if anything, in the past, prior to this opinion, I would have confidently said that distinction shouldn't matter at all, and that even the distinction between minors' rights and adults' rights in this particular context shouldn't matter. But I do think I still have a large amount of case law on my side to say that basically every time there's been a new medium, whether that was like the dime store novels of, hundreds of years ago, to comic books, to music, to drive-in movies, to video games, to then the internet, there have been, I won't quite call them moral panics, but essentially fears by people in society that the new medium, and in particular the new content, or maybe even the way that the medium allows people to interact with each other, create new dangers, often couched in terms of dangers for children, but I think probably what people in government and legislators generally are worried about is dangers for everyone. And there have been, therefore, attempts to regulate access to those mediums, particularly for kids. And historically, those have all been shut down. The Supreme Court has said you don't get to regulate drive-in movies because you're worried about nudity. You don't get to regulate video games because you're worried about violence. All of that is protected even when it comes to kids. So I expect that's how the medium-based question will be resolved.
Other questions from one panelist to another?
I liked your piece. It was really good.
Oh, we like that. We like compliments are also acceptable. Ezra, I had a question for you I wanted you to discuss. You mentioned the tiers of scrutiny and rational basis review. So this is kind of the bane of our existence here at Cato. Comes up a lot in equal protection, but also in economic liberty challenges under either the Due Process Clause or the Privileges or Immunities Clause. Basically, it's the lowest level of review where any hypothetical justification a court can make up, even if it's not the one presented by the litigants defending the law, they have to uphold it. So the court has created this whole complicated structure of tiers of scrutiny for equal protection, ranging from strict scrutiny for racial distinctions to intermediate to sex distinctions to rational basis for, as you mentioned, disability and distinctions. In your perfect world, would essentially every group-based distinction just be strict scrutiny? Do you think that's the way to most faithfully execute the 14th Amendment as it was originally understood, equal protection?
Yes, specifying as to natural persons. Corporate entities, no. There are more problems when you put labels onto individual people. And if you're serious, like methodological originalists, I think we can all agree that like the 14th Amendment was about like living, breathing human beings, right? So I think that would be appropriate. And the reason why I think that's necessary is if you're not familiar with sort of like the mid-20th century switch on equal protection, the tiers of scrutiny were ostensibly established as a way to react to the court's failure in cases like Bradville v. Illinois, which is about sex discrimination, and Plessy v. Ferguson, which was race and sex discrimination, but we often only remember it as race discrimination, where they basically applied what we would today call rational basis. So in a way to like, it's kind of like a bad version of reparations from the court. In recognition that they really screwed up Plessy and Bradwell, they now treat sex and race as special and everything else that is not sex and race as not special, which makes no analytic sense. It's morally dubious at best. And it creates this hellscape where you have someone like Justice Barrett, who's a really intelligent jurist and a really intelligent scholar, saying, well, as I've seen when we look at our doctrine over time, it has to be really, really bad for decades and decades before we elevate anyone. Well, I think most of us in the room can say, whether you've experienced being at the bottom of the pole or not in your own life, no one should have to endure great evil for decades, even lifetimes, before the court takes a hard look at what's going wrong. And the other sort of more practical problem is if you've got judges who are set in their ways because they've only ever seen something a certain way with respect to scrutiny, how many of those people have to die off before the court is willing to move the ball forward? And should the court even be able to do that? I don't think that they have the power under Article 3 to do that, because equal protection applies to the judiciary too. They are not allowed to unequally enforce laws. We got that from Shelley v. Kramer, right? That applies to the US Supreme Court. Why they're telling us today race is always treated a certain way unless we want to use race in the bad way, in which case we're going to allow that to happen anyways. It's not analytically honest. It's not good. It doesn't create the sort of society that we want. And it leads to this weird, bad match where when one group is trying to rise up and say like, hey, we want full equal protection too, you're ostensibly pitted against other groups that historically had to fight too. That is a fight over nothing, and it is a fight that destroys us. It doesn't move anything forward. It would also just be easier. Has anyone in here ever tried to teach equal protection to students? I decided when I was going to teach it, I was just going to say the court is bigoted and has been bigoted from the beginning, and the bigotry shifts over time. Only because I was a little bit lazy, but also I wanted to be honest with the students, because there's no other way to make sense of all of these cases over the entire existence of the 14th Amendment, right? Other than be like, yeah, so Korematsu was a dark time. Strict scrutiny did no one any good in Korematsu, right? And you go through all of these cases. Think about what it would be differently. What would it mean to give every possible classification of natural persons strict scrutiny? I think as a devout Catholic, that's just recognizing the inherent dignity of all persons. And if the government really wants to single out a group for any reason, they better have a really darn good reason that's true, not just fictive. And the courts, as some of the other people were saying in the earlier panel, the court shouldn't be in a position to play co-counsel for the government to try to justify it. That's screwed up. That goes against everything that the Bill of Rights was supposed to be.
Thanks.
Can I ask a follow-up to that?
Yeah.
Yeah, so how would you handle classifications based on age? And in particular, what I'm thinking of is I've been thinking a lot about compulsory education laws, and there's no way that you could ever do that to an adult. And so how would you imagine implementing strict scrutiny to all age groups, or would you draw the line somewhere?
So I'm probably in a dicey personal position right now where I think we should be able to mandate all Americans reading books more. But setting aside that knee-jerk response, I think what we have to remember is strict scrutiny, even if we think the court is applying it in the right way, a non-bigoted way, a justified way, a way that puts the government under a spotlight and they do a really, really hard look without deference to what the government's saying, right? There might be instances where compulsory adult education might make sense. Who hasn't gone through traffic school to not get a point on their license because they don't want their insurance to go up? There might be little carve-outs or compulsory education like most of us lawyers have to undergo, at least in New York. I know there's a few states that don't have to do that. There are little specific contexts where it can be justified and it can survive strict scrutiny. I don't know what we do with public education. I'd probably call you up.
I was kind of hoping you were going to go the other direction and the compulsory would go away instead of expanding it to adults, but.
Okay, I'm deeply worried that Americans do not read enough and do not know enough. And again, that gets me in a personal place, but.
So Cindy, you're thinking of a kid basically saying, treat us more like an adult. You're biased against us. You're forcing us, you're taking away our freedoms just because we're kids.
We're little.
Yeah.
You don't want us out.
Interesting.
And that is a risk and that is a concern, but I think you can still deal with it through a strict scrutiny framework without giving the government total deference on whatever bizarre position it wants to take.
Because you'd have to have the least restrictive means, right? And that's going to be.
And I'd rather the government have to work hard if they're going to force people to do something.
Yeah.
Just like I think that, the school district's problem was it's a diverse school district. That's their job to figure out how to navigate it, make it work.
So this leads into actually the next question I had for Vera on the tiers of scrutiny, on strict scrutiny. I feel like there's a little bit of a theme of the court grappling with both the tiers of scrutiny and also how strict really is, both in the case you talked about, Free Speech Coalition, and also in the TikTok case, which I'll throw into the discussion if you want to touch on that as well. And what the court did in both of those cases is they only applied intermediate scrutiny. And in both, there was either in the majority or in at least one concurrence, there was a concern if we applied strict scrutiny and upheld it, we'd be watering down strict scrutiny, and we can't do that. And I sort of am skeptical of that or concerned that, I guess it's a question of what's the better way to lose if you are concerned about free speech rights? By them only applying intermediate and upholding it, or by them applying strict scrutiny and saying it's upheld under strict scrutiny? So what are your thoughts about that? Should strict scrutiny just stay strict in theory, fatal in fact? Or should we apply strict scrutiny more commonly, but let the government occasionally win under it so courts are more comfortable applying it more broadly?
I agree with your overall take, and I think that it reflects also the extent to which I think these opinions were quite outcome-driven. It really seemed to me at the argument for Free Speech Coalition that the question was, it seemed to me that the court, most of the justices were interested in saying these kinds of laws are okay, and the path to how to get there was the bigger disagreement. And my opinion is that there's not a principled way to apply the wrong level of scrutiny, and that's what's really concerning to me. So I'd much rather say that sometimes strict scrutiny is satisfied. Typically it's not. Very rarely is it satisfied. But I do think that there's, the least restrictive means. That's right. If you have an interest that you have to further, and there must be a way to further that interest, there's some answer that suffices at some point. It's very rare that the government chooses the right answer, and I think I agree with Ezra that it's incredibly important to hold the government to account in having to choose the right answer. But I think it's actually in some ways dangerous to say, well, you'll never choose the right answer. So why even try to choose the most restrictive means? Because there's also the fact that these laws are in place sometimes until they get struck down, including by the Supreme Court. So there's also just the issue of what are the incentives for legislators. And I think if they know that they're going to be held to the highest possible standard, but that maybe sometimes they'll succeed under that standard, that's really not the worst outcome.
Mm-hmm. Yeah, it almost feels like maybe we're forming a bit of consensus that strict scrutiny is kind of a misnomer, or it should be the standard, and that to some extent calling it strict scrutiny is comparing it to all the other lower ones, which you almost, I don't know, you start the standard down a little bit if you act like intermediate scrutiny is maybe the middle ground or the normal thing and strict is unusual. Cindy, I had a question for you about the most common objection I hear to the Mahmoud case, or the most common concern, is that it's just not going to be feasible going forward to have so many potential opt-outs or so much fighting about opt-outs. So I guess I'm wondering, what do you see in terms of, are the floodgates going to open up now? How are courts going to draw lines between valid and invalid claims? Or is it just going to be sort of chaos across the board? More conservative judges are going to give more opt-outs than more liberal judges?
So I would suggest two things. What seems clear to me from Mahmoud is if the objection is on free exercise grounds, then they are going to need to find a way to handle the objections. There are already widespread, nearly ubiquitous opt-outs for sex education, and that, at least in the modern time, has not opened the floodgates. But I think my third response to that would be, school boards are elected bodies, right? They're supposed to be responsive to their constituents, and if the decisions that you're making are causing such outrage among your constituents, then maybe you should stop and listen to them and figure out a way, as you were saying, figure out a way forward that's going to work for, maybe not everybody, but close to everybody. And if you're left with a small number of people that you can't satisfy, then you have to let them have a way out.
And I appreciate what you mentioned about sort of the distinction between a religious objection versus maybe a non-religious but still conscience-based objection. I think that was one of our concerns here at Cato. One of the reasons we didn't weigh in was, well, we're not so crazy about sort of saying you get an opt-out, but only if it's religious-based.
Yeah, and I'm actually a little bit disturbed by that, not because there's a religious opt-out. I think that part of it is good. But then what do you do if somebody has really a deep-seated and valid objection? They just don't happen to have a religion. Right? Shouldn't they have some means of going forward without that being the only path to satisfying what for them is very necessary? But again, I would suggest possibly that free speech might get you there, at least in the schooling arena, because obviously education is delivered through speech, and so
certainly,
potentially, there's something there.
We had a conference on parental rights at Cato earlier this year, and it was brought up that we really still don't know much of the contours of parental rights in and of themselves outside of religious rights, other than you have the right to send your child to a private school if you want to. But then once you send them to a public school, to what extent do you have inherent opt-out rights just as a parent? And I think there's a pending cert petition right now on that topic, if I'm not mistaken, about a parent wanting to have the right to be more involved in the public schooling of their child.
Well, it's interesting because this comes up a lot in the schooling arena, because right now we have a whole bunch of bricks in the wall, but we don't quite know yet what the wall looks like. And there are cases that are coming through in New England where they have where the states are required to pay for schooling for students if there's not a public school available, right? And so we had the Carson v. Macon case in which the holding was that you can't exclude a religious school because it does religious things, right? But then there's the question of if the government wants to only have schools that teach from a particular viewpoint, how does that run now into Mahmoud, right? Because if the parents want to opt out of that viewpoint, particularly if the reason for opting out is free exercise, so it's squarely within this case, but the only school that's consistent with the religious perspective is a school that the state doesn't want to fund, but the state simultaneously has a duty under its own state law to fund the public education. How then do you square that circle? And I suspect that's probably where we're going next.
Yeah, that's fascinating. We'll go to questions. I had one more for Ezra. I mostly just wanted to underline something you said that I think is underappreciated about Skrmetti, that as I read the opinion, this law was about was targeted at minors specifically.
Yes.
But imagine a hypothetical law that's banning the same treatments for adults, for people over 18 who normally you would say have the right to make their own medical decisions. As I read the decision, its reasoning would have upheld even that law. Is that how you read it? That really age didn't come into play here?
Yeah, so the court doesn't use the language, but it's heavily implied throughout that like trans people's very existence is a moral panic that is also contagious, and which is you can't make people trans. You literally cannot change someone's innermost sense of sex. More than 150 years of peer-reviewed medicine on that. Can't change anyone's. Well settled. Not up for debate from anyone seriously, right? But yeah, there is no limiting principle here. So unlike it sounds like the cases that my colleagues have been talking about, where it's more openly stated that maybe there are special rules just for minors and special rules just for parents trying to rear their kids, Skrmetti has no limiting principle because of age. That's concerning. Again, I'm not a fan of our current president or our current head of HHS. They both do weird medical things to their bodies that I would never do. And I don't think they should be dictating to me what I should do with my body, let alone I don't have kids yet, but if I did, I really wouldn't want them dictating what my kids should do. Right? We should be concerned about that. If you're concerned about big government, Skrmetti is different. If we talk about it just from a health power perspective, we have not had a health power case from our Supreme Court ever, where the government is allowed to choose treatment protocol for every single patient under a class, ever. What treatment protocol are they demanding in Skrmetti? They call it the wait and see approach. That means have no medical interventions. Something that has been debunked for more than a century as being ineffective. It also drives up the cost of healthcare for everyone, by the way, because if you don't properly treat someone with gender dysphoria, they try to treat everything but gender dysphoria, which is wildly expensive, right? It's also torturing someone. I used to experience gender dysphoria. I got healthcare. I was crafty and good at getting it as a teenager, but most people aren't. It goes away if you get treatment. This is like having someone endure something that is hell on earth just because people who don't have the condition don't want it. In my paper, I talk about, think about the absurdity. Open heart surgery, wildly dangerous. You probably shouldn't have open heart surgery unless you really need it, right? But if you really need it, open heart surgery, good. This is like people who don't need open heart surgery saying, that scares me and it's dangerous, therefore no one can have it. That doesn't make sense. That's not how medicine works. It's not how it should work. It most definitely is not something that our government has the power to do. Why? Government of limited powers, they don't have the power to intervene in medical decisions like this. That's why we have the Constitution. That's why days like today are important. We need to not forget that stuff.
Let's open the conversation up to the audience. Please remember to state your name, your affiliation, and keep it a short, succinct question.
All right, Carl Polzer, Center on Capital and Social Equity. I study inequality. And my question's about the inequality between kids and parents in regard to, if you're looking at the government's attempt to control exposure of kids to obscenity or ability of kids to change their bodies, the parents are, how does the parents' point of view get worked into the law, and how should it? Because on the one hand, they have a duty to raise the child. There's a sort of a trust issue. It's an element. On the other hand, there's the government has a duty also to protect the child from a bad parent. It's a very complicated issue. So how does the law treat the parent in these things? Does that make any sense?
Sounds like that could be for anybody. Anybody want to try it?
Well, I have a very short and probably not very helpful answer, which is that in response, in preparation for this, Skrmetti made me wonder, what is there out there in terms of case law in which a parent wanted a particular type of medical treatment for their child, and I couldn't find anything. There's a little bit of case law out there in which parents asked to, or parents wanted to withdraw from medical care where the state wanted to intervene, right? But I didn't see anything going the other direction.
So I can speak a little bit more to that because I read a lot. There are some health power cases, including a handful that went up to the Supreme Court, and most of them try to draw a line between like stigmatized at the time care and non-stigmatized care. So it's a lot of sexual health stuff. So like if a little girl is raped by a family member, maybe you don't want the family member who raped her to have a say on can she go to an OBGYN, right? Like that's common sense, right? There are some other cases, none of which went up to the Supreme Court. A few of them went up to federal circuit courts. They're basically Munchausen by proxy cases. I think some of you guys are nodding because you know what that is. So it's a condition where a parent sort of makes up for attention that their kid has something that requires serious medical intervention and aggressively seeks out intervention to satisfy their own psychological problems, right? So there are those very specific cases. I think what we need to think about, though, is the one thing about Scrimity is we don't see that conflict at all. That's not present here. Scrimity was parents who took their kids to good doctors who worked through it, including some of them with religious communities. And I say that because I'm Roman Catholic. There are religious, deeply devout religious people who are trans, right? They work it through themselves in their immediate communities with their doctors, with their kids' input. They're not forcing the kid to do anything. And they found a decision that made sense for that kid and that family. And most of the time, and I've counseled families like this, the choice is to not get treatment because the kid's not ready, the parents aren't ready, or there's something else that's going on with the kid that they want to deal with first. And I'm not going to second guess parents because those must be horrifying decisions to have to make, right? The one thing I can say is that the very last person that should be in the room making that decision is the government. Government should have no say. You want to make sure that drugs aren't contaminated. You want to make sure that medical doctors get the good enough training, that they have their licensure, that people aren't divulging medical confidences. Yeah, that's a place for government. But making those really, really difficult decisions, that's not a place for government. That, I think, if nothing else, that's supposed to be what the Ninth Amendment gave us all to retain, right?
Vera, did you want to add anything? Or?
I can just add quickly that from the First Amendment context, I think the most relevant Supreme Court case is a case called Brown versus Entertainment Merchants Association, which was a challenge to a law that prohibited very violent video games from being sold to minors. And the Supreme Court basically framed it not simply as a prohibition, but as a parental consent law, because they said if a parent wants their kid to have this video game, they'll just buy the video game for the kid, even though the law at issue was in fact a prohibition on selling to minors. And the court basically says we can see two different interests here from the government. The first is that violence is so bad that we want to restrict kids from being able to see it. If that's the case, then allowing parents to overcome that prohibition doesn't make sense, because if it's so bad, they shouldn't get the video games at all. And the other interest that we can see is parental authority. I think this is maybe more relevant to the question. The court basically says that doesn't work because what this law is imposing is actually a governmental authority, a governmental veto, not a parental one. Parents can do whatever they want with their kids. The government doesn't get to require them to do one thing or another.
Got it. I saw Roger Plon back there.
My question is for Ezra. We agree that we don't want government involved in these issues, but government will be involved in these issues. I quite agree that the Tennessee statute and this opinion leave a great deal to be desired. We are seeing in the European context, the medical establishment has moved in a very different direction than ours has so far moved. But we are also seeing litigation, especially from adolescents who've been brutalized by medical treatment. So the government will get involved ex post, if not earlier. What do you suggest by way of addressing this when it does come to the litigation that we are already seeing?
Yeah, I think that's a good question. Just to clarify, Skrmity actually misrepresents the European position. The European position is you gotta fund medical care. Remember, they all have universal health care, unlike us. So the government has much better statistics for almost all of their patients, and they can do longitudinal studies, right? But Hilary Cass, who wrote the Cass report, which was discussed a lot at oral argument and is name dropped at the beginning of Robert's majority opinion, did not suggest that they outlaw care. She specifically said there is a rare group of children who will require these interventions, and no matter what, you cannot block it. This is a case-by-case thing. The government needs to do a better job in a lot of ways to collect information, to fund appropriate health care, and to not put a thumb on the scale of making important decisions. With respect to people who come forward, a lot of them call themselves detransitioners. I talk about this in my piece a bit. All of the detransitioner briefs in Skrmity, all of the detransitioners admit they repeatedly lied to themselves, to their parents, and to their medical providers to get a diagnosis and get treatment they did not need. Some of them said that they only came to the conclusion they weren't trans after doing repeated like rounds of acid and other things. I would say, again, not being a parent, not judging anyone, there's something going on with those kids. We as a society failed them in ways. I think that that's a legitimate problem. Assuming everything that the detransitioners say is actually true, and they did not actually lie repeatedly, but that's what they themselves said they did, that's what malpractice laws are for. That's how we go after doctors that do dangerous, bad things. Like the doctor who maimed David Reimer, that should have been a malpractice suit, because guess what? You shouldn't use an electric cauterizer thing to perform a circumcision. Everyone knew that, but he did it anyways. I think a lot of people would be better protected if, and I realize this gets iffy with children, but some of these children are teenagers. I did some really dumb things when I was a teenager. I never lied to a doctor to get a treatment I didn't need. And I can tell you as a teenager who got these treatments, and it was much harder to get then, I read everything I could. If you're noticing a trend, I read a lot. I read everything I could about this treatment, about the history of the treatment. I read bone studies about monkeys because I wanted to make sure that my bones wouldn't crumble, because that's what I was told at the time. Learned a lot of things about what testosterone and estrogen do to bones. Payoff on that is testosterone protects bones in ways estrogen doesn't, so that was kind of cool, but like monkey studies. Not every kid should do that. Some of us become professors, right? And that's sort of what we do, but miseducation and myths and things, I'm not talking smack on religion, because I understand that, but just ignorance isn't gonna get us through this. We need to be able to trust even some minors to make really big decisions. Again, I don't have kids, but I know that sometimes parents are in a position, a very young child, 4 or 5 years old, has reproductive cancer, and they have to decide whether they're gonna undergo surgery that will result in permanent sterilization. Doesn't matter how smart a 5-year-old is, they can't contemplate what that means, right? But a decision has to be made because it's cancer. When we get to teenagers, though, we very often, and there is case law on this, you consult with the teen, because they have more of a brain and they're still developing, but they have some conception of bodily autonomy and some amount of choice. I think we shouldn't be treating childhood as like an off-on switch. If anything, our brains are still developing up through 26. And Jesus, I did some really dumb things in my early 20s, so I now see it now in my late 30s. But I think we can bring nuance to these issues, right? And I think my colleague over here said something, there's different about sort of like books available to very little children as opposed to high school children, as opposed to college students or the law students that I teach, though often some of them are children too still. I think we can have a better conception of sort of personal responsibility, both with respect to parents, but as well as to children. We need to cultivate them to be able to make these hard decisions, because one day they'll have to make these hard decisions with permanent consequences, and we should be cultivating that, not having the nanny state sort of decree from on high and often from a place of ignorance what people should do.
All right. More questions in the audience? I see one down here in the front row.
Stanley Kober, I'm a former Cato person. My question concerns habeas corpus. The Constitution provides that habeas corpus can be suspended in the event of invasion. And you see the administration arguing that we have been invaded. This raises the question of whether the courts can say no. that we have not been invaded. The administration is arguing this is not a justiciable question, that the executive has the authority in this case. If the courts agree, and the courts recently have been very accommodating to various administrations on national security issues, we don't have habeas corpus. And this would affect the Bill of Rights, no?
It would. I mean, that's not directly on any of the cases we've been talking about, so I don't know if any of the panelists have a reaction to it, but it certainly is, as you said, relevant. Yeah, you want to jump in?
So I love the Constitution, and we should never forget that it all applies simultaneously. So yeah, you do have to be aware of that stuff. The judiciary needs to grow up and remember that they are the third branch of government, and sometimes it is their absolute responsibility to say no. Yes, for decades they've allowed Article 2 to expand way beyond its limits. Congress is deflated way below what Article 1 promised them to do. They're incompetent and have not functioned in my life since I have been a conscious human being, and that's awful. The judiciary needs to rise up to an occasion, and the justices in particular, you have life tenure in the highest echelons of our profession. They need to learn how to say no.
I like that. More. I see another one up here in the front row.
Thank you for a very interesting panel discussion. My name is Stephen Keat. I'm speaking as a private citizen. Ezra Young touched perhaps best of all of you on what I'm about to ask about. I should also add I'm not a lawyer. In the real world, governments do discriminate against people on age. Okay, so, you know, when I was a young boy in New Jersey, I could drink at age 18, not earlier. And when I went to college in Pennsylvania, where it was 21, at that point I could not drink. It was a minor thing, but it's an example of a whole range of things. So how should government be dealing with youths as opposed to adults? You know, we have some things we say age 18, you're allowed this. You know, it used to be age 21, you were allowed things. Ezra was speaking about age 26 for mental abilities. So, you know, how legally and constitutionally is government allowed to treat us differently because of our age? And perhaps how should it be treating us differently because of our age? Thank you.
Yeah. Could I ask maybe Vera to jump in on that? Because you haven't gotten a question in a bit, if you have.
I mean, I will say, I think it's interesting that it really does seem like this was the Supreme Court's kid docket or something this year, just thinking about the overlap of the cases that we're talking about. I think I'm an attorney for the ACLU. It probably won't surprise you to hear that I think kids largely have full civil liberties, and I think that's quite important. They're people. And also they need to, and I will also say I mainly think about the First Amendment, so there may well be things that I'm missing and there are reasonable restrictions that should apply differently to kids, but at least in the First Amendment realm, I think that it's quite limiting to restrict what kids can think about and talk about and how they can engage with people they disagree with, because if we expect them to be contributing members to society as adults, they have to at some point learn how to think for themselves, how to debate, how to push back and respond to people they disagree with. So with the limitations for the First Amendment, I will say I personally, notwithstanding the fact that I am quite pregnant and already have a kid, think that kids should have the full scope of First Amendment rights, even though, as I said, the Supreme Court already disagrees with me.
Cindy, I'm reminded of a debate we had again at our educational policy conference about, you know, when we're talking about school rights, some people objected to the term parental rights because they thought we should focus more on the kids, not the parents. It so often frames, including in Mahmoud, it was the parents objecting, not the kids objecting. So do you have thoughts about what if a child says,
Yes.
I don't want to read this?
I actually have a paper on this.
Yeah.
You're all welcome to go read on SSRN. But yes, so age obviously is a continuum, right? So anytime you make an age distinction and you drop a pin in the ground, there's going to be a certain level of arbitrariness. That said, Western civilization has recognized the ages of 18 and 21 as being sort of breakpoints for age of discretion, and so I don't mean to challenge that because I don't necessarily have a problem with those breakpoints. But it is true that the court has been pretty clear on the rare occasions that it's addressed child's constitutional rights, that the Constitution applies in full to children. And the only case that really comes to mind, which is a weird aberration, is Prince v. Massachusetts. I don't understand that case. This was whether a child could be handing out or selling leaflets out on the street. And so that's sort of an oddity, but the fact that it's an oddity almost weighs stronger on the other side. That said, from a practical standpoint, it's not meaningful to say, that a 4-year-old is exercising some sort of liberty interest, right? Their parents exercise that for them, and over time, it shifts more to the children and away from the parents. So I think, it makes sense when the kids are little, that the right is in the hands of the parents. And the right of the parents to raise their children in a particular way is a distinct right from the right of the children. So you've got two things going on, right? You have the parents' rights that are held by the parents now and forever, at least until they lose the ability to exercise that right. But there's also sort of the parents, in a sense, holding the children's right in trust, right, to protect the child from the state. When the state steps in and says, I'm going to do something to this kid, and the kid doesn't have the ability to protect themselves, and so the parents do it for them.
All right, let's see, maybe one more lightning round question here, the bow tie in the middle there. One of you, yes, who's got it? All right.
This is for,
wait.
Thank you. Ms. Crawford.
Could you give your name and if?
David Frost, I'm sorry, and I actually live up in the People's Republic of Montgomery, as we fondly call it. Certainly, the Mahmoud case was an easier one in the sense that it had that sexual.
Could you hold the mic closer to your mouth?
Sorry, it had that sexual component. What about other things, and how would you outline the interest of the state in educating people to be good citizens, and the parents' rights to say, I don't know, I object to algebra, to our form of government, to almost anything else?
Okay, so that was a very short question, but you actually have many layers built into that. So I'm going to try to unpack this just a little bit. There's actually case law, and actually I think it's cited in my paper, where the Ninth Circuit says there's not really a distinction for sex, right? Like we're sort of accustomed to that because it's built into the opt-out system that most states have. But as a legal matter, it's not really a distinction. The second part of your question goes to whether you're talking about an opt-out or whether you're talking about controlling curriculum, right? Because the state, and especially governments at a local level, nearly always win on curriculum questions. So if the objection of the parent is, I want the curriculum to change to meet my demands, most of the time, like by most I mean like the vast, vast majority of the time, that's going to be a losing argument. So then you get to the question of opt-outs, and what we know, or we can be reasonably certain, is if the request to opt out is based on a religious objection, that objection will probably prevail. Now, you could spin up a hypothetical in which the objection seems patently absurd, and maybe somebody could bring that claim, like my religion prohibits the practicing of algebra. Well, okay, I suppose that's possible, but it's not a particularly likely scenario. So.
All right, thank you. We're out of time, so please join me in thanking our panelists.
Thank you.
We're going to take another 15-minute break, and then we'll have our Looking Ahead panel to the next Supreme Court term, moderated by our own Dan Greenberg.
Our previous panels have analyzed the past. In this panel, we look at the future. What do we think the Supreme Court will be doing in its next term? What opinions will it issue? And I'm joined by two of my favorite people. I'm joined by Mike Fox, who's another attorney here at Cato. Mike brings with him experience both as a former congressional staffer and as a public defender, and I learned something about our criminal justice system every time I talk to Mike. And I'm also joined by John Vecchione, who is Senior Litigation Counsel for the New Civil Liberties Alliance. John has a long and successful career as a public interest attorney, and he's also one of my heroes because he was counsel of record for one of the victorious parties in Loper-Bright versus Raimondo. That's the decision that overturned the Chevron doctrine. And I hope that if there's someone in the audience who hasn't met John, I hope you'll come up to him after this and shake his hand and say, you are responsible for eliminating a doctrine that is half incomprehensible and half obviously wrong. And I want to thank you for the part that you played in overturning that doctrine and returning interpretive authority to judges and away from bureaucrats. And you've eliminated a gigantic burden of thousands of hours, really perhaps millions of hours that has been borne by lawyers and law students. So my name is Dan Greenberg, and I have the privilege as a member of Cato's staff, one of the attorneys here, to ask these two to tell us a little bit about what they see coming up in the next year. I have many questions for the two of you about these matters, and I hope to supplement them with questions from the audience, provided we get through the various matters I have on my to-do list here. I think the preferred way to take questions is for listeners to submit questions electronically. When I'm informed of those questions by this device I have here, I'll throw those questions into the mix of the two of you, and I hope to be able to take questions from the audience as well. Now, John, I want to begin by asking you to talk a little bit about tariffs. The President's use of the International Emergency Economic Powers Act to set tariff policy has been a little bit controversial. Recently, as you know, the Federal Circuit Court of Appeals issued a 7-4 decision explaining that IEPA allows the President, by the terms of the statute, to regulate the importation of foreign goods, but that as a matter of statutory interpretation, this does not cover the presidential power to to encompass, to issue broad worldwide tariffs on just about every country. Somewhat relatedly, that decision also suggests that the Trump tariff scheme can't be reconciled with the major questions doctrine. So let's talk about the future. I think it's almost inescapable that this issue is going to be handled by the Supreme Court sooner rather than later. Would you agree with that?
Not only would I agree, first of all, I want to thank Cato for having me here among the dwindling group of people who still think that it's unconstitutional to criminalize hate speech. So I'm very happy to be in this with this audience today. But so when Calvin Trillin used to say at The Nation that it takes a tough capitalist to run a commie magazine. And it takes a harsh taskmaster to run a libertarian Supreme Court review. So I had to put this in about a month and a half ago, and I just want to say what I said there because it's echoed by Dan, which was it's about the tariff case. And I said, not only are these decisions important to the administration, but they also affect nearly every American in the economy in such a massive way that it is virtually impossible for the court to duck the issue. And then I go on about why they have to take it. And before we came here, about a week and a half ago, they took not only Learning Resources, which is the D.C. case, but they also took Voss and combined it with an Oregon case, which is the case out of the Federal Court of Claims brought by some of the states. So they not only have taken one, they've taken three in some ways, but two. They have two real cases going up before them, and they've put it on expedited, they've put it on the fast train. And so the government's going to have to put in its briefs very shortly at the end of September. The folks who won below, I think I'm going to call them the respondents, but the way this got there is a little tricky. But the respondents will have to put it in late October. The amicus briefs for them will be October 24th. They'll get a reply, and they'll argue this in November. And I think it's because it's so important. We may get a decision in early 2026. So it's coming.
Well, I think you'd probably agree that the Trump administration will have to frame the issues of the tariffs a little bit differently than the Federal Circuit Court of Appeals did in order to have a shot at winning in the Supreme Court. Say a little bit about what position the administration will argue in that venue to defend its tariff scheme.
So there's two issues. First of all, there's jurisdiction, whether the jurisdiction is in the federal district courts or in the Court of International Trade. And each case is different there, but otherwise they're the same. And they've said that IEEPA, that's what we call it, is not a tariff statute. It basically gives the president a lot of powers to stop stuff coming into the country. It allows sanctions, lots of things like that, but not impose duties, tariffs, or anything like it. So what has the government done? What the government's done is put in really extraordinary declarations from Rubio, from the head of commerce, from all these people saying that this is absolutely vital to our national security because the president's negotiating all these deals. And their interpretation of IEEPA is okay because it impacts the Article 2 powers of the president having to do with foreign policy and national security. And so the court should really keep hands off and allow this interpretation to go forward because really Congress delegated this to him. And it's a combination. They're going to say it's a combination of both being delegated to by Congress plus his inherent Article 2 powers.
Well, I don't know if you're a betting man or not, but if so, how do you bet? How's this case going to come out? What are the chances that the Supreme Court will accept the administration's argument that these tariffs are legitimate and constitutional?
So we've been having conversations about this over the past few days, and Jonathan Adler wrote a very nice piece for the Wall Street Journal explaining why the government should win. And it bothered me because it was Jonathan Adler, and I respect him greatly. And then Eli Nachmani, in his continuing effort to give me a heart attack, gave me other reasons why that should be so. But I think really the two folks who have really supported the administration from outside the administration is like Jack Goldsmith, but he thinks the president's like Superman and has all the powers. So I'm not too worried about that. I believe, and I'm going to say it here, and you can replay the tape like John McLaughlin used to if I'm wrong, I think it's going to come out 9-0 against the government outside. So that's who I place to win. I place it 7-2 to show, it might be. But I think that John Sauer, he was my co-counsel in Murphy v. Missouri. I have great respect and affection for John, but I think he's in a bad position because below and everywhere else, there's no limiting factor. The government has not come up with a limiting factor argument, and the Supreme Court likes limiting factors. And I think the marching orders, there's no limiting factor. Everyone on earth is apparently taking advantage of the United States and tricking us in our trade relations. Burundi has outsmarted us on trade. So I think, and so any amount of tariff is okay. And if you can't give your lawyer a limiting factor when you go before the Supreme Court, you're in trouble. They want to know about the next case.
Well, assuming you're right, tell us a little bit about what happens if the court finds the tariffs unconstitutional. What's the remedy? How does the court fix things and decide how we get back to an appropriate status quo?
And this is unusual because in Trump v. Casa, which we've talked to if you've seen some of the panels beforehand, they said there were no nationwide injunctions from the district courts. But John Sauer made a very important concession to the Supreme Court at Trump v. Casa. He said that the administration will not only follow the judgments of the Supreme Court, but their opinions. So meaning that he's at least told them that the administration will follow the logic of their opinions. The actual people who are in front of the court are Learning Resources and subsidiary of it, and all they've asked for is that the tariffs don't apply to them, which, it's nice work if you can get it. If you're the only two guys in the country who don't have play, I'd go into every business. And then also Voss has asked, they say, look, if CIT does have jurisdiction, that's the only court for this, so it should apply to everyone. And they're going to try an APA vacatur, I would say. There's no class action filed yet, so those are the three ways you can do it. I think what the court will then do what the administration will then do is look at the other tariff statutes, and this is the real rub about this whole thing. They're using IEPA in this unprecedented manner, and John Sauer would differ. He'd say, no, it's precedented. Nixon did this, but I give that short shrift. But there's lots of tariff statutes. There's tons of them that give him power to do things, and he's not using those. I think the court will like that argument, too. They like when Congress spells something out, and then the president follows what they spelled out.
Well, Mike, let me ask you about a different upcoming case called Case versus Montana. I look at SCOTUS blog. I'm struck by the fact that about half the cases that the court has granted cert to in the upcoming term are criminal cases. And a lot of criminal law cases are really about a big question, which is what are the cops or people who work with the cops allowed to do? What sort of discretion, what sort of abilities do they have? We have case law doctrine, of course, that gives some explanation of what cops are allowed to do generally. If they have reasonable suspicion, they're allowed to briefly detain a suspect for investigation. If they have probable cause, they're allowed to detain someone for a much longer period of time and cart them off to jail. And now the court is about to hear Case versus Montana, which rests on a group of law enforcement officers' decision to enter Case's house without a warrant after his ex-girlfriend told the cops that he was apparently considering suicide. And the facts of this case end with Mr. Case being charged with felony assault on one of the cops, and the operative question is whether the evidence of that assault ought to be suppressed that's obtained from the cop's warrantless entry. So, Mike, what can we say about how this case will be decided or about how it ought to be decided?
Yeah, I'd say first, I guess if your name is Case, you're inevitably going to wind up having a case before the Supreme Court. If you look at the Constitution, I opened the text of the Fourth Amendment, it doesn't carve out exceptions, and that's not by accident, right? The framers were very clear. They were sick and tired of living under British writs of assistance or general warrants, and they made it clear that when they wrote our Constitution, they did not want that, right? So the facts of this case are as follows. William Case phoned his girlfriend with a domestic violence, William Case phoned his girlfriend. I guess they had some sort of argument on the phone. and he expressed suicidal tendencies. She then called the police. I understand that Mr. Case in the past had been, mentioned what we'll refer to as blue suicide or suicide by cop. So cops show up. Mind you, they stand outside for 40 minutes. So if this is some type of emergency that really necessitates immediate entry, why in the world are you standing out there for 40 minutes trying to figure out what to do? So they were able to see a holster of a firearm, not even a firearm, just a holster of a firearm. And because they see the holster of the firearm, they force entry into the home, find Mr. Case hiding, I believe, in a closet, ultimately wind up shooting him. Thankfully, he survives, but is charged, as Dan mentioned, with felony assault on a police officer. So he then asked the trial court to suppress the evidence that they found, i.e. the firearm, and the court said no. Case went up to the Montana Supreme Court, which has 7 justices, and in a 4-3 opinion, the court said that the community caretaking function authorizes these type of warrantless intrusions into the home. So now, we want to talk a little bit about how we got here, right? So I mentioned at the beginning that the framers really were intent on not having all of these categorical carve-outs or exceptions. The only thing that was sort of known at the time of the founding was hot pursuit, which is, if officers were in pursuit of someone wanted for a felony, which at common law was a really serious crime. It's not like today where everything's a felony. So there was no emergency aid exception. In a case called Mincy versus Arizona, the court hinted that you can make entry, or officers can make warrantless entry into a home. In Brigham City versus Stewart, they cemented that rule. This case involved officers who responded to a disturbance, and they saw people fighting inside, thought they needed to be restrained. They ultimately made entry. But what's notable about that case is they mentioned an objective reasonableness standard, which to me sounds a lot like probable cause. And here, the Montana government, the Montana Attorney General's office is conceding that they didn't have probable cause, but trying to go on this lesser standard called reasonable suspicion. And going back, reasonable suspicion was created in 1968 in a case called Terry v. Ohio. And as Dan mentioned, the whole purpose of reasonable suspicion and the Terry decision was to allow officers to conduct a quick pat frisk for weapons, things like arrests, full searches, warrants, require this higher standard of probable cause. And I would also note that Terry is wholly inconsistent with the text of the Fourth Amendment. This doctrine of reasonable suspicion was confected completely out of whole cloth by the court. There's no originalist basis, no textualist basis at all. But now you have the Montana government arguing that they needed to make entry without getting a warrant because they're exercising this community caretaking function, responding to an emergency. Meanwhile, they're standing out there for 40 minutes trying to figure out what to do. It seems to me this is a case of, you can't have it both ways. Is it an emergency or it isn't, or is it not? And there's also some other cases that were interesting. The court really makes an effort to protect the home, the sanctity of the home that, the framers understood. Your home is your castle. There was a case, I think in 2018 called Collins versus Virginia, where one of these other exceptions, the automobile exception, came up, and what the court was asked to do is extend the automobile exception into the home. So i.e., let's say you have a car parked in your garage and the officers want to go in and search that car, they were going to argue that they could do that pursuant to the automobile exception, and the Supreme Court said no. This is really a hard case. I don't know what the court's going to do with it. It sort of presents, on the one hand, it's pretty clear that there were some serious, problems going on. Guy who was, suicidal, had made threats to law enforcement in the past. But on the other hand, they were standing out there for 40 minutes. I don't understand why in that time frame they couldn't have, gotten a warrant or done something beyond stand there and try to figure out what to do.
All right. Well, given that we have a number of other cases to cover, I'm going to move on to an entirely different matter. I want to ask John, I want to ask you a little bit more about Trump versus Casa. I think that you'll probably recall that the most important part of Trump versus Casa so far was not really the substance of the decision, of the matter that was being considered, but the unconstitutionality of the nationwide injunction that was issued by a lower court. That case began with an executive order from President Trump that attempted to eliminate or redefine birthright citizenship. And I want to ask you about that. I mean, we all know that according to the Supreme Court now, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. But I want to ask you about an interesting fact, which is the court never even got to the constitutionality of the executive order itself. So what's the future here for birthright citizenship? I mean, I guess we know a little bit of the future because some of the CASA plaintiffs noticed the reasoning in that case about how the plaintiffs could use the class action vehicle, and miraculously a couple of class actions begin to spring up. But tell us a little bit about the future of birthright citizenship at this point.
So it's been remanded. They have class actions. The courts have all either recognized a class action or at least a putative class action, and the states have argued that they need to do the remedy. For them to be completely whole, it has to be nationwide. The injunctions have been automatically put in after it got remanded, and the government has not tried any emergency petitions to the Supreme Court on this issue, which is interesting to me. And as I say in the article, and I'll say here, they've lost everywhere. They've never won anything on the merits. Every single court, and they just had an argument in the First Circuit, and it went terribly for the government. So on this issue, you not only have the Constitution, saying that with very few exceptions, there's birthright citizenship, but then Congress put in a statute just mirroring it. So there's this push to say that if you parents are here illegally, or that's not birthright citizenship. But what I really think is that no matter what happens, it's going to be 9-0 because you can't do this by EO, right? The fact that the president can't just do it by EO, it'd be one thing if Congress says, well, using our Article 14, our Amendment 14 powers, we think this is what it means and we're going to shape it. That might create a question. I don't think it does. And the thing I always tell people is if you want to get a case to the Supreme Court, you've got to have a good brief on why it's an important question, but the main thing is how you sign it. And you have to get out your blue pen, you have to sign big and large, and then underneath it you have to put Solicitor General of the United States, and that's the best way to get it up there. And I think that that's the only way it's going to get up there, and if they lose everywhere, the parties who won can't petition for cert. Only John Sauer can petition for cert. And I think it's going to be interesting if he does. And that's why I said, I don't know if it'll get there this term, because you might want to see how he does on other things.
All right, well, let me just follow up on that. Are you more confident that the tariffs case will have a 9-0 decision? Or are you more confident that Trump versus CASA will have a 9-0 decision?
Birthright citizenship.
Well, let me go back to you, Mike. There's another Fourth Amendment case that's percolating its way through the federal courts, and this one involves the Trump administration's enforcement of immigration law. And this involves a district court that issued an order that prevented federal immigration officers. Well, let me say, the wording of this order is very important. The district court's order prohibited federal immigration officers from relying solely on 4 demographic factors when detaining suspects, except as permitted by law. And those 4 factors are apparent race or ethnicity, speaking in Spanish or speaking in a Spanish-inflected accent, proximity to locations where illegal immigrants are known to gather, and working at, I guess, what you'd call immigrant-associated jobs, such as perhaps landscaping or construction. And the Supreme Court used the emergency docket to stay this order earlier this month. And I want to ask you a tricky question about the Supreme Court's decision. Under current law, as explained by the Supreme Court, under what circumstances is the brief detention of a suspect, based on the fact that the suspect appears to be of Hispanic origin, a constitutional problem?
Yeah, it absolutely is. So last week, the Supreme Court issued a ruling. It was 6-3. It was just granting a stay of the temporary restraining order that was granted by the Central District of California back in July. And, as Dan mentioned, there were 4 factors that the government alleged and that Justice Kavanaugh seems to believe create reasonable suspicion to stop someone on the basis that they're perhaps in the country unlawfully. And those are the presence in a location known for, where people who are here unlawfully would be looking for work. Those are things like tow yards, 7-Elevens, Home Depots, farms, agricultural centers, things like that. Another one is the type of work that they engage in, day labor, farming, things like that. But the even more disturbing ones are the fact that the person appears to be of Latin American or Mexican origin, which is very clearly an immutable characteristic, which is protected by Constitution, or the fact that they either speak Spanish or speak English with a heavy accent. So the government alleged that not one of these on its own is dispositive, but you have more than one, two, maybe three, that's acceptable. And Justice Kavanaugh seems to buy that. That's just absurd, right? And if you look at the facts of the case, there were instances where there were people who appeared to be Caucasian who were engaged in the exact same conduct that the people who appeared to be Latin American were engaged in, and those people weren't stopped. Well, why is that, right? So now what you have is a situation where large swaths of the population don't enjoy the protection that the Fourth Amendment affords them on account of either protected status or immutable characteristics, and that is perhaps the most obvious violation of the Fifth Amendment that I could think of. But it's also important to realize that the court has not yet granted cert on this. I'm assuming it's working its way up through the process. It's got to go back to the district court for application for preliminary injunction. It'll wind up going to the Ninth Circuit, then potentially back to the Supreme Court. But Justice Kavanaugh's decision was deeply disturbing for a number of reasons. I know John discussed briefly some things about injunctions. I know it came up earlier on a panel. One of the case here that sort of establishes Article III standing to bring an injunction is a case called City of Los Angeles versus Lyons. And that case came out of a gentleman named Mr. Lyons, who was the victim of a chokehold on a traffic stop. He offered no resistance, was rendered unconscious by a police officer. He then went into federal court and brought a suit under statute known as Section 1983 seeking damages, but he was also seeking injunctive relief. He wanted to bar the Los Angeles Police Department from using chokeholds on people in the future. And the Supreme Court said that he lacks Article III standing to pursue injunctive relief. He can only pursue damages. And the reason why is his claim was purely speculative because he hadn't established that it would happen to him again, and that it's not an official policy of the LAPD, or it's not something that the LAPD has encouraged officers to do. Now compare that with the facts of Perdomo. There are plaintiffs in this case, or petitioners in this case, who were stopped repeatedly. So the idea that it can't happen to them more than once is insane because it has happened to them more than once. That's the first thing. Second thing that is worth noting is the directive came from Stephen Miller, who is senior staff in the White House, the president's deputy chief of staff. So it's not one rogue agent or two rogue agents or even a rogue supervisor in the Central District of California making these calls. These calls are coming directly from the White House. So I don't for the life of me buy the argument that there's no path to injunctive relief. But even so, if you look at the underlying opinion that Justice Kavanaugh has, it's really, really concerning because it says large swaths of the population are not protected by the Fourth Amendment on account of protected status or mutable characteristics. And then he goes even further and suggests that there are remedies available for damages, right? In other words, if your rights are violated by a federal agent, that you can go into federal court and bring a lawsuit seeking damages. I know there are several lawyers in this room who have done that before and can say that that is emphatically false. There were not one but two cases that were brought to the Supreme Court while Justice Kavanaugh was on the court. One is Egbert v. Boulay, the other is Hernandez v. Mesa, where the court explicitly declined to extend. So there's this case from 1971 called Bivens versus 6 unknown federal agents. And what the court did is they created a narrow implied right of action to sue when your rights are violated by federal officials. That doctrine has been so constrained over the past 55 years that now, unless your name is Webster Bivens, you're not getting into court. And frankly, if Webster Bivens brought a challenge again, I don't know if he's still alive, but if Webster Bivens tried to bring a challenge again, I think there are several justices on the court that would get rid of the doctrine entirely.
Let me press you a little bit about the nature of current law after the Supreme Court lifts this order. Imagine two cases. On the west side of town, a cop sees a person of Hispanic appearance, Hispanic complexion, or whatever, sees this person driving and pulls him over. And on the east side of town, an immigration officer sees a person of Hispanic appearance or complexion walking down the street and pulls him over. Do these two cases, are they identical? Are they identically constitutionally problematic, or is one more alarming than the other in terms of current constitutional law?
Yeah, so we started talking about this before. So I mentioned the Terry case and how in 1968, in response to political pressure, the court created this doctrine of reasonable suspicion, this lower standard that was designed to allow officers to conduct pat frisk for weapons. But if they wanted to make an arrest or do anything else, a full search, they'd need probable cause that the person was engaged in a crime, right? In 1996, the court decided a case called Wren versus United States, in which the court said that pretextual stops are okay. So this would be, I really want to stop this guy based on race, but I can't do that. But if I follow him long enough, he'll cross the yellow line, or he'll go 51 and a 50, and there you go, now I can stop him, right? So this case, Terry and Wren, were used to funnel, members of minority communities into the criminal justice system. But the distinction between that and Perdomo is no one has ever actually said you could use race as a basis to stop someone until Perdomo.
Mm-hmm. So I guess it seems to me that you would want to say, under current law, these two cases are a little different because according to the logic of the Supreme Court, according to the logic of the Kavanaugh concurrence, there's no reason to think that a person with Hispanic complexion, there's no reason to think that that person needs to be pulled over. But again, according to Kavanaugh's concurrence, the immigration officer sees someone of Hispanic complexion, Hispanic appearance, and says, I think I'd like to talk to this guy, right? So they're different in that way, right? Under current law, right?
Yeah, that's absolutely right. The only thing I would clarify is that Kavanaugh's concurrence in this whole opinion was simply staying the temporary restraining order. And frankly, all the temporary restraining order was doing is telling immigration agents, so ICE and Border Protection, that they had to follow the Constitution. I don't get why this is why this is controversial. But the actual merits of the case, which Kavanaugh really hinted at in his concurrence, are not binding until the court actually issues that ruling, which may happen if they grant cert.
Yes. So, one interesting thing about the order, it says that cops are not allowed to look at the four factors that I identified solely. It uses the word solely. So I guess what I'm wondering is, under the terms of this order that was pulled out, if a law enforcement officer says, I noticed that one of these factors is alive, but I'm also going to look at a fifth factor. I'm going to say, for instance, let's say I'm an immigration officer, and I say, here's a person of Hispanic appearance, and furthermore, there's a fifth factor. I think that I've been told that there are a whole lot of illegal aliens in this part of the country. So I'm going to use these two factors to talk to that person. If that order remained law, that would be legal under the order, right? Because the word solely is used in the order. You're making a mistake. You're doing something improper if you look at these four factors solely. But if you've got a fifth factor, it's a little different, right?
I think that's right. That's the thing. A lot of these, the cases could turn on one word. Yeah. And I would just add one thing. It's not that you can never use, race, ethnicity, national origin. So say, for instance, there's a robbery, right? Police are looking for the robbery suspect, and the robbery suspect is a black man with dreads who's in the area. They can use that as a factor, but they can't go up to every black man and stop them and ask if they're the robbery suspect, right? So that's the distinction. They're looking for someone for a reason. They're not just looking at someone based upon race, ethnicity, national origin, or occupation, which, by the way, all of these occupations and everything they're doing, hanging out at a Home Depot, these are all legal things, and that's the problem, right? When you put four legal things together, it doesn't then become a crime.
Right. So one more question about this. Yeah. Which is, we're now in the situation where we have a Supreme Court making an order on the emergency docket that says, the lower court's order is no good, and so we have this concurrence by Kavanaugh. The force of all this stuff is a little bit mysterious. Is the Supreme Court actually going to get to the point where it gives us actionable policy to determine what immigration officers can and cannot do? What's your forecast about what decisions the Supreme Court is actually going to make on the merits?
Yeah, I mean, I think think, it's hard to know. So we know where the three liberal justices stand. We know where Justice Kavanaugh stands. I would guess that Justice Thomas and Justice Alito are probably aligned with Kavanaugh. So then the question is, we start peeling off some of the other justices, like Justice Gorsuch, Justice Barrett, Justice Roberts. Are they aligned with Justice Kavanaugh on the merits, or are they aligned on the standard for issuing an injunction on Article 3 standing? I don't know, right? Part of me is like, yes, the court needs to take this up. It's such an important issue. But part of me is like, if the court's going to issue a bad decision, we're better off with them not granting cert and not taking the case at all. So, I don't know. If I had to guess, my guess is going to be that a lot of the Kavanaugh concurrence in the order for the stay, you're going to wind up seeing in the merits opinion itself.
Well, John, let me go back to you and ask you about a case that the Supreme Court decided about 90 years ago, the case of Humphrey's Executor. And I want to give you some facts of today. Today, all of us are surrounded by thousands of federal bureaucrats who have no personal loyalty to the president. And some of these bureaucrats actually have differences of political opinion with President Trump. And it's rumored that the president does not like it when federal employees disagree with him. And some people might even suspect that when President Trump identifies a federal employee who doesn't agree with him, he might occasionally take action to fire him or her. Now, it's often the case that under the law, these federal bureaucrats can only be fired for cause, not for political disagreement. And there's a very serious point here, which is that the Constitution says that there are really only three branches of government, and the president really ought to be able to control the executive branch. And so my first question to you about that is, how close are we to seeing the Supreme Court overturn or substantially modify Humphrey's Executor? And that's really the decision that provides the foundation for immunizing executive branch employees from political firing or presidential control that derives from the threat of termination.
Well, I think that I say in the article, Humphrey's Executor is almost as dead as Humphrey, because it was called Humphrey's Executor because he had died. He was really looking for back pay. The one reason why the Trump administration has won so much in the emergency docket is because he's firing people, and the president is allowed to fire people, except under Humphrey's, if it's a if it's a multi-member organization and Congress says they can only be fired for cause and they have a term. Humphrey's Executor was the old Supreme Court trying to stop FDR from running his administration. And so they kind of weakened a case called Myers that said the president could fire anyone. So I think Humphrey's is dead. And the reason that you're having this ping pong is the district courts and the appellate courts are saying, look, we're bound by Humphrey's. You said these type of organizations, they can't fire them. And the Supreme Court is saying, no, he can fire them. And the dissents are saying, well, wait a second. You can't overturn Humphrey's on the emergency docket without a full opinion. And so I think that's a fair cop, right? And Kavanaugh does say well, could we take it? Could we please grant cert? We can grant cert on the emergency docket. Let's get to the basics here. He says grant cert. And I don't understand why. The three dissenters says, this is outrageous. You're overturning Humphrey's on the emergency docket. And Kavanaugh says, let's grant cert. And they don't vote to grant cert, those three, and 4 would have gotten cert granted. So I really don't know what they're playing at, but it's going to be there because now one of the FTC commissioners has been fired, and she's fighting it. And the FTC was Humphrey's executor. So that it's going up, and I think they will do it. There's another case where they fired another multi-agency head, and one of them was Richard Trumka's son. What I really love about that case makes it a little better. He was reinstalled, and he immediately told everybody not to listen to the president and started getting rid of everything that had been done under the president's appointees. So it's a perfect case for why you can't have Humphrey's executive. But I think they're going to do it in the FTC. And so all these firings, now he's firing a bunch of multi-boards. He's now fired someone on the Federal Reserve. They actually dropped in Bowens or Wilcox, one of the two cases, they dropped a footnote saying, oh, but the Federal Reserve is different. It's way different. It's completely different. And that goes to my longstanding view that if the Federal Reserve's independence is ever in danger, John Roberts is going to find it's a tax, and he's going to say, "Look, that's that." But all this is coming up, and the one thing that I don't know if it's going to come up, but the multi-headed agencies, the president's ability to control the Fed, all this is coming up. The one thing, though, is all of the protections for federal employees that came up actually out of Republican administrations trying to get rid of the spoils system are still in place, right? So the Personnel Management Department still is a multi-headed agency who's fired those people, but you're still entitled to back pay and money. So I think part of this may be remedies. He may be able to fire everybody, but they may get their back pay because of the laws Congress has passed, because that wouldn't impinge on his ability to control the executive, would it? So there's going to be a lot of things going on. I don't know if the civil service reforms will get there this term, but it's coming.
So a related question is, a related question I have has to do with another one of President Trump's managerial tactics, which appears to be, if you want to avoid spending taxpayer money, then you simply figure out a way to do mass firings and mass layoffs. This seems to be what's happened in several cabinet agencies and several independent agencies. And tell me a little bit about to what extent the president gets pushback from a litigation perspective, whether he's prevented from carrying out this strategy as a legal matter. And I think that this is, I suppose it's fair to call this something like impoundment under another name.
Yeah, I'll group these together because there's a couple of cases. One is McMahon, because it's the Department of Education. He says, we don't need a Department of Education. I'm going to get rid of the Department of Education. He tells Linda McMahon, start firing people in preparation of getting rid of the Department of Education. And she does. And she fires hundreds of people. And then they stop grants under the Department of Education. Now, so far, he's been allowed to do this, but the plaintiffs came up with a theory, which is an interesting theory. I just don't know how it'll work out. They said, listen, if Congress makes an agency and funds an agency, you can't use your executive power by other means to get rid of a congressional commandment, right? So I don't know what's going to happen in those, but we're going to see how much, and he's also going to challenge the impoundment, because these grants, he's going to say, I'm not going to spend the money. Well, if he doesn't spend the money on anything, like, I don't know, he could give all the grants to Hillsdale or something. I have no idea, but they don't take federal money. I know, you all know Hillsdale. Anyway, but the fact is, I think that it's going to raise real interesting questions because, and I'm not sure how it's going to come out, because the Congress is supposed to have controlled tariffs and budgets and all these things, but Congress is not a plaintiff. Like, they should be defending themselves, and they're not. And I wonder how the court's going to look at that. But if these people are heard, I assume they have Article 3 standing. I just think it's a big term for presidential power over everything, not only executive, but spending for each of the agencies he doesn't believe in. What if he doesn't believe in the Department of Agriculture? They'll grow things whether we have a Department of Agriculture or not. Why do we have to do that? And is that someone at Cato? Anyway, so I think that if just because the president doesn't like what the Congress has said an agency should do, whether he can stop spending on that is up in the air.
And forgive me for jumping around. So it's your view that a strong form of Humphrey's executor is probably not going to survive, that Humphrey's executor is probably going to be weakened or eliminated.
Yeah, I'll name check Eli Nachmani again, and I cite him. He has a view that Humphrey's executor is only because the FTC at that time didn't really have executive power. Basically, they could recommend things. They couldn't fine you. They couldn't do a lot of things they do. He says if you have executive power, Humphreys is gone. And what they're going to say, I think they're going to overrule it because it's causing all these problems. But it could be that they'll just say, look, the agencies today all have executive power. We use them to fine people and take their money and tell them what to do. Mm-hmm. So they're not, Humphrey's word was quasi-judicial, quasi-legislative. It's not any of the quasi-legislative. It wasn't executive power. I don't think they're going to find, maybe the Civil Rights Commission, but they're not going to find a lot of organizations that are made that way now.
Well, Mike, let me go back to you. I want to ask you about a pending case, the Villarreal case. And the facts of this case are really pretty simple. It was something like you have a defendant on trial who's testifying for a while, and it's the end of the day, and he's due to begin testifying again tomorrow. And the judge says to the defendant's lawyer, "Don't talk to the defendant." More precisely, the judge says, "I'm going to give you what's called a qualified conferral order," which is to say, you're allowed to discuss trial strategy with the defendant, but you're not allowed to discuss past or future or pending testimony. That's I think, the fact situation of Villarreal. And I'm curious to know, can you say a little bit about what you think the consequences and the likely future and really the importance of allowing these kinds of restrictions between conferences between an attorney and his client are?
Yeah, so this is an interesting case. So David Villarreal was on trial for murder, and in the middle of his testimony, end of the day came, so they recessed overnight. And before they recessed, the judge gave an order telling Mr. Villarreal that he cannot consult his counsel on anything testimony related. Now, I've been a public defender. I've tried criminal cases. I know Matt has. I know I have a few colleagues who have as well. I have no idea how you can have a conversation with your client to prepare trial strategy but not discuss testimony. That is completely unworkable. And it's worth noting that there's a case called Geeters versus United States where the Supreme Court struck down a blanket ban on communication. The facts were almost identical. The difference is in Geeters, it was a blanket ban, so you can't consult counsel at all, whereas this limits it to consulting on testimony, and the court said that blanket ban violates the Sixth Amendment right to the assistance of counsel, which is, obviously correct. And then there was another case called Perry v. Leak where the court held that it's okay to not allow consulting counsel during a short recess. This would be like, a lunch, a 5-minute break. Okay. But they made it very clear that there's a distinction in a lengthy recess where the, accused needs to consult his lawyer. And you wind up with a situation here where, from what I can tell, this stands in direct contradiction of the court's precedent in Geeters. And even if you were to say that, okay, we can create some carve-out, it's not a blanket ban, it just deals with testimony. Anyone who's done criminal trials, people love to talk. And I don't know why this man was testifying. Oftentimes it's not wise for people accused of crimes to testify. Perhaps sometimes it can be strategically. But sometimes people just like to talk. And, sometimes your clients will start saying things and you need to be like, dude, you got to shut up, right? And in a case like this, is that a permissible thing for me to do if I was representing him? The way I read the order, it's not, because it's discussing testimony. So to me, it's a blanket ban, which the court already struck down. So I think the court is either going to have to go the same way they went in Geeters, or they're going to have to overturn their precedent, which would be, pretty devastating to the ability of clients to consult their attorney, because you have, I think it came up earlier on a panel, where there's, a disproportionate share of judges, especially federal judges, but also in most states, who are themselves former prosecutors or former courtroom advocates for the government. There's nothing stopping the judge to just declare an overnight recess and block the attorney from consulting with his client. So this sort of just gives, tilts the, rigs the system even more in favor of the government and against the rights of the accused. So I'm hoping that the court, looks at Geeters and is like, yeah, we got this right once, we're going to stay with it.
Well, fair enough. I'm going to ask both of you if you have any quick 1 or 2 sentence predictions about anything else that we haven't covered so far. And I'm going to ask people in the audience to raise your hand if you have any questions for our experts up here. So, but before we start taking questions, do either one of you have any quick predictions that you want to make about anything else that the Supreme Court is going to be doing next?
I think the previous panel talked about it. They're going to do a lot of medical. There's a free speech case about what counselors can say to people who don't want to transition or want to transition. I think they're opposite cases. One said you can't talk to them, one said you can. I think it'll be an interesting free speech case, and I don't know how it'll come out.
Yeah, I'd just add the long conference, which is where the court grants cert or decides to hear cases that have been pending over the summer, is I believe 2 weeks from now on September 30th. So there's a number of cert petitions pending before the court. So I think once we see that, we might have a better sense of, where the court's planning to head this term.
And can I just, that last case you discussed, it's just asking for contempt for lawyers. It's just asking for contempt. Because what do you tell your client? I think I know where the prosecutor's going now, and I didn't know before he started asking questions, so beware of this question.
Do you think it's fair to say there's a huge danger of client mystification?
Yes.
Attempting
yes, I do. Anyway, I just want to get that out because I don't know how you handle it.
And I just add one thing. If you think, there's a lot of Justice Department lawyers who do some pretty egregious stuff and are never held accountable. If you are a criminal defense lawyer, judges tend to have no problem finding you in contempt.
All right, Harry, do we have a question over here? Mm-hmm.
And I was just wondering if you knew whether the case about women registering for the draft, as a West Point graduate, I always found that an interesting area because the court back in the early 80s said women didn't have to register for the draft because the draft was for combat arms like infantry in the times of a national emergency. And Obama back, I think, 2012 or 2014, changed the rules to where women can go in the infantry in the Army. And so I understand that court case is bubbling up. I wonder if you guys were aware of it and what's the likelihood of it hitting this year?
Yeah, I'll take this. Yeah, so Judge Young, who sits in the District of Massachusetts, just had arguments on this case in his courtroom. I think it was either earlier this week or late last week. I would say the Fifth Circuit, which is the southern states like Texas, Mississippi, Alabama, a couple years ago upheld the Selective Service Act, and the Supreme Court denied cert. They said they weren't going to review it. This case is now at the district court level, so it'd have to work its way up through the First Circuit. But frankly, I don't see that the court would take it. And if they do, it certainly wouldn't be this term. I don't know, John, if you have a different take.
I fully agree. They're not going to take it. They're going to leave that to the political branches unless something big happens. And once again, the Solicitor General asked to go up. That's where I am.
Over here, I think.
Thank you. I'm Robin Johnson. I'm a lawyer in private practice here in Washington. Got a question for John on the IEPA case, tariff cases. If you were right and the government loses 9-0 or 7-2 or what have you, there's a lot of money at stake that could be refunded. Now, I suppose if there is an order to refund the money, the Customs Service could drag their feet and require everybody to file a protest or something like that. But however, the administration's hands are, alternatives are limited under the other tariff authorities. They either have to, the remedies the president can impose would be limited in time, or they have to go through the procedural hurdles at the International Trade Commission and the Department of Commerce. My question is, do you think Congress would step in and amend IEPA to specifically mention tariffs?
Yeah, well, I think there'd be a huge fight about it. Here's where I am on this. I think that the declarations they've put in that this is a huge amount of money and we'd all have to refund it, we can't do that. Look, they gave half of Oklahoma back to the Indians. Right? They don't care. The Supreme Court doesn't care once they've decided something's unconstitutional. So I think, though, the practical question, I've been wondering whether the CIT won't make a special procedure for getting your money back, right? It's going to be a huge thing. It's going to be like asbestos or something. I mean, it's going to be a thing where, well, no, I hope it's not, because the Supreme Court threw up its hands about asbestos. But I think with this, they will do something. And I do think that Congress will then have to get involved, because one of the problems with this whole structure is the Republicans control the House, they control the Senate. There's huge appetite in this country to at least put tariffs on China, right? So if you really wanted to, you'd have the political winds at your back if you wanted to craft legislation with more tariff power, at least to our adversaries, if not to our friends, right? But that's not what the administration wants to do. But yes, I think Congress would get involved because the president would ask him, and I think that whether it's right or wrong economically, it would be extremely popular to pass certain tariffs against places where we don't want to, we want to impede their growth. Let's put it that way.
Thanks, Harry. I think we have a question over here.
Yeah, Carl Polzer again on the tariffs. So I read the majority decision and the one where the 3 businesses in the states went to the appeals court. And a big point in that case is that tariffs are a tax, and the Congress has the primary authority for taxation. And so I went as far in writing an op-ed for the Hill as to saying that it's given what you said, that the Trump administration is saying this is a lot of money. Well, they're changing the social contract. While Congress and Trump both compressed the income tax, which is progressive, or kept it that way in law, Trump on his own basically put a big sales tax on the country, which is regressive. If you go to state policy, you can that's where that's studied. The federal tax policy experts don't really have their head wrapped around it.
So what's the question?
Well, I was going to get, he asked the remedies. They can't tell, the court couldn't tell the Senate that you got to do your job.
No, that's true.
So it gives Trump, does it give Trump an off-ramp if the economy is soured and the tariffs are, identified by the media as one of the factors where he can downplay that a little bit? Does he go for another pretext, another statute?
So
what do you, or could the court just say, we'll let this go?
No, I think they're going to say these are unconstitutional because AIPA doesn't allow it. And then he's got other schemes, right? So Jed, Yale professor, says that Smoot-Hawley tariffs are still okay, and he could use Smoot-Hawley to do it. And he's got a whole article about this. I don't know what's going to happen. I do think the remedy is there's plenty of remedy in the CIT to get your tariffs back. What he does about, obviously you're right, the Supreme Court is not going to tell Congress to do its job, but it has hinted that they should be doing their job. It did in Loper Bright and Relentless. It has been pushing them to do it, but I think that they'll do it because the administration right now has the wind of its back on certain tariffs, and it has control of the House and Senate. It could at least get its bills in there. And what this would do is force the constitutional structure to work the way it's supposed to work. That's what the Supreme Court's been telling them to do for a while. So I think they tell them to do it again.
The gentleman in the center here that I'm pointing at? Yes, sir. Yeah, you might wait for the microphone, though.
Oh, okay. Thanks. Slightly different angle. Prior years, we've had a lot of action on the Second Amendment. And although we're seeing some administrative action vis-a-vis the ATF, I was wondering if this distinguished panel had any thoughts about the coming year vis-a-vis the Second Amendment.
Yeah, I'll take this. So actually my colleague, Matt Cavadon over there, just filed an amicus brief in the Supreme Court on a case out of Massachusetts that the justices called for a response on. So I don't know if they're going to wind up taking the case, but what it deals with is the right to armed self-defense and interstate travel. So this gentleman was from New Hampshire. He traveled into Massachusetts, was involved in a minor motor vehicle accident, lawfully possessed a firearm in New Hampshire, but because he was in Massachusetts, and the only way to get a permit in Massachusetts if you are not a resident of Massachusetts is to apply to this whole arbitrary process where the colonel of the state police has absolute discretion, and you have to know well in advance that you're coming and all these things. So his conviction wound up being upheld by the Massachusetts Supreme Judicial Court, and now the Supreme Court is asked to review the case. I hope they do, but I have no idea at this point how likely that is or isn't.
Yeah, and he went from the live free or die state to the die state.
Yeah, exactly.
I think that there's appetite, but I do think that you will see if they don't take it, I think you're going to see a dissent again from Thomas.
I think that's right.
Yeah, thank you. Brent Skorup, Cato Institute. This is for John about Humphrey's executor. How much how much room do courts have to craft a remedy? And I ask because, the likely remedy would be to strip the removal protections from a statute. Another remedy that I think is much more attractive would be to strip these agencies of executive power and perhaps allow them to be reinstated. I think it would do less violence to many of these agencies' underlying statutes, and would also have the nice side effect of defanging these agencies from exercising executive power. And I mean, that's one reason lower courts, Supreme Court keeps telling them to look again, because they keep evading the requirement to see if they have executive power. But yeah, on the question of remedy, could or would the Supreme Court strip them of their executive powers that were added often decades later?
They won't. And I'll say this, it's an elegant solution to this problem, but number one, what I said before, they want Congress to do this stuff. Second of all, they say that they're not there as scriveners to rewrite the statutes. They say that all the time. So I think they will just say that the removal is unconstitutional, which is easier for them than striking all the executive power that has accreted over the years into the FTC. So I think that would be great, but I don't think it's going to happen. I also think that as far as we've seen in the Supreme Court cases where they say that there can't be double protection for ALJs and certain officers, but the remedies are often terrible. If you have one of those cases and they find, for instance, a guy hasn't been appointed correctly, they just appoint the guy correctly and then ratify everything he did, right? So there's this whole ratification problem where the Supreme Court says, it's the right officer now, so now everything that was done before is A-okay with us. It's like the whole remedy in those wrongly appointed or double protected officers, it's all the remedies are kissing your sister. They're just awful.
Do I see any more questions? Well, I'm afraid I don't. I want to say one thing about our upcoming Simon Lecture, which will take place in 15 minutes. Steve Richer is going to be a very interesting speaker to listen to. He has withstood, I think, more pressure and behaved more honorably than probably just about any of us ever will. And I look forward to the Simon Lecture in about 15 minutes. And I would just ask all of you to give a round of applause to our very interesting guests.
Welcome back, everyone. It's my great honor to introduce tonight's B. Kenneth Simon Lecture. The lecture this year is delivered by Stephen Richer. Richer is a visiting senior fellow at the Ash Center for Democratic Governance and Innovation at Harvard University's Kennedy School. He's also the CEO of Republic Affairs, a crisis consulting firm for pro-democracy, pro-rule of law entities and individuals. And we're very proud to say that he is also now an adjunct scholar right here at Cato's Robert A. Levy Center for Constitutional Studies. In 2020, Richer received nearly 1 million votes when he was elected as a Republican to the recorder position in Maricopa County, Arizona. As county recorder, he was responsible for a wide range of government services, including voter registration, early voting administration, and public recordings in Maricopa County, the 4th largest county in the United States. And as Dan alluded to, he had quite an eventful term in that position, and really, in my view, courageously stood up for the truth in that position. He's appeared on a wide range of national television networks, Fox, CNN, MSNBC. He's received many awards and recognitions for his commitment to the truth, the rule of law, and democracy, including being named Arizonan of the Year by the Arizona Republic in 2021, Public Law Attorney of the Year by the Maricopa County Bar Association in 2022, Leader of the Year by the Arizona Capital Times in 2023, and Defender of Democracy by Time Magazine in 2024. Richer received a JD and an MA from the University of Chicago and a BA from Tulane University. He also wanted me to stress that during the Q&A portion, he welcomes sports questions in addition to anything in his lecture, and he'll be speaking tonight on courage and the Constitution. Stephen?
You guys making it through the day okay? All right, do we need to do any jumping jacks or anything like that? All right, well, it's been a long day. So I'm going to start with a few thanks. First, thanks to Tommy for putting together today's great events, and thanks for having me here, and thanks for really running the show. Thanks to Clark for being our fearless leader in the legal team now. Thanks to Laura, who's the one who had to most suffer through my procrastination, I guess. Yeah, procrastination, so I appreciate that. And thanks to Ryan. I know it's no small feat for putting on an event, and so really appreciate all that he and his team do. And not least of all, thanks to Roger. Because Roger, when I last saw you, you were talking about the merits of University of Chicago. You were among the phalanx of liberty-loving folk who were like, you should really go to University of Chicago. I didn't like it all that much, but I met my wife there, so thank you very much. Oh, so did you, all right, yeah. In fact, they have that. At University of Chicago orientation, they have a little bit of a play on the paper chase, which was, look to your left, look to your right. One of these people will not be here by the time you graduate. At University of Chicago Law School, they say, look to your left, look to your right. You're probably going to marry one of these people. And indeed, my wife was not sitting too far away. All right, but we'll turn to the topic at hand, which is, of course, talking about constitutional law and, of course, talking about liberty. And there's no better place to be doing it than at Cato Institute. And another acknowledgement of Roger in the center that I believe you founded some time ago now. So Roger founded it all. In the first there were the heavens and skies, and then on day 2, Roger got this outfit. All right. Well, very good. Okay, so for 4 years, as you've heard, I served as the elected Maricopa County Recorder, responsible for, as Tommy mentioned, voter registration and early voting, among other things. And whenever anyone would say something nice to me on social media, another user would usually immediately get on Twitter or immediately get on Facebook, and they would counter with, "Why are you praising him? He's simply doing his job. He's simply following the law. Isn't that the bare minimum?" Such commenters might similarly question why I'm standing up here today. Why would a nice, intellectual, prestigious organization like the Cato Institute give me the floor at the end of a wonderful day celebrating the Constitution? But if simply doing my job or doing the bare minimum or simply existing is the rubric for this speaking slot, then it's no surprise to me that I'm here today because I actually have a rich history of being recognized or rewarded for doing the bare minimum. On just the 8th day of my life, Jewish men and women gathered to celebrate me for simply being me. My bris, and if you don't know what that is, you can look it up, was something I can't remember soliciting or consenting to, but I'm told the breakfast was good and the turnout was strong. Throughout my childhood, I collected over 20 most valuable player trophies in baseball alone. Given that my athletic career did not end with the New York Yankees, I can only assume that the requirements for such awards were pretty much show up, play, follow the rules, and don't throw a bat at anybody. At age 13, having neither been imprisoned nor run away from home, I'd again positioned myself to be celebrated by a large percentage of the Salt Lake City Jewish community. They not only had to give me money or gifts and pretend that I'd somehow become highly masculine, something I'm not sure I've achieved to this day, but they had to attend an NBA-themed pizza party and listen to my profound thoughts on my Torah portion. And in January of this year, I secured a plum position at the Harvard Kennedy School, something that was likely the result of simply being an elected Republican who had previously spoken at the school and had neither threatened to defund the school nor deport any of its students. And I'm happy to say that I'm enjoying my new position and my new colleagues immensely. And yet, while I understand why this might provoke criticism on the internet, we perhaps now live in an age when simply showing up or simply doing your job or simply following the law is exactly what is needed to save American rule of law and American liberty. After all, it was Mike Pence who was simply doing his job on January 6, 2021, when he certified the election results according to established constitutional law. The challenge that Mike Pence faced was certainly novel, and so too are many of the other challenges that we face today. We have new technologies. We have a highly polarized country. We have 40 million people living in one state alone, a state that, if it were a country, would have the 4th largest economy in the world. Many politicians and political commentators claim that these new challenges require new solutions. The left has long held that we require a, quote, living constitution that adapts to meet the moment. The new populist rights thinking is perhaps best captured in the 2016 essay by Michael Anton titled The Flight 93 Election, which argues that exigent times call for exigent measures, that the new nationalist conservatives need to fight fire with fire and use the power of the state to strike down enemies, even if that means coloring outside the lines. I think they are both wrong. Instead of looking for new solutions, we should face our modern challenges with a renewed commitment to constitutional fidelity. In other words, we should follow the law, follow our oaths to the Constitution, follow the oath that is taken by every American politician and civil servant. The Constitution predicted such times as the present, and its solution set still meets our needs. For example, many at the Cato Institute, myself included, are dismayed by the ever-expanding power of the federal government. The authors of the Constitution, of course, foresaw this challenge and designed safeguards. In Federalist 45, Madison writes that, quote, the power delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite, end quote. And perhaps no writing better gets to the heart of the architecture of the Constitution than does Federalist 51, in which Madison writes, quote, the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist the encroachments of the others, end quote. Similarly, many look at our 21st century presidents and worry that we need new solutions to counter demagogic appeal. But it's silly to think that the Constitutional Convention didn't contemplate the idea of a populist president who catered to emotion rather than to reason or law. Madison warned in Federalist 55 that, quote, in all very numerous assemblies of whatever character composed, passion never fails to wrest the scepter from reason, end quote. And Hamilton explained the importance of the Electoral College, states' rights, and the division of power in the federal government by writing in Federalist 68 that, quote, talents for low intrigue and the little arts of popularity may alone suffice to elevate a man to the first honors in a single state, but it will require other talents and a different kind of merit to establish him in the esteem and confidence of the whole Union, end quote. So while our challenges might be wrapped in a veneer of novelty, I'd suggest that they are actually inform the same challenges that governments, including the United States, ours, have faced for many years. And because these aren't really uncontemplated challenges, a lot of the constitutional challenges to acts by recent presidential administrations are actually amusingly straightforward in the application of constitutional law. I'll start in one of the domains I know best, which is election administration. On March 25th of this year, President Trump signed an executive order titled, quote, preserving and protecting the integrity of American elections, end quote, in which he ordered material changes to election administration, including the certification requirements of tabulation equipment and requirements for proof of citizenship. More recently, on August 19th, President Trump teased another election administration executive order by writing on Truth Social in lots of capital letters, as is his style, that he would ban mail ballots. Remember, Trump wrote, quote, the states are merely an agent for the federal government in counting and tabulating the votes. They must do what the federal government, as represented by the President of the United States, tells them, and this is the all caps part, for the good of our country, end quote. But this runs afoul of even the simplest reading of the Constitution. Article 1, Section 4 of the Constitution delegates the times, places, and manner of holding elections to each state by the legislature thereof. And anyone who has consistently read Walter Olson's publications here at the Cato Institute, which hopefully is lots and lots of you, knows that this delegation of election administration authority is a feature, not a flaw. In 2022, Wally wrote in Cato's Handbook for Policymakers that, quote, one practical value of decentralization is the resilience created by a federalized system. Innovations adopted piecemeal can be sorted out by local trial and error with less risk of mass failure, end quote. Additionally, Wally writes that thanks to decentralized control of election administration, quote, no Washington official or agency can start bossing around or removing local election officials, end quote. To the extent that this state power can be curbed or tailored or overruled by the federal government, the Constitution gives that authority to the Congress, not the President. That same section of the Constitution, Article 1, Section 4, reads that, quote, the Congress may at any time, by law, make or alter such regulations, end quote. How then to explain the President's insistence that he can craft election law by decree and that states are, again, mere agents of the federal government? I'd suggest that instead of looking for the hidden brilliance or complexity of such an idea and then crafting novel solutions to counter it, we accept it for what it is, a straightforward violation of the Constitution in a way that the founders contemplated. Judge Kolar Kotelly of the Federal District Court for the District of Columbia agreed. She ruled against significant parts of Trump's executive order and wrote very simply that, quote, our Constitution entrusts Congress and the states, not the President, with the authority to regulate federal elections, end quote. To me, this was what we scientifically and in legal terms call a duh ruling. But many on the internet disagreed. Another constitutional dispute that hits close to home is Harvard's lawsuit against the Trump administration for having suddenly frozen $2.8 billion in already contracted federal grants that were competitively issued for specific research projects. Now, as a preliminary matter and as a libertarian, I should note that I have significant misgivings about billions of dollars of federal government dollars being poured into universities every single year. Having the federal government steer the research agenda of the United States is problematic. But more troubling is the situation that Harvard, UCLA, Columbia, Penn, Northwestern, and University of Virginia, and many other research universities now find themselves in, which is that they are reliant on the federal government for a significant portion of their annual revenue, leverage that the federal government now seems willing to exploit. But as a legal matter, this is, to me, another duh case. As Cato noted in the press release for its amicus brief in the matter, quote, "The government may not impose its preferred viewpoint on private parties. Once the government establishes a benefits program, it cannot condition participation on a recipient's exercise or non-exercise of rights that fall outside the program's scope," end quote. The Trump administration tried to forestall this First Amendment criticism by saying that it froze the grants because of rampant Jew hatred on Harvard's campus in violation of Title VI. That's a general cause that I'm very, very sympathetic to. But the government did not engage in any fact-finding to this effect, and it didn't even acknowledge the notice and remedy component of Title VI. What the government did do, namely President Trump, was make very clear that the grant freeze was because of the school's politics. On May 26, Trump wrote that Harvard is full of, quote, radicalized lunatics, end quote. On April 16th, the president wrote that Harvard shouldn't receive its already awarded federal funds because the school hired, quote, almost all woke radical left idiots, end quote. Now, whether or not it's true that Harvard is filled with radical left lunatics is certainly interesting, and it's one that I'm sort of testing out as I spend more and more time there. There's at least one or two. But more importantly for the constitutional claim, President Trump's comments clearly showed his decision to freeze the grants had lots to do with the school's constitutionally protected speech and associational rights. Judge Burroughs of the United States District Court for the District of Massachusetts ruled in favor of Harvard on summary judgment and wrote that the government, quote, used anti-Semitism as a smokescreen for a targeted, ideologically motivated assault on this country's premier universities and did so in a way that runs afoul of the APA, the First Amendment, and Title VI, end quote. Despite the bombast and bluster of the internet after the ruling, this was not a hard question of constitutional law. And of course, these two cases are only examples of what I would suggest is the vast and growing body of easy constitutional cases against the federal government. In 2014, in the case NLRB versus Noel Canning, the Supreme Court ruled 9-0 against President Obama that just because the Senate recessed for 3 days, effectively a long weekend, did not mean that the president got to make recess appointments without any Senate oversight. In 2023, in Biden versus Nebraska, the Supreme Court ruled that Article 1 really does give Congress the power of the purse, which surprise. And President Biden couldn't unilaterally give away hundreds of billions of dollars in the form of excused student debt. And last week, when Brett Baer of Fox News asked Justice Amy Coney Barrett if the 22nd Amendment means Trump can only run for president for 2 terms, she responded, quote, well, that's what the amendment says, end quote. And if you were here for the previous panel, it seems like Mike and John think that the birthright case and the tariff case are perhaps also similarly straightforward constitutional matters. So if these are such straightforward constitutional matters, constitutional cases, then why do they keep getting tested by politicians who have sworn an oath to the Constitution? Why do they keep getting litigated? Why do our politics seem so confused, controversial, and combative? And I think the answer lies not in the Constitution, in our people. John Adams famously wrote that small L liberalism, the type of liberalism that's celebrated here at the Cato Institute, and any form of democratic government is possible only if there exists a moral and religious people. Michael Ware, the CEO of the Center for Christianity and Public Life, was thinking of Adams when he wrote in his latest book that the state of our politics is a reflection of the state of our soul. And under such a rubric, I'd suggest that our soul is sick, very sick. Just last week, we witnessed a homegrown 22-year-old U.S. citizen assassinate Charlie Kirk because he hated Kirk's politics and his brashness about his politics. This, of course, follows the politically motivated assassination of Minnesota State Representative Melissa Hortman and her husband, as well as the shooting of Minnesota State Senator John Hoffman and his wife. And it follows the assassination, just a few blocks away from where we are here today, of 2 Israeli embassy staffers by a gunman who shouted, quote, I did it for Gaza, free, free Palestine, end quote. And we closed last year with the assassination of United Healthcare CEO Brian Robert Thompson in what was supposedly a political statement about our healthcare system by Luigi Mangione. These horrors were each compounded by online barbarians who shrugged their shoulders about these assassinations and took to the internet to type out some form of, well, they had it coming. I mourn for each of these victims. I mourn for America. I mourn for humanity. So what is our political soul lacking? It's not knowledge. We don't lack the knowledge that murdering Charlie Kirk in front of a crowd of 3,000 college students is wrong. We don't lack the knowledge that breaking into a house and attacking an old man, Nancy Pelosi's husband, with a hammer is wrong. Similarly, my celebrated accomplishment, validating and standing by the 2020 election, wasn't born out of a situation in which we lacked knowledge, or at least the ability to gain knowledge as to the results of the election. And in most cases, we don't lack knowledge as to what the United States Constitution requires of us. What we lack is courage. The courage to stand up for what we know to be true, or the courage to stand up for what we know to be right, or the courage to stand up for the Constitution, especially when it aggravates our side or our tribe. With respect to standing up for the Constitution, I often think of what my friend Ilya Shapiro said when he ran Cato's Center for Constitutional Studies for a number of years. He said, he was always proudly pointed out, this is no longer true today, but he proudly pointed out, he said, Stephen, I'm an immigrant. And like all immigrants, I do a job that most Americans don't want to do. I defend the Constitution. I suspect that is even more true today than when Ilya first mentioned it to me 16 years ago. Today, the cost of standing up for principles or for constitutional rights is very weighty, and many individuals and organizations have taken the road of compliance, appeasement, or surrender. Law firms, media companies, and universities all too quickly surrender their First Amendment speech rights rather than suffer pressure from the federal government. Major retail companies sacrifice their free speech and sometimes even their physical security rather than suffer the consequences of the woke mob. But there are also acts of courage. And here I have to return to one of my personal heroes, Mike Pence, who risked his life and his political career to defend the Constitution in one of the weightiest moments of American history, the ultimate example of a hero. Or people like FIRE, which is an allied organization CEO, Greg Lukianoff, I never know how to pronounce his last name, Greg Lukianoff, who every day manages to aggravate, really, it's amazing if you watch it online, every day manages to aggravate both the left and the right for his unyielding defense of free speech. Or Danielle Sassoon, who accepted her termination as U.S. Attorney for the Southern District of New York, rather than engage in a political quid pro quo for the benefit of a corrupt New York City mayor. Or IRS officials during the Obama administration who revealed that the agency had been paying undue attention to Tea Party organizations. Or Senator Kyrsten Sinema, who encouraged her fellow Democrats to think twice before throwing out the filibuster, one of the biggest restraints on governmental overreach and capricious zealotry. Or the professor who dissents in the faculty lounge and says that maybe not everything from 1776 was all that bad. Or maybe courage is manifest when an organization never indulges in the political fascination of the day, be it the gross overexpansion of the federal government in the name of hope and change, or the trampling of the rule of law in the name of making America great again, and instead stays true to its guiding principles of individual liberty, limited government, free markets, and peace. Hopefully you all know where those came from. The good news is that courage is contagious. We know this. Whether it's one person standing up to a playground bully, whether it's a soldier willing to fight instead of surrender, whether it's one person choosing to march for civil rights. So do the courageous thing, and soon others will as well. I hope that I fulfilled this responsibility when serving as Maricopa County Recorder, albeit, and admittedly, by simply telling the truth, simply doing my job, simply following the law, and simply following the Constitution. But there will be other election administrators, politicians, lawyers, judges, generals, academics, doctors, think tankers, and business leaders in the coming years who will similarly have to exhibit great courage by simply doing their jobs, simply telling the truth, simply exhibiting sanity, and simply defending the Constitution. To those people, we see your courage, we thank you in advance for defending what is precious, and we look forward to celebrating you. Thank you very much. All right, I think we're going to do some questions. All right, and we've got the microphones. All right, we're going to go right up here in the front, good sir, in the blue shirt. They're both coming your way.
Thank you, Stephen. My name's Andy Hawks, and I'd like to hear more of your personal story. Who exactly pressured you in the 2020 election, and what did they pressure you to try and do?
Yeah, I appreciate the personal story. Given Arizona's history as a reliably red state that in 2020 went for President Joe Biden, there was a lot of interest from Trump administration personnel and Trump campaign officials, everyone from the president to Rudy Giuliani to some of his lawyers to some of his political affiliates, who were very interested in throwing the Arizona results into question, into calling for extra statutory reviews of the process, and for ultimately sending it to the state legislature because it was too confused of a system. Unfortunately, that didn't comport with what we knew the facts on the ground to be and what numerous courts had held in all of the election challenges after that. As for how I got involved in this, I was a movement attorney, movement business person who had long been involved in the political liberty movement, and I had volunteered for the Republican Party for many years. In 2016, my predecessor had taken the seat, which was a very significant blow to the Republican Party because we didn't lose seats in Maricopa County, one of the largest red county in the United States, and so got involved in that, ran, and I said to myself, what can be too controversial about this? We'll run an administrative office, we'll show that we do it right, we'll show that we do it lawfully, and then we'll be off to the races. And it just goes to show that man makes plans and God laughs. Yeah, so other questions? Do we have any other questions? I think we've got one question up front. Okay. Oh, all right, we're good. All right, we've got one question in the back. And just name and affiliation.
J.P. Hogan, independent writer. The presidential veto. If Congress has the power of the purse and he can back it down and wait for what he wants, or she, when it gets there, have you studied that line of thinking that a president with the veto power can do what he, if Congress can act against him on something, but they're not, whether it's acquiescing or just implied consent, and he has a veto power if he isn't going to get what he wants, where do you debate that?
So the presidential veto power, so I was interested in for a long time in the line item veto. That's not authorized by the federal constitution, obviously. Obviously, the veto power is certainly important, but I think the more pressing challenge that we have today is that the Congress is largely AWOL. That the founders designed our government with obviously co-equal branches, and if anything, that the ultimate authority would rest in Congress. And today, Congress seems almost enthusiastic about delegating its power to the executive. And so I would say we really have three branches of government. I would say we have the executive, who creates the laws and then enacts the laws. We then have public interest groups who sue to stop the executive. And then the third branch of government, the judiciary, which we just dump everything on its lap and we say, figure it out. And so I find it very disheartening that there's not more institutional pride within the Congress to really jealously guard the power which is theirs. And a number of those powers have been touched on regularly today, and as well as a few that were sort of referenced in my speech. And so I think that if we are to have a rebirth, a remodeling of a healthier constitutional dynamic, I think it rests in large part on Congress reclaiming its authority as prescribed under the Constitution. So, yeah. Any other questions? Yes. Do you have Tommy's monitoring the internets as well.
I'm monitoring the internet, but this is actually a question from me, not from the internet. You mentioned Justice Barrett, who are being asked about, running for a third term. When you bring up courage, I think about the judiciary, which has some built-in protections against unpopularity, like life tenure and salary protection. I'm just curious, we've heard rhetoric from both the left and the right criticizing the courts and the Supreme Court for various reasons. We heard some rhetoric from the left during the last administration saying that some justices were illegitimate, or that the 6-3 so-called conservative majority is illegitimate. What do you think about rhetoric, and what do you think is best for long-term society in terms of what type of criticism people should be making of the courts, and what might be counterproductive in terms of undermining their legitimacy?
Yeah, I think that this is one of the most pressing challenges of today, and I think it's unfortunately become all too common. Justice Bullock of the Arizona State Supreme Court and friend to the Cato Institute for a long time recently wrote that when judges are looking over their shoulder, the process is done. The game is over. And so it has given me renewed appreciation for Article III judges who have, even if you don't believe it should be life-term tenure, but with no ability for removal without serious cause by the president. Now, I do think that we are chipping away at that judicial independence by doing such as things as making them think about their safety, making them think about their clerk's safety. And so what I think began maybe 20, 30 years ago of the casual undermining of the judiciary was saying, oh, well, they're not valid, or remarkably, when President Obama, during one of the State of the Unions, chastised the Supreme Court, to what has now translated today into sending pizza boxes to the homes of members of the judiciary as a, we know where you live and we know what we can do to you, is incredibly alarming to me. And I think that if that happens, if our judges are no longer able to act independently, and they don't independently exhibit the type of courage we would all love to see them exhibit, but which would be understandable for them not to want to risk their lives or risk their family members, then I think we go from having two functioning branches of government to just one, and then I think we get into really hot water. Yeah, Roger.
First of all, I want to thank you for bringing forth some of the big themes to today's program. You mentioned, for example, Madison's 45, which brings to mind the testimony of the governor of Nebraska some years ago, that he was not elected to be the manager of the Nebraska branch of the federal government. What we have today is a culture of dependency at many levels, states depending upon the federal government. The attempt after Obamacare was passed to there were 26 states, I believe, that took over Medicaid and Medicaid, and did not buy into increasing the program. Gradually, one by one, they have come into the program because of the incentives that were established. In this culture of dependency, the great problem is that behavior, as we know it, is such that if you have a culture whereby you lose if you stand for principle, you're going to gradually decrease liberty and depend upon the government. How, in your judgment, are we going to address the behavior that follows from a culture of dependency?
As I said, with respect to relying on the federal government in other circumstances, that is also now increasingly true of states, as Roger mentioned, being wholly reliant on the federal government because of the way that just money flows in our country. My mom's family is from Louisiana, and I used to grow up hearing the story of how everywhere else had switched to 21 for the lawful drinking age. But Louisiana, to the extent that it enforced any sort of identification laws, it was 18. And it was 18 until the federal government said, we're going to pull your federal highway funding if you don't bump up to 21. Growing up, I just thought that was kind of funny. I was like, oh, classic Louisiana, and they should have gotten on board. Today, I see it in a different light, which is that the federal government, as I learned recently with universities, has become so interwoven with the functioning and the budgeting and the administration of even our state governments that it increasingly makes operating a state very challenging if you don't go along with what the federal government says. Now, to Roger's point, that obviously gets at one of the most basic principles of the division of power that is referenced in the Federalist Papers, that between the states and the federal government. So I think it's very troubling. Now, what can we do about it? I think that we need to start taking pride in different forms of government. We cannot have a cult of personality, whether it's in Barack Obama or Donald Trump, in which we so firmly believe in just the elected authority of one person that we think all other fashions, forms, and individuals that constitute government should be subservient to that individual. So while you might be the same party as President Obama, or you might be the same party as President Trump, you have to say, I am a member of Congress, or I am a member of the state legislature, or I am a governor of this state, and you have to have pride in that, and you have to defend that. Now, what I've learned about politicians in my term as an elected official is that if there's one thing that politicians care about, it's that they are almost single-minded seekers of re-election. And so that means it is increasingly incumbent upon us to say, we care as individuals, we care as voters, we care as constituents, we care as donors in you preventing against and preserving preventing against federal overreach and preserving the independent authority of whether it's the United States House of Representatives or whether it is your state government. I don't think it's an easy fix because it's really, really hard to turn away federal dollars, and you don't want to be at a competitive disadvantage. This is something that a lot of universities are facing right now. Did Columbia probably want to go with the deal that the Trump administration had offered? Probably not. Did they think that they would be at a huge competitive disadvantage and lose a lot of their science researchers? If their grants weren't funded because they stayed at Columbia, absolutely. And so I think that it is increasingly something that we will have to be facing. I think it should be litigated, yes, but I also think that it should be discussed more among the populace, and that there should grow up a reservoir of resentment against it. Okay, I think we have one more question. Yeah, last question.
My name is Samar Chatterjee, Save Foundation. You made a lot of interesting points, and also you said you have changed your position on things just recently. Let me ask you on one simple issue that was raised in the previous session, that the president can fire a person appointed by him for cause. Now, has the Constitution defined what is a cause? And then it was said he cannot fire for difference of political opinion. Now, why a political word has been inserted, I don't know. But if the president is the boss and they're getting the same briefing, both the president and the person who's been appointed to help him manage the government, and the two creates a totally different understanding. The president, being the boss, should be able to get rid of that individual who is only going to create problems. So why is it, and what's the constitutional rationale to create the cause, and has the cause been defined?
Yeah, so thank you. So on the legal matter, I'm going to defer to Mike, who's still here, so you should wrangle him after that. John's still here. As a matter of principle, I will say, when you're an elected official, you get to see a lot of elected officials. You get to meet a lot of elected officials. You get to know the intelligence level of a lot of elected officials. You get to know the character of a lot of elected officials. And it dawned on me over the last 4 years that maybe an entrenched bureaucracy isn't necessarily the worst thing. And that was a different perspective that I had prior to entering into politics. Now, I understand as far as the government's ability to make change, government's ability to do something, and I'm sympathetic to that. And I'm also, somebody who came to conferences such as these when I was of my sort of political growing up days, and shook my fist at the unaccountable bureaucrats, especially in a Chevron world. But I will say that my experience with elected officials has given more shape to that conversation in my brain. And then lastly, I'll just say that my wife is a federal government attorney, so I have my own dog in this fight and sort of have thoughts on that. So I'll punt on that one, if you'll forgive me. So thank you all very much for listening to my bit. Thank you all for caring about the Constitution. Thank you all for going out and encouraging others to care about the Constitution. And thanks for being part of an organization that I think if it has a defining feature, it's that it cares about liberty and it cares about the Constitution, and it's a real privilege to be here. So thanks very much.
Thank you so much, Stephen. That was great. That concludes our programming for the day. Please join us in the Winter Garden right here on the ground floor, right where you entered, for a reception. Thank you all.